We are live.
Okay, great. Thanks. Well, good afternoon, everyone. Welcome to the
Mute yourself.
Judicial Proceedings Committee. We have 11 bills on the docket this afternoon. I will go ahead and just read off the order, and Senator Kramer, you're up first. So just give me one moment and we'll turn the floor over to you. So first off, we'll start with Senator Kramer with Senate Bill 295. We'll then move on to Senate Bill 289. We'll then move to Senate Bill 7. Next will be Senate Bill 151. Fifth will be Senate Bill 171. We'll then go to Senate Bill 355. Seventh will be Senate Bill 331. Eighth will be Senate Bill 57. And ninth will be Senate Bill 151. Ninth will be Senate Bill 210. And then 10th will be Senate Bill 232. And we will finish the day with Senator Carter, Senate Bill 334. So without further ado, Senator Kramer, you are up first with Senate Bill 295. The floor is yours.
Thank you for that, Mr. Chair, Mr. Vice Chair, members of the committee. Ben Kramer here to introduce Senate Bill 295. Committee, this bill is not new to you. I won't spend a whole lot of time on the merits. I'm fairly certain that this committee is familiar with the merits of this legislation. Quite simply, this bill is a constitutional amendment that would afford the residents of Maryland to decide if our circuit court judges should face contested elections or retention elections. I would proffer to this committee that in the 21st century, it is time for us to move from contested elections to retention elections, and that there's so much logic and merit to doing this that I'm a little bit lost that we have yet to take this step. The fact of the matter is, particularly at this time of division in elections, that those of us who are serving in political offices have to deal with. Now more than ever, it's time to move our judicial branch away from that rancor. The fact of the matter is, yes, I have to deal with that because I am, quote unquote, a politician. Our judges are not, and they should not be subjected to the need to run a political race. The way our law exists now, that's exactly what happens. We force members of the bench to go out and campaign as if they're running for some other elected office. We force them to do things that, in fact, they can't do as participants in an election, but their opponents can. They can't come out and say, here's what I will or won't do to continue as a judge. They are prohibited from doing that. Yet their opponents can come and make all kinds of claims and representations that may be completely fictitious to try to pander to the voters. The other piece of this is that, look, I recognize there's probably 10% of the people in my district who know what a Ben Kramer is. There's probably fewer, far fewer, that know our judges. So when we have these contested elections, we are leaving to chance the possibility that someone, by virtue of nothing more than having their last name start with an A or a B, may end up being elected a judge and they're completely unqualified to serve in that position. Right now, when a circuit court judge is first appointed, they have gone through a rigorous process to ensure that they have the capability, the temperament, and the understanding, the wisdom and the knowledge to fill the position of being on the bench. Someone by virtue of just putting their name on the ballot and paying a nominal fee, I think it's what, $50, could end up filling that important position, and that's a disaster. I will share with you, and it's also, what we're doing is forcing our judges to go out and fundraise. That instead of being focused on their duties on the bench, they are going before the very people who come into their courtrooms, representing clients, and asking them for money so that they can then run competitive races against challengers. And that really is inexcusable. And it certainly does not do favor in the eyes of our constituents, the residents of the state, when they want to see an impartial judge making a decision based on the merits of the case, not because attorney X or attorney Y contributed $2,000 to their campaign. And whether that ultimately happens or not, it gives the impression that that influence just might be there. And that's a huge mistake. In Montgomery County, this past election, we had the perfect example of the problems of these contested circuit court elections. There was a candidate in Montgomery County whose name came right at the very front of the ballot just because of where it is in the alphabet. This is a candidate who has run repeatedly and has lost. This time it got very close. And this is a candidate that was out making representations and claims. This is a candidate that 2 years ago ran and courted the Republican Party in that effort, made contributions to Republicans in the Republican Party, thinking that was going to be the strategy to get on the ballot and hopefully win. It didn't work. So in this last election, the same individual decided to curry favor with the progressive Democratic wing of the party and pander to them to get their support in an effort to win. And suddenly this conservative candidate from 2 years ago was a far left progressive candidate in this last election. And it shows what a farce this process is and how we have to fix it. Quite frankly, again, in the 21st century, I'm at a loss as to why we haven't. There seems to be this misplaced belief that our residents of color need to have these elections in order to be able to become judges in our state. But the facts at this point don't bear that out. Unless I am mistaken and the figures I have are not accurate, and I believe they are, significantly better than 50% of the members of the bench at this point are women and minorities, and a full third are minorities. So we have seen that the time has come. Let's get the politics out of our process for selecting our judges. Let's get the money out of the process for selecting our judges. Let's turn it over to the people of the state to have an opportunity to vote on this. And with that, I will wrap up what my comments are, because there's some people who are following me who certainly understand the process far better than I ever could. That includes the chief judge of the Court of Appeals and a good friend of mine, the Honorable B.B. Berry, who is one of those individuals, a capable, competent individual who had to run, raise money, campaign to stay in her position. And she is more than qualified to be there, yet we put at risk, because of what we have in place right now, we put at risk her ability to stay on the bench and do the things that she is doing and qualified to do. With that, Mr. Chair and committee, I thank you for your attention and hope for finally a favorable vote to turn this over to the people of the state of Maryland to make this decision. Thank you.
Well, thank you, Senator Kramer. I'm proud to say that I do know what a Ben Kramer is, and I do know who a Ben Kramer is, and I'm better off for it, so I appreciate it. And I'm glad you brought this bill back, so I'll leave that there. So what we're going to do, we're going to take the testimony from the panelists, and then we will open it up to the committee members for questions. And next we have our Chief Judge Barbera. The floor is yours. Good to see you.
Great to see you, to see every one of you, and good afternoon. Chairman Smith, Vice Chair Waldstreicher, I hope he's here. I see his name, but I haven't seen his face just yet. And many other men and women on this committee who've done masterful work over the course of the years. And I so appreciate being able to echo much of what Senator Kramer has said, and much of what I am about to say. I will keep my remarks short. We'll have some echoes of Senator Kramer's points. The reason being, those are the central points that need to be made to, I hope, convince this really wonderful body of the best of our General Assembly to give us a hand this year. I know we haven't been successful in the past. There is Mr. Vice Chair Waldstreicher and my senator, hello. So I will begin. For the record, I am Mary Ellen Barbera, Chief Judge of the Court of Appeals of Maryland. Thank you for the opportunity, Mr. Chair, Mr. Vice Chair, members of the committee, to talk with you once again about the need to eliminate contested judicial elections in Maryland's circuit courts. With me today on this panel are the Honorable Keith Baines. I hope you can see him. I know he's here. He is here in his capacity as the Circuit Administrative Judge of the Second Judicial Circuit and Administrative Judge of the Circuit Court for Cecil County, but also here, most importantly here, in his capacity as the very newly elected chair of the Conference of Circuit Judges. Also with us on this panel, I'm honored to introduce to you someone who is well known by Senator Kramer and others, and that is the Honorable B.B. Berry. She is an associate judge of the Circuit Court for Montgomery County, and it is she who is going to be talking most particularly, and of course answering any questions you might have about the most recent contested election in which she was right at the center of the target. So many of you have heard my testimony in previous years. Today's testimony may be familiar because contested elections for judges continue to undermine, and I will say it again, they undermine trust and confidence of the people in the impartiality of justice. Contested elections for judges have long been decried for the adverse impact upon public trust and confidence in the impartiality and fairness, quite frankly, in the impartiality and fairness of judges, and ultimately upon the judicial branch of government. Gentlemen and ladies, justice is meant to be fair. Justice is meant to be impartial. It is the only promise a judge running for elected office can make. That is why so many courts around the nation, including both of Maryland's appellate courts, rely upon retention elections. We judges who are subject to retention elections are accountable to voters who are able to vote upon our individual records of fairness and impartiality, upon our ability to deliver meaningful justice in the matters that come before us. In urging retention elections for judges of the circuit courts, we do not seek that the voters give up a vote, no, but rather the voters cast a vote that decides whether a circuit court judge should be retained. Contested elections, however, by definition, are not political. According to commentator George Will, and I quote from Mr. Will, Politics in a democracy is transactional, emphasis on politics. Politicians seek votes by promising to do things for voters who seek promises in exchange for those votes. That's the perfect example of what, again, members of the committee, you must and should do because you want the voters to know of what you think is best for the people of Maryland. And so you are politicians in the best sense of the word. In contrast, judges are not politicians. They cannot make promises about how they will rule in future cases. They cannot promise, for example, to be tough on crime, which we have over the years heard on many occasions by non-judge candidates for election. Though there are some ethical restraints on lawyers seeking judicial office through a contested election, the temptation to make those promises about future performance is simply too great to resist. Further, individuals and groups who are not candidates are able to launch communications that are inaccurate and ultimately, in many cases, unfair. While the judge must stand silent, he or she must stand, figuratively speaking, with her hands or his tied behind the back to maintain the promise of fairness and impartiality. That is what, in various formulations, is the centerpiece of what the standing judge should be able to and is able to and quite capably able to deliver to the public. So we don't want a judge to be beholden once elected, and I'm sure you feel the same way, to those who believe an additional promise beyond being fair and impartial and following the law has been made. You don't want to know that that's what's happening in these contested elections. Still worse, where there are contested elections, there is, as Senator Kramer said, there is the need for money, far more than a public servant should need to raise. That requires the unfortunate solicitation of funds, which even at arm's length can give the impression of a promise made. Justice Sandra Day O'Connor, some of you may remember, when she visited our General Assembly about 10 years ago, maybe a little bit longer, she added her voice when she came before this committee to ending contested elections in Maryland more than a decade ago, as I said. And this is her quote, and I can just hear her saying it. And I don't think we should have any cash in our courtrooms. It doesn't belong there. Those are the words of Justice Sandra Day O'Connor. Lawyers and judges across the state and this nation will tell you how wholeheartedly they agree. It is no accident that the MSBA has urged strongly for the end to contested elections of circuit court judges for many years now. Fairness and impartiality must be the only currency in Maryland courts. We've come such a long way, members of the committee, here in Maryland from the early 80s, when courts were, as the senator mentioned, overwhelmingly white and male, and only about 1 in 10 judges was either a woman or a person of color. Today, our courts look so much more like the Maryland communities that they are a part of. It is important that all who seek access to justice in our courts know that people come from all backgrounds, including theirs, serving with distinction as judges in Maryland's courts. Although contested elections may have played a role decades ago to begin diversifying some courts in Maryland, and it was a good thing and needed decades ago, Maryland's governors and the judicial selection commissions, of which I believe you're all familiar, that are established to screen judicial applicants, have played the largest and most effective role in ensuring the diversity of judges we now enjoy. Contested judicial elections have been used most often in recent years with the attendant issues I have already described to target sitting judges of color and unfortunately, with some devastating success. I urge all of you, please, to support this long overdue change to the type of election of circuit court judges. Retention elections will provide the voters with the accountability they are owed, and that will build trust and confidence in the judiciary. Thank you for allowing me to speak this afternoon. When time comes for questions, of course, I'll be happy to answer any of those. But at this point, I would like formally to introduce the Honorable Keith Baines from Cecil County, sitting before this committee as the representative and chair of the Conference of Circuit Judges. So, Judge Baines.
Thank you very much, Chair Smith. Members of the committee, good afternoon. As Chief Judge Barbera indicated, my name is Keith Baines. I am the administrative judge for Cecil County, as well as the administrative judge for the 2nd Judicial Circuit, consisting of Cecil, Kent, Queen Anne's, Talbot, and Caroline counties. I'm here today in my capacity as chair of the Conference of Circuit Court Judges. As many of you know, there is no chief judge of the circuit courts as there is with Chief Judge Morrissey of the District Court. The Conference of Circuit Judges, which is essentially the governing body of the circuit courts, is made up of the circuit administrative judges for the 8 judicial circuits and 1 elected judge from each judicial circuit. I'm here to convey to you that the Conference of Circuit Court Judges unanimously supports Senate Bill 295. Mr. Chairman and members of the committee, there is no question that elections play a vital role in our democratic process. Senate Bill 295 proposes a constitutional amendment to alter the method of selection and tenure of circuit court judges from a contested election process to a retention election, whereby the registered voters of the county from which the judge was appointed vote to approve or reject the continuance in office as judge. This bill does not change the term of office nor the mandatory retirement age. For more than 20 years, the Maryland judiciary has opposed contested elections of Maryland circuit court judges. The rigors of today's judicial elections have proven that open, contested elections do not produce the intended results of the process. By any standard, our system of electing circuit court judges in Maryland is seriously flawed and in desperate need of reform. As noted by Chief Judge Barbera and Senator Kramer, the current process requires judges to raise large sums of money from the very lawyers who appear before them, which undermines the integrity of the very system itself. Yet that is what continues to happen every time a circuit court judge is appointed. Everyone has a right to a fair, independent, and impartial judiciary. Everyone has a right to appear before a judge free from political influence or social pressure. Fair courts mean fair outcomes. Unlike legislators and executive branch officials who choose a career in the political arena, most appointees to the circuit court have no interest in being politicians and fundraisers. They are interested in due process and the rule of law. The rule of law should be everyone's focus, not politics. Once elected, judges are rightfully forbidden from having anything to do with politics and fundraising until their 15-year term is about to expire, and even then, they are limited in what they can say or do compared to their opponent. They have one hand tied behind their back. It's an unfair system. When it's time for an election, judges can only say, as noted by Chief Judge Barbera, I will be fair, I'm going to work hard, I'm going to be impartial. Opposing candidates often say anything they want, for example, being tough on crime, giving long sentences to offenders with weapons, putting addicts in jail, and other things. This often happens without repercussions. In addition, our citizens deserve judges with the background and experience to do the job. From the day a judge dons the robe, he or she is making the decisions that fundamentally affect the lives of people in family, criminal, civil, and juvenile cases. Simply, this is not a job judges have the luxury of sitting on the sidelines for a while learning the job This is a job that needs experience. We currently have a process through the Judicial Nominating Commission. In addition to a comprehensive application, judges are thoroughly vetted through the commission, as well as through 13 local and specialty bar associations. That is the way to pick a qualified judge. Moreover, lawyers who run against sitting circuit court judges need only be 30 years old, a resident for 5 years, and in good standing with the bar. That's it. There's no vetting, there's no qualification or background check. No need to have ever stepped into a courtroom. We have lost some amazing jurists through the current process. Dirty campaign tactics by opponents and named position on the ballot are just some of the reasons. You will hear about some of these from my colleague, Judge Barry. Finally, again, I would like to thank you for your time today, and I would respectfully request your favorable consideration of Senate Bill 295.
Thank you, Judge. We appreciate your testimony. Judge Barry?
Good afternoon, Mr. Chair, Vice Chair, and the members of the committee. Thank you for having me. I'm BB Berry. Before the bench, I practiced in the county for 15 years. My career goals always included engaging in activities to improve competence and integrity in the legal field. To that end, I joined the Judicial Selections Committee of my county bar. Then in 2015, I joined the Trial Courts Nominating Commission. As a member of those two bodies, I vetted judicial applicants. My process, like the others vetting applicants, included review of their application and writing samples, checking the docket to see the extent of their practice in the county, finding and talking to other attorneys, including opposing counsel, because references are great, but we wanted to know what stuff some didn't necessarily want known. How do you treat folks on the other side? Did you follow the rules? Did attorneys have to put everything in writing because they can't trust your word? I would go to several judges and ask the same things. Were they credible, respectful, timely? Did they understand and articulate the law? The vetting revealed things like whether you've been charged or arrested for any violation of any law and the details of that, your business interest, details of litigation in which you were a party, any information that might be considered detrimental, any sanctions, including private reprimands and the like, whether you filed your tax returns. This is just a subset of the information that comes out during this rigorous investigation. Much of this voters can't find out because it's not available to the public, and it's far too much to be conveyed in sound bites during an election. The opinion of the judges is one of the most important pieces of information because we're the ones that see everything. We see how you practice. We see how you treat people. We know if you're competent and honest. The opinion of the judges is completely unavailable in an election, as is much of the other very important information. What voters know is what candidates tell them. As you know, I recently survived an election. My colleagues were condemned for being white. We were accused of being racists, insiders who took advantage of a rigged system, insensitive to the needs of the marginalized communities. Words were twisted out of context and even changed to impact the election. Members of the Judicial Selections Committee were accused of being unethical. These are good people volunteering their time to do the intense investigation that cannot be done in the election process. Of course, the vetting process was attacked, and important facts conveniently left out, facts that opponents know the members of the commission can't discuss. I couldn't reveal them as much as I wanted to. Confidentiality was used as a shield and a sword. Often vetting was entirely discounted because voters were convinced that it's fake news. Voters wanted to know my stance on abortion rights, my political affiliation, and opinions about politically charged issues that we as judges could not give. We go through elections, as you've heard, with a hand tied behind our backs because we're sitting on the bench and are obligated to follow the code of judicial conduct, because we recognize that our responsibility to the community to foster trust and faith in the integrity of the system doesn't stop because we want to keep our jobs. Last year was the centennial of women's suffrage. Of course, that's not when Black women got the vote. We fought a long time and still are not fully franchised. I take the vote very seriously. I take diversity very seriously, as do many people involved in this vetting process. And what I'm also serious about is having competent people on the bench, including, of course, competent people of color. Competent people of color, because we as Black people haven't arrived to the point that putting incompetent Black folks on the bench won't close doors for other people. I didn't always agree on the judges that got appointed. In fact, the impetus for my joining the bench included seeing what good judges can do for our community and also what bad judges do to our community. I wanted to be on the side of good. The vetting system is not perfect, but it is good. It is necessary. It is necessary to protect our community. I implore you, please, please eliminate judicial elections. Thank you so much.
Thank you, Judge Barry. Next, we'll hear from Ron Jericho, and then that will be it for the proponents. We'll take questions after you, Mr. Jericho. Mr. Jericho, you are muted and we'll need you to unmute yourself so we can hear you.
There we go. I've done that. Thank you very much, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Ronald Jericho. I'm a former circuit court judge in Anne Arundel County. I lost in the 2010 election, in a very political charged election. I agree fully with Senator Kramer and Judge Barry's comments because there are elements of that that come in my election and my comments that I've given to the committee. I'm testifying on behalf of the Maryland Association for Justice today. I've also submitted written comments with an exhibit, and I've submitted my own personal written comments with an exhibit for you to be able to review. Let me try to address some of the issues here. A judge is different than all other elected offices. Every other elected office that you run for, there are checks and balances. You have your legislators, you've got the executive branch. Judges don't have that check and balance. A judge can really mess up somebody's life, and they're basically uncontrolled in many ways, in many instances, with no standardized checks and balances. Every 4 years, you run for election. Most politicians run for election, whether it's state or local government. That's not true for judges. Judges are there for 15 years. So the selection process is very important. A judge goes through, and you've heard some of this, about 14 different interviews with bar associations, interest groups like the Women's Bar, the Hispanic Bar, the local bar association, the Maryland State Bar. They're evaluated, that all submit to the Judicial Nominating Commission that does its own evaluation and investigation. Then I know the governor's staff does its own investigation, and then they have recommendations, and the governor vets somebody, does an interview, and gets a selection. A candidate who files goes through none of that. Nobody knows their qualifications or background to be able to take the bench, yet so much is there dependent on alphabet. I lost to somebody whose alphabet started with an A. Judge Adoptee, who reportedly had never tried a case in circuit court before, won, and I lost. I lost at the same time as Laura Ripken, who was just elevated to the Court of Special Appeals. We were appointed in 2010 by Governor O'Malley. And so the fact is that I lost by 7% of the vote. And to somebody who had alphabetic and political connection. Allison Asti, who had been a longtime Democrat, courted the Republican Party, and she became endorsed by all Republicans in this county. We had bipartisan support. The Republican supporters for us would not let us use their names in our advertising or anything else. Unfortunately, it was a highly charged political election. In our county, Governor Ehrlich, who ran that year, won 54% of the vote. Governor O'Malley did not. And he endorsed Allison Asti against us. And so as a result, I'm not on the bench. I have to admit, I've had a great career since, but I can't regret it too much. But still, I missed what I tried for 35 years to get to be on the bench. I submitted as one of my exhibits a study I did last year on how much money judicial slates raise. It's about $200,000 to $400,000, and it's not a complete study, but it gives you some indication of the ethical issues that have been talked about, where most of the lawyers contribute, and that does raise an ethical issue. Allison Asti had raised some money before the election, and then after she was elected,
Mr. Jericho,
yes, ma'am.
we're coming up on our 5-minute limit here. Would you like to have some words to conclude?
Yes, let me just conclude. The retention election solves the problem. Please read my written comments in which I've summarized all this. Look at the exhibits I've got, which emphasizes what I've said in my comments. And please adopt and let the voters vote on a retention election. Thank you.
Thank you, Mr. Jericho. I misspoke earlier. We're going to take all the witnesses on this bill and then questions after. So Ms. Barber, you are next, signed up to testify as an unfavorable witness.
Thank you very much. Good afternoon to the chair, as well as the vice chair and the committee members. My name is Claudia Barber. I am a 2016 and 2018 candidate for judge on the Circuit Court for Anne Arundel County. The 2020 presidential election is an indicator that circuit court contested judicial elections should never be eliminated. In 2020, 7 of the last successful challengers have been women, and 4 of them have been African American. And one of the successful male challengers was Judge Quincy Coleman, an African American male now on the Circuit Court for Howard County. I would like to continue their names: Judge Quincy Coleman of the Circuit Court for Howard County, Judge Gladys Weatherspoon, all the way at the bottom of the ballot for the Circuit Court for Prince George's County, Judge Makiba Gibbs, Circuit Court for Charles County, and Judge April Adamailuyi on the Circuit Court for Prince George's County. There are many county circuit courts in the state that continue to lack diversity. They include the Circuit Court for Anne Arundel County, which has no Hispanics, no Asian Americans, no Native Americans on its bench, and no African American males. Other circuit courts lacking African American male judges include Charles County Circuit Court, Montgomery County Circuit Court, Carroll County Circuit Court, and many rural counties. The real problem is that the trial court judicial nominating commissions continue to practice exclusion when it shortlists candidates for the governor to appoint. There is no sign that they will stop. They will continue to participate in state-sponsored discrimination. When Governor Marvin Mandel created his executive order decades ago, someone recognized it would be an imperfect process. It remains an imperfect process. One of the pieces of misinformation by many of the proponents of this legislation is that all candidates go through specialty bars. That's not true. The application says that is a voluntary choice by the applicant to allow their applications to go through specialty bars associations. So that is not a mandatory thing. Secondly, the fact that there are no Native Americans or Hispanic Americans or Asian Americans in the 300+ year history of Anne Arundel County Circuit Court exemplifies the insidious glass ceiling created by the Judicial Nominating Commission process. To remove the only hope that most minority candidates have to being elected to the judiciary is to ensure, particularly in those counties where minorities are underrepresented, that the judiciary in Maryland will remain monochromatic. My running in a contested judicial election in 2016 was the only reason there was a sudden interest to diversify the bench in 2018. For a decade, the bench was not diversified. From 2004 through 2018, it was a segregated circuit court for Anne Arundel County. I ask that the legislature reevaluate Senate Bill 295 as it further removes voter impact to effect change and to diversify the judiciary throughout the state of Maryland. Voters are in a better position to decide on who should be their trial court judges, more so than a non-elected commission chosen based on partisan relationships. This is too important of a matter to remove the voice of the voters. The electorate should continue to have a say in those adjudicating the most important matters of their lives. Thank you.
Thank you, Ms. Barber, for your testimony here today. That concludes the witnesses. I don't see any hands raised in my panel, but in real life, how about we start with Senator Jackson?
Thank you, Mr. Vice Chairman. Mr. Chairman, I have a couple of questions for the panelists. Attorney Barber hit on a number of points. Just for the record, I served as sheriff of Prince George's County. Prince George's County has 23 members of the circuit court bench. Prince George's County is a county that has, a majority minority county. We have 62% or roughly 70% Black and Latinos, close to 80% almost in Prince George's County. Yeah, we do not have an Hispanic on the bench. We have I think Simpkins Garner is Afro-Latina. We only have 4 male circuit court judges. In an earlier statement, I believe it was Judge Bain that mentioned the qualifications of the applicants. So I guess I'd pose a question to the maker of the bill, to Senator Kramer. Are you interested in working to enhance the qualifications for those who are seeking to get elected to the bench, if that is a challenge? I think the overall challenge is the opportunity for those who apparently, the attorneys apparently feel that they have gone through the extensive process numerous times and still can't get appointed to the bench. So I believe in the past I have voted against this legislation. Senator Kramer, if you could speak to the qualifications matter, if you'd be interested in enhancing those, if that is a barrier that, or an unfairness that sitting judges believe it works against their favor, works against their favor during an election process, because obviously they are limited in what they could do. This would actually place all of our judges, except for the district court judges, at the behest of someone's appointment versus an election. So thank you, Mr. Chairman.
Yes, thank you for that question. And it's a good one, Senator Jackson. The fact of the matter is the bar is non-existent for someone to run in one of the contested elections. It is ripe for creating mayhem, and we have seen that it does time and time again, and that we can have individuals who are completely unqualified, who are prepared to pander and say what they believe is what's going to get them on the bench. And I just don't think that we can accept that standard when, as it was mentioned, these are individuals, those who sit on the bench, who can have dramatic impacts on the lives of the residents of our state. And the notion that someone can just simply either spend their way onto the bench or alphabetically find their way to the bench, or simply, as is the case in this last election, curry to the Republican Party 2 years ago and then get in bed with the far left progressives, hoping that that's a strategy, that somehow we are going to do justice on the bench, because we're not. I don't know whether there is an opportunity to create standards to elevate the opportunity for someone to be a candidate, but clearly the process that exists right now for vetting these candidates is far, far superior to the notion of I can pay $50 and I could be making a decision that could change your life for the rest of the time you're on this planet. And that's a frightening notion. And I know that I would much rather go before someone that I believe has the skills, the competency, and the capability and the right temperament to be making those decisions than just somebody who was able to find a way to get on the bench. So, I do appreciate your comments. But I also don't think when you look at the bench as a whole, as I had indicated, that the full third of the bench comes from the minority community, and well over 50% of the bench is comprised of women and minorities. And I think that, the fact of the matter is, in the 21st century, we have seen a dramatic change in appointments and things have moved forward. But I thank you for the question. And Mr. Chair, at some point, I am going to have to jump because I have a bill being heard in my committee. I already got a notification, but I'm trying to delay. And so if anybody has questions for me, please jump in and ask me now. I'd love the opportunity to have that conversation before I go back to my committee.
So I saw Senator Carter and Senator West. Do either of you have a question for the sponsor of the bill? Okay. It looks like Senator Jackson, you have a quick follow-up.
Yes, thank you. Thank you. Again, I'd just like to reiterate, if qualifications are the issue, I think I would love to work with you, or I would like to see that addressed. And when you talk about the numbers of judges, percentage-wise, I'm not sure if we're talking about locales, right? I mean, so if you look at individual counties, love to see that breakdown. I've actually looked at this. And in some counties, again, there are folks who believe that they don't have any other opportunity. And having been a sheriff, we actually went through that as well, who's qualified to run for sheriff and what have you. So I understand the concern, but I think qualifications should be where we should go. Thank you, Mr. Chairman.
All right, thank you, Senator Kramer. We'll release you to committee. And
Thank you.
I think Senator West had the next question here. Go ahead, Senator.
Actually, I do have one for Senator Kramer. Normally, I understand that the practice of the General Assembly is not to take constitutional amendments in years that are not election years. As you'll recall, I had my bill, which addressed this issue from a slightly different slant last year. I didn't file it this year on purpose because it's not an election year. If for whatever reason we were to turn thumbs down on your bill this year, Senator Kramer, are you prepared to bring it back next year, or has he left? Looks like he's left.
So that's okay. I think Senator Kramer had to head back to committee.
Okay.
But I'm sure that's a discussion we'll be having within the committee. I apologize for that, Senator West. I spoke too soon earlier. But I know you had a question perhaps for the rest of the panel.
Yeah, I have one or two. Chief Judge Barbera, we had this similar conversation last year. You advocate for the replacement of the current system with a replacement system in which judges once appointed would have to run in retention elections, and therefore their names would still be before the voters. Now, I got sworn into the bar in Maryland in 1975. So it's been 45 years now, actually more than 45 years since I was sworn in. I've been in a system of retention elections for appellate court judges my entire legal career. Are you aware of any judge running in a retention election in Maryland who has ever lost? I think we need to unmute the Chief Judge.
Judge, if you could.
There I am. Sometimes I'm a little late to, I knew what I needed to do, but I was finding the button. I know there hasn't been a loss in Montgomery County. I can't speak to it in the other jurisdictions. At the risk of giving you misinformation, which I would be loath to do. So there are folks who can get that data, collect it, and send it to you, and we will share it with the rest of the committee. There have been circumstances in some of the counties where judges have resigned with the well, no one knows for sure anything before the vote is counted, but have resigned with the thought, circuit court judges, sitting circuit court judges, that they will lose the battle.
Actually, I was talking about the appellate court judges, which did have to run in
I'm
potential
sorry.
elections.
I don't think there ever has been.
That was my impression too. So we got
Yes.
5 years with lots of retention elections and nobody's ever lost.
Right. And I think that's absolutely the case. You know, the elections for, well, the appointments by governors for appellate judges seems in many respects to be less potentially fraught. Decisions made more difficult for our governor, regardless of party, over time. I think that when we're talking about trial judges, where they're having direct one person on the bench making decisions as they must and should and do on a daily basis, as everyone on this committee I'm sure knows, it is really, should be a rigorous, and I believe it was Judge Barry who used the term, a rigorous vetting process, because many lives can be destroyed if a judge goes wrong, has not made a wise decision based upon the law. That doesn't mean that every judge would decide the same way or impose the same sentence for the same facts, but their jobs are very different. And I will say, I admire the trial judges to be able, I get to contemplate for days, if not weeks, on what the answer to an opinion that I'm going to be authoring for the court. Trial judges decide in the moment. Am I not correct, Judge Baines? He's nodding his head. I think Judge Barry is nodding her head. But I will follow up on your question, Senator, and get that information to you. And I can do it as well for the circuit court if you're interested.
Yeah, I'm not just in the circuit court. That would be a much greater effort to get all that information. Just the
okay.
court elections.
We'll do, and we'll have it for you very quickly. Thank you.
Thank you, Chief Judge. And if for whatever reason this bill doesn't come to fruition this year, I would love the opportunity to sit down with you between now and the next session to see if we can't come up with a compromise that those of us on my side could support, as well as those of us on your side.
I'll be happy to have a conversation with you, Senator. And you may or may not know that I'm a short timer. I have a birthday
That will be our
coming
loss.
in September. But I want to make every minute between now and then work.
Right.
Everything needs to be valuable. And so this is valuable. What we're doing today, right now, this minute, it's valuable. And so thank you for the opportunity.
And then I have one more question, and I guess it's for Judge Baines, who is new to this conversation, I think, this year. I've been involved in it for many years now. So I'm a lawyer who's always practiced in Baltimore City, and I can remember back in the 1970s and 80s when there were a long succession of judicial challenges by members of the Monumental City Bar Association, which is the African American Bar Association in Baltimore, to a series of circuit court appointees who were white males in almost every case, maybe in every case, by the governors of that era. And in one case after another, the challengers won those elections. And it was a way in which diversity was achieved on the bench. And then in the 1990s, there were a number of Republican challengers during an era when the governor wasn't appointing any Republicans to the bench anywhere in the state. So then now recently, I've taken a look at the numbers, Can you confirm to me, it looks to me as if in 2018, there were two general election challenges, both by women of male judges, and in both cases, the women won. And then last year in 2020, there were 4 challenges in the general election, all by African Americans, 3 by African American women, 1 by an African American man. And the 4 people being challenged were white men. And in all 4 cases, the African American candidates won. Is that your understanding of what happened in the last 2 elections? I'm sorry, I was talking to Judge Baines, but
So I don't have that documentation in front of me, so I accept.
okay. So it looks like the election process is still performing the same, if that's the correct, and I think it is performing the same function as it did back in the 1970s and 80s, as well as in the 1990s, namely to provide opportunities for minorities to challenge the appointees of the governor, and so the bench becomes more diversified in the process. So I guess that's the end of my questions. I think Senator Carter was next.
I think, Judge Barry, did you have something to say before we?
I just wanted to just tell you, Senator West, thank you. I do know that there were 3 women, excuse me, there were 4 Black persons who got on, but 1 and 4 white judges who came off. One of them got out of the race when I think the writing was on the wall that he was going to lose. But I do want to just point out to the group that Judge Mike McCullough applied at the same time. There were 2 positions. Well, 1 position opened first, and then while we were in the middle of the application process, the second one opened. And no people of color applied for the position that I got, no people of color. And I think part of the reason is because, one reason is because you don't have to go through any vetting. You don't have to go through that. You can just put your name on the ballot and you're good to go. But there also might be another reason, which is that when you apply for the judicial position, you have to close down if you get it, you close down your practice. You close down everything, you give away your clients. That may be okay for someone who is in a large firm and they can just, give their clients to someone else. And then if they lose, they come back and they're good to go. Not so good for someone who's in a smaller firm or a solo. And I think you'll find that there are a lot of people of color who are in those smaller firms. But if you have a system set up, we're talking about systematic racism is what we're talking about, systemic racism. In my opinion, you don't resolve systemic racism by saying, okay, we just need to diversify this. We need to put people on the bench because we need people to see Black people on the bench. And we're not concerned with whether or not they are experienced to do it. And for me personally, it's an insult. It's an insult. And I think it is for a lot of people of color that people are saying, let's just put them on the bench. So those are my thoughts. Thank you.
Thanks, Judge Barry. We'll now move to Senator Carter.
Thank you, Mr. Chair, and thank you Judge Barbera and Judge Baines and Judge Barry for bringing the bill and supporting it. I've heard it many, many times over the years, and I used to object based on the fact that my history in Baltimore and with Black judges and having clerked for the Honorable Kenneth Levon Johnson, who had to win his seat in 1982. And also prior to that, when I was a small child, Judge Joseph Howard, who had to run, those are 2 among the ones that I think Senator West was speaking about. But also subsequent to that, I had the experience of Judge Paul Smith, who it is largely believed that had he not run to give himself that leverage, the governor would have never appointed him. And so those are the situations from the past, but Senator West and Attorney Barber brought up these recent elections where we've had in Prince George's County now Judge Gladys Witherspoon, April Ademiluyi, I may not say that correctly, and then in Howard County, Quincy Coleman, and Charles County, Makiba Gibbs. And what I keep hearing from the side of the proponent or the proponents to remove the judicial elections is about the qualifications and the vetting. And so my question to any or all of you is it your position that any one of these 4 judges that was just one election are not qualified to be judges?
Senator Carr, do you have a specific person you'd like to start with?
I guess I was kind of directing it to the members, the judges, but anybody's welcome to answer because consistently from the sponsor and the judges, we hear about the vetting being the big reason that we need to eliminate elections because just any old person could get elected. And I just wanted to know, are there specific examples, particularly among these recent 4, that won their elections having been duly elected by the voters of their jurisdictions?
I would just say, thank you, Senator Carter. I actually don't know the four people of color that won, but I can tell you that the candidates that we had in Montgomery County were not qualified to be on this bench.
But you all won, right? The sitting judges won there, correct?
Correct, but we won.
Right.
You know, the reality is we won because of money. We won, we had to throw $500,000 into this campaign to educate people about us. Because when I was at the polls, and I was at the polls for days and days and days and days, and the judiciary didn't have 4 of its judges because we were at the polls. And over and over and over again, I was in Silver Spring, and people were saying, well, I'll vote for you, but not those other white boys. I'm not voting for them. That happened throughout the election. People didn't care about qualification. And we had to throw so much money to just try to get them to know who we were and to understand this process.
I think Senator Kramer said it earlier, and I agree. Many of the people in our own jurisdictions that elect us, delegates, have no idea who we are or our qualifications. And I empathize because we also are expected to raise exorbitant amounts of money for a job that pays $50,000 a year and often cuts into your ability to earn a living outside of the legislature. So the burden of having to raise exorbitant amounts of money is pretty much across the board an issue, and I think most of us can relate to it. I just want to highlight that while there is a history of racism and white supremacy as well as sexism, which is why we were not able to get diversity through appointments historically, that what I believe is that there is a system of elitism that exists with the process that exists now, with just the nominating the different legal groups, legal associations, and then the nominating commission, you know, those members of the nominating commission being people that the governor selects. And, you know, over the course of my career, first I want to say that having had a long career and experiences with multiple judges in multiple jurisdictions, I actually have a high regard and high opinion of the integrity that exists generally on the bench across the state. And so even though, you know, one of the reasons for this bill is ostensibly the corruption or potential for corruption, I really haven't seen very much of that. I've had a lot of judges that I disagreed with, but I don't believe it's because the other side funded them more heavily or at all, because I think it's very rare that I've actually put money into a judicial campaign. But so I think that integrity not really a huge problem with judges, because most of the judges that I've appeared before, whether they be elected or appointed, they have a lot of integrity for the most part. But when you talk about the dilemma of having to expose yourself or go into the communities and explain yourself, I actually believe that is a benefit, like a bonus. I think that people whose lives you preside over, their divorces, their custody, their criminal cases, their civil cases, I actually believe that this current process is the only opportunity that people have to actually have a voice in the person or persons that will preside over their most important issues in life. And one question I've heard a lot over the years, like, you can't say your positions, blah, blah, and that's a problem. But what I do struggle with is I don't understand what the restriction is on being able to explain to a potential voter or group of potential voters, there are two sides or multiple sides to this dilemma. The proponents of this would argue this, the opponents would argue this. And at the end of all of it, after I hear it, I'm going to be fair. I'm going to make my decision based on what's fair under the individual circumstances and not some cookie cutter or blanket approach. I believe that voters would be happy with an answer like that, as opposed to just no answer at all. And it also helps enlighten them on the process. So, and gets them more engaged in terms of, this is why I should vote for judge, because they preside over my life. So can you speak to that at all, Judge Barry or anyone?
Okay, can I address those points? I'm sorry, Ron Jericho, I'm a former judge, as you heard. The biggest problem in campaigning, and I appreciate the dilemma, is you're running county-wide, not just in a legislative district. You're raising money, and you can never raise enough money to do that county-wide. When you go to community forums, which I went to just about every night, most people want to hear from people like you running in their local legislative district or the county executive. And as a judge, they say, well, you can wave to the crowd, but we're not going to give you an opportunity to speak. There were 200,000 people in this county that voted for governor in my election. Only 100,000 voted for judge, meaning 100,000 people either didn't know enough or didn't bother enough to get down and vote for judge. The prospect of going out and maybe speaking to 10,000 people in the course of campaigning, or going house to house, even speaking to 20,000 people. You can't speak to enough people in order to have an impact. And in mailings, you need money. And in going out and doing television advertising, you need money. And the problem is there's never enough of that. We basically ran out of money. I mean, it's just a reality. I'm sorry to say that.
I understand. I hear what you're saying. I think it's also difficult though for challengers, unless they're like, super rich, to be able to raise enough money to challenge judges. I mean, over my career, I've seen a multitude of persons. I remember when in Baltimore City, I just had a case come before it came to session. It's escaping me, but he ran for office as well, and then was ultimately appointed. But he was unable to raise, enough money to really compete adequately with the sitting judges. So it's difficult on all ends. I think that what I'd like you to contemplate as you continue to move down this line, and Judge Barbera, we'll miss you, but I hope that this issue is not finally resolved this year, because I think that the discussion is important. The decision is too important. The decision is way too important. I am a person that tends to champion for the underdog just in every aspect of my life. And I know and appreciate those attorneys that are dogged, that work so hard, that are taking low bono and pro bono cases because they're Black and they represent a lot of Black and underserved communities. They don't have time, or maybe the resources even, to join every bar association and be part of the elite inner circle of attorneys that are often elevated and promoted through these processes. But I want them to have a chance to be on the bench. I don't want to foreclose the only opportunity they have to ever be able to be a judge. And that is my biggest concern and fear with what you propose here. So can you speak to that?
I'd like to make a quick response, Senator Carter, to your comments just moments ago, as well as earlier comments that you made. When you think about it, what do we want? What do we want of our judges? And this is again, I'm swinging back to Judge Barry, something that you said. What we want is people who are prepared to preside over the lives and the welfare of the people who come before them. We want them to be sufficiently experienced in the law, competent, have exhibited over time the qualifications that I think are central to good judge decision-making. I certainly understand that there are not everyone has the financial wherewithal to be able to explain, as you say, solos or small practitioners. They run a risk when they run for an election. They put their qualifications on the line, and sometimes they'll prevail. And what one would hope, let the best man or woman who is most qualified for this position, demonstrably, I suppose is the better word. So what Judge Barry said, we don't want women on the bench simply because they're women. We want qualified women on the bench. We don't want people of color on the bench just for, I think you said, Judge Barry, that you found it insulting. We want people who are going to do the job well, and meanwhile, don't overlook women, don't overlook people of color. We've got many, many fabulous attorneys in the state of Maryland who would do an admirable job as a judge. Not all are interested in doing it. There's a smaller number of us that are. But in the end, what we want are the people who will do the job well. Short, tall, men, woman, Caucasian, African American, Asian. You get my drift. So I'll be quiet. I'll stand down, and I'll be interested in the continued conversation for sure.
I appreciate it, Chief Judge Rivera. And Senator Carter, just if you could close with a couple questions. We are still on our first bill. We've got 10 to go.
I'm finished. Thank you, Mr. Chair. I'm finished. Miss Attorney Barber looks like she's been raising her hand to respond, so I'd like to.
You have a question for her?
Well, my question was posed to everyone, but she wanted to answer, I think, an earlier question.
Ms. Barber.
Thank you. I'll be very brief. Judge Makiba Gibbs was shortlisted in the Charles County Circuit Court judicial selection process. So she's an example of someone who was vetted, but she was not appointed. Another example of an African-American male who brought diversity to the bench, who ran in a contested judicial election because the judicial nominating process was not open to allowing African-American males to the bench, is Judge Billy Murphy. Is a perfect example of someone who ran in a contested judicial election because the Judicial Nominating Commission process was a failure. And to the extent that they continue to allow elitists in as opposed to qualified applicants. I mean, I've spoken with people and had conversations with nomination commission members, and some of them will share with you that they make up their own rules when it comes to deciding who is shortlisted. And it has nothing to do with the qualifications that are identified in the Constitution. So that is the major concern. Thank you.
Thank you very much, Ms. Barber. Senator Carter, you good to go?
Thank you.
All right, great. Looking around the room, it's funny you mentioned Mr. Murphy. I do believe he testified in favor of this bill last year, but and I think that, I'll let you, Jill, I'll let you get back then, don't worry. I do want to say, like, the example from Montgomery County is instructive. And so for the members of the committee that are not familiar with it, I think you should take a look into what that campaign looked like and some of the information and some of the tactics that were used and employed during that campaign, because I think it would be instructive for the members to understand how that unfolded. Senator Carter.
Thank you, Mr. Chair. I just wanted to say that I think, so Billy Murphy, who had been a longtime opponent of eliminating judicial elections, I think that last year he testified, I'm not sure if it's this exact bill, I think it was an alternative bill that I think maybe Senator West and Eric Barron had put in, which would have broadened the authority or the input from the Senate while taking the vote away from the people. It would actually have been somewhat of a more democratic process, because it would have given us, those that represent the people on the legislative level, more input. And so I think that is the bill that he was in favor of, which, while I don't support either bill at this point, I think that is the better of the two.
That's right. Senator West is nodding, but I think we'll pull his testimony, because I definitely will. I was trying to get it. I think he made some very strong arguments for ridding ourselves of judicial elections. But let us look around the Zoom room. Senator Castley.
Thank you, Mr. Chairman. Just really briefly, so this is, I guess, my 7th legislative session, and I think every session this and other similar bills have come in, and every session the same question comes up, that as to why there's never any effort, any attempt made to improve the existing system. The only choices we're ever given here are throw it out, go all elected or no elected, and there's people come in every year. The judiciary comes in with the hard list of the top 10 worst election stories. There's never, each time we asked, well, is there any effort made so you can rein in, so that you can apply different standards in an election to judges versus other elected positions? Are there any, could we put standards, minimal qualifications if you want to run for a circuit court judge and the like, to try to tighten this up? And we never do that. And I find it frustrating that, look, let's face it, the current system, and my question here can anybody tell me why there's never any effort to simply make even a single change to the existing system to correct at least one of the horror stories? Because the litany is that, well, this system produces judges who are super qualified. But look, your overwhelming docket is criminal and domestic, and it's rather frequent that you get judges who A, have no litigation experience, and B, no criminal experience, and C, no domestic experience. So are they smart people? Yeah, they're typically smart people, but I see it's a far cry from the current system, is a far cry from a perfect system, and let's face it, it's incredibly political. If you don't decide from the minute you graduate from law school that you want to be a judge and start according yourself on a straight line towards that, you'll probably never get there. So the current system, I think, has a lot of flaws. I'm sorry, the nominating system is far from flaw free, and I think the election system has served a useful purpose in rectifying some of the critical flaws. But can anybody just tell me why we never make any effort we never have a bar commission to study that? We never make positive recommendations. Why is that? Thank you.
Just an offhand response to that. Good question, Senator Castle, because as I'm listening to you, I'm thinking, I can't recall when the courts or the bar or I think governors, the application has changed, not dramatically over the years, but that might be one place for us to look. And I don't mean just the judiciary. The bar should have an opportunity to weigh in on what should that application look like? What should its experience? What should the questions that go to experience? What should be the content of those questions? My friends, Judge Baines and Judge Barry, know full well what that application itself is and the amount of time and energy that it takes, because it generally provides, they're usually 40, 50, 60 pages long by the time all the questions have been completed. So that might be something for us to take another look at, Senator Cassidy. I'm so happy that you raised the question. I might be calling you.
Good. And good luck, Chief Judge. Thank you.
Thank you.
Not with calling me. Good luck with what happens next in your career, in your future.
Oh, look, I still
I'm
have,
right next to the phone. Call me anytime. I didn't mean
my
good luck with-
birthday is not till September. I'm a Virgo. And I'm going
All
to
right.
work every darn minute between now and then to get as much good work done as possible.
All right. Thank you.
Glad you corrected that for the record, Senator Cassidy. Seeing no further questions, I think that is it. Thank you all very much. And with that, that'll conclude. Thank you. Good to see you all. And that'll conclude the hearing for Senate Bill 295.
Thank you.
Now move on. I know that Senator Riley, you've been waiting very patiently. Thank you. Senator Riley, you're up next with Senate Bill 289.
Thank you, Mr. Chairman. And Vice Chairman and members of the committee. About a year ago, I stood on the floor of the Senate and announced that the circuit court building was closed due to COVID, due to the overabundance of caution to protecting the hardworking people in the courthouse. And of course, that had wide-ranging implications, and one of which brings us here today. For about 60 days, there was not a single marriage license issued in Anne Arundel County. This was because nobody was there, and the current COMAR says one of the parties must show up in person to sign the documentation and attest to the upcoming wedding. About 60 days into the COVID restrictions, the good Chief Justice Barbera issued a declaration that they can now start issuing marriage licenses virtually. And they did. And now for the past many months, people are getting married in Anne Arundel County, some in person, some virtually. And our clerk of the court, Scott Poyer, will be here to tell us a few stories about how things have occurred over the past 10 months. But again, I said on the floor of the Senate a year ago, we'll be back to try to put a permanent fix in, because as soon as the state of emergency expires in Anne Arundel County, you have to show up in person to sign the affidavit. This bill removes that responsibility, that obligation, and makes it an option. At the end of the testimony, if other counties were to approach their clerk of the courts and want to be included, I'm all for it. I don't think I have I'm not in a position to make this a statewide bill. Most of these things are done county by county. Scott may even talk about what the Association of Clerks of the Court may have said about this, but I'd be happy to have anybody else tag along, and would ask for your support. Now, Mr. Chairman, the procedure in Anne Arundel County Senate delegation is all the bills heard during this first several weeks will be reviewed by the delegation on February 1st. At that time, I'll be able to come back to the committee with a letter of support or a letter of non-support, and I'll let the committee know at that time as to what Anne Arundel County Senate delegation will do with this position. Thank you, Mr. Chairman.
Thank you, Senator. Thank you for addressing that, because kind of always the first question is, what is the delegation say? Appreciate that. Well, thank you very much for your testimony. We are going to go into your panel, and then we'll take questions at the end if there are any. I saw that is Senator Middleton. Is he on?
No, I don't think he's on this panel. It's just Mr. Poyer.
Okay, there you go. Mr. Poyer, you are up next.
Thank you, Chairman Smith and members of the committee, for this opportunity to testify in support of SB 289. For the record, my name is Scott Poyer, and I am the Clerk of the Circuit Court for Anne Arundel County. My testimony today is not on behalf of the Maryland Judiciary. I am here representing myself as the elected official who is responsible for issuing marriage licenses and performing marriage ceremonies in Anne Arundel County. I support SB 289 because it offers the flexibility to accept marriage applications and perform marriage ceremonies remotely. As you may be aware, during the COVID state of emergency, Governor Hogan temporarily granted this authority in Executive Order number 2020-05-13-02 in May of 2020. My understanding is that SB 289 seeks to make this authority permanent. During the approximately 8 months that my office has been operating under the governor's temporary authority, we've conducted approximately 500 online marriage ceremonies and processed thousands of marriage applications. I would consider this real-world test a success. At the beginning of the state of emergency, it allowed some couples to get married who would not otherwise have been able to do so. And later in the state of emergency, when we started offering applicants the choice of either in-person or online ceremonies, numerous couples chose the online option. The online ceremonies continue to be very popular and do not cost more or take any more time to conduct. The online option may be as popular as it is with the couples getting married because it offers facets that aren't available for in-person ceremonies. For instance, for an online ceremony, the couple needs to be located together in Anne Arundel County, but the number of guests can be almost unlimited. We have performed online ceremonies with guests on 3 continents who would not otherwise have been able to participate in the ceremony. We performed a ceremony for a couple who could not leave their house due to quarantine. We performed a ceremony for a couple in the hospital who had just had a baby. And we performed several ceremonies for service members about to be deployed. Now, one issue that concerned me when we developed our process for conducting online weddings was whether it would increase the potential for child trafficking. However, we built checks into the process, such as requiring signed affidavits, photo ID, and dialogue with the applicants before the ceremony to ensure that both are eligible to marry and that neither is being coerced. My opinion is that the security of the online option is approximately equal to the in-person option. So, because of the increased flexibility offered by the online ceremonies and an approximately equivalent level of security compared to existing in-person ceremonies, I support SB 289. Thank you very much for the opportunity to comment on this bill, and I'm available for any questions that you may have.
All right, thank you very much. I think Senator Hedelman has a question.
Thank you very much, Mr. Chairman. I wonder if you could just go into a little more detail about those security precautions. Are you actually Zooming face-to-face and seeing the parties involved? I know you said you have an affidavit and you talked to them on the phone, but can you just kind of walk us through the security protocols that you go through to ensure that there aren't trafficking issues?
Absolutely. And you put your finger right on some of the security checks that we put in place. It's a requirement that we see both parties that are being married. So let me just walk you through the process from the beginning. When we have, and some of the security checks that we put in, when they originally apply on the application, they also have to sign an affidavit that under penalty of perjury, they're not lying on their application. So, and then in big red letters, it also says that they have to be physically present in Anne Arundel County. So under penalty of perjury, they are saying that they're in Anne Arundel County, they're eligible to marry, they are the persons who they say they are. And then we go ahead and we issue the license. And then when we schedule the ceremony, when we start the ceremony, when they come on screen, we make them show photo ID so that we can make sure that the people that are engaging in the ceremony are the people who are also, we granted the license to. So we have to see photo ID. We have to see them together. And then if at any point there were anything that caused me to question whether either of the people were there being coerced or anything like that, I would have them call me individually. I would break up the call, I would stop it, the ceremony, and I would say that each of them would need to call me individually.
Colleagues, I stepped out for a minute to
Thank you very much. I just have a follow-up question. Have you had the circumstance where you've had to stop things?
I've had it in person.
Tammy,
I actually had to do it
I
in
can share with
in-person
you.
ceremonies, where I had a couple who had just come from the hospital. It wasn't a child trafficking issue. It was an issue with a elder person who was marrying a much younger person. And I did stop the ceremony. And I talked to each of them individually. The gentleman who was getting married knew what he was doing, and he was there to get married. I performed, after he set my mind at ease, I did perform the ceremony. So far, it hasn't come up during one of our online ceremonies, but if it did, I would handle it the same way. I would stop the ceremony, and I would make sure that both were there under of their own volition.
Thank you very much.
No, thank you, Senator.
Thank you very much, Senator Heddleman. Senator West has a question.
Thank you, Mr. Chair. This is just a technical question. It's on page 3 of the bill. Down the middle of the page, lines 16 through 22, it says that the information on an application submitted under paragraph 1.1 shall be sworn to, 1, under oath before the clerk through the use of video conferencing, or 2, if the use of video conferencing is not practical under the circumstances in an affidavit included with the application. It sounds like the preference is for video conferencing, and unless you can establish to the clerk's satisfaction that video conferencing is not practical, you would have to use the video conferencing as opposed to using the old-fashioned method of submitting it in writing. Shouldn't we invert that so that the normal way of doing it would be to submit it in writing? And if that isn't practical, through video conferencing?
Is that a question for Senator Riley or?
Well, for either one of you.
He's on you right now.
Okay, I'm afraid. You can answer the question. I have to run to another committee for a different bill. I'm sorry. So
just very quickly, I would say we've been operating under the governor's authority, virtually the same, and it gives us the option. So we do a high volume in Anne Arundel County. We're doing 2,000 weddings ceremonies a year, and because of that, we're using the affidavit option. But the way it's written right now, it gives the clerk the option either to do it by video or to use the affidavit. I believe some of the smaller jurisdictions are using the affidavit, are using the video option. Because of our volume, we just chose to use the affidavit. I think as long as it gives the clerk the option, I think it's good, but I leave to Senator Riley if he wanted to invert it, as Senator West just suggested, up to the members of the legislature.
All right, thank you very much, Mr. Poyer, and thank you very much. Actually, hold on, we have one more question. Senator Castley.
Senator Castley may be muted.
Yeah, Senator Castley, if you could unmute yourself, sorry. Here you go.
Are we there? Okay. So I and a lot of my colleagues have done litigation, both deposition and even hearings, and even trials by video over the last 6-7 months. And there's sort of a constant complaint that as long as credibility is not an issue, video works pretty well. If you're just getting down facts, but when you're trying to discern that bit of discomfort, that thing that makes you push a little bit harder as a litigator to say, or was that the truth? And it's tough to do that in the videos. And so maybe you can say something that would sort of alleviate my concerns as someone who does try to ascertain a person's true intent, comfort, credibility through a video screen, and is not too comfortable with that. Thank you.
Oh, yes, sir. So, Senator, it is the case that suppose all the checks that we put in place don't work, because perjury happens. People lie. If they do, it's not a valid marriage. Already written into the statute is that if somebody falsifies the information, gets married under false pretenses, it's not a valid marriage. That's already in the statute. So
it's not really a matter of that
Yes.
they're overtly committing perjury. The issue we often face in JPR is marriages that are perhaps coerced, or there's something else there. There's something that we ought to be looking at and say, wait a second, because it is a matter for the person giving the ceremony to feel very comfortable that this was a free and voluntary act. So that there's no other inducements and the like, that this isn't being done as a sham, or that this isn't for financial gain or something like that. So which would not then rise to the level of, oh, well, you lied. Your name is actually Sue Jones, not Mary Smith. Yeah, clearly that now you've perjured and the whole thing's a sham. It's more the issues of trying to have a neutral set of eyes who watches these two people and tries to make a credibility judgment that this is actually a marriage for the right purpose and not for some sort of improper, or that someone's being coerced. That's all.
I'd say no system is perfect. I can usually get a good feeling from the people, whether they're in front of me or on the video. So I'm comfortable enough when I'm talking to them that I do have the feeling. Everybody is nervous on their wedding day, everybody. But it is the case that when you can see them, and we do require that we see both of them, you can see if something just doesn't look right. So no system is perfect. We put in as many checks and balances as we can to protect and to make sure that there is nothing untoward going on. But at the end of the day, I can't think of a perfect system that would absolutely guarantee it, whether it be in person or via video.
Thank you.
No, thank you, Senator.
Excellent. Thank you, Senator Castley. Looking around, any more further questions from the committee? Seeing none. Thank you, Senator Riley. Thank you, Mr. Poyer. Good to see you both. And with that, that'll conclude the testimony for Senate Bill 289. We'll now move on to Senate Bill 7 with Senator Simon Ayer. You're up next. The floor is yours.
Thank you. I'm assuming you can hear me.
Loud and clear.
Okay, great. I wanted to open up by saying thank you to this committee for your support over the years for the Courthouse Dog Program. I initiated the program as a pilot program back in 2016, and last year it went statewide with your support, and it was very successful and well received in Anne Arundel County and Harford counties. The legislation set up a framework for allowing highly trained dogs in the court with children. In fact, this idea has gone nationally since we've enacted it, and there's legislation pending for the federal courts. And after last session, I was approached by veterans groups and asked if we could expand the program to the Veterans Court. Knowing the need for veterans and the struggles many of them have with PTSD and other trauma issues, I thought it would be a perfect fit. While some had voiced desire to expand this much wider of an audience, which I understand, my concern is overwhelming the program and resources, thereby making it not available to those most needing it. Therefore, we are taking a limited approach and requesting it to be expanded to the Veterans Court, which sees approximately 135 veterans a year. We have and continue to have great support for this legislation. We have worked collaboratively with the stakeholders, and you should see their support on your computers. The court administrative judges and staff have been amazing. The Judicial Conference continues to be helpful and supportive, along with their wonderful partners in the state's attorney's office. Not to mention all the amazing partners with numerously highly trained dogs, and of course the trainers and owners. So a summary of the bill, it simply expands the existing Child Courthouse Dog Program to include Veterans Court, which entails both circuit and district courts. The program remains voluntarily for the courts, and it will provide veterans comfort and allow access to these highly trained dogs for court proceedings and other related court process and meetings. There are two small amendments provided to the committee. One, it changes the term Air Forces to Uniformed Services, as the Armed Forces does not include NOAA and USPH. which the term uniform services does include. The Second Amendment just is a minor change to update the modified program title Courthouse Therapy Program just to be Court Dog Program, since there are not only therapy dogs, but also facility dogs. Again, I wanted to publicly thank all those involved for their efforts, support, and positive impact for Marylanders, and I ask for your favorable consideration of this legislation as amended. Thank you.
Thank you, Senator Simonaire, and thank you for all of your previous work supporting our veterans in the state. So thank you for all of that. And we'll now move on to, I see that it was Judge Clevens. Judge, there you are.
Yes, Mr. Chairperson, Vice Chair, members of the committee, I'm Glenn Clavens. I'm the Administrative Judge of the Circuit Court for Anne Arundel County, and I'm also Chair of the Judicial Council's Court Operations Committee. I represent the Maryland judiciary today in support of the Court Dog Program bill. The Anne Arundel County Circuit Court was one of the jurisdictions to pilot this program originally, which was designed to assist and support children in the unfamiliar and somewhat frightening environment of a court. Ours has been a modest program staffed by volunteer handlers and animals, but it has been most helpful to children witnesses and to our judges and magistrates. Frankly, several of our judges even seem more relaxed with the dogs around. But we always envisioned that the program had more application beyond children. To expand the program to veterans treatment courts is a logical and needed next step. Maryland currently has such veterans problem-solving courts in 7 of our district courts and 1 circuit court. Additional veterans courts are desired and are being discussed throughout the state. Dog therapy in a veterans court is, quite frankly, a perfect fit. Individuals who come before these courts often suffer from co-occurring conditions involving mental health and substance abuse problems. These conditions also often exacerbate anxiety and other emotional upsets that coming to court may cause. Having another resource, such as a dog program in the veterans courts, increases our efficiency and, more importantly, our effectiveness to provide real change in veterans' lives in order to move them towards better integration into our communities, maintaining families, and promoting public safety. The Maryland judiciary is pleased to support the expansion of the Court Dog Program through this bill. Thank you, and I'm happy to take any questions.
All right, thank you, Judge. Next, we have Mr. Smith. How are you? Good to see you.
Doing just fine, Chairman Smith. It's great to see so many of my friends in Annapolis, if only over a camera.
There you go. Are you? Here's a $64,000 question. Are you in Williamsburg right now?
I am in Williamsburg until I can get my wife to release me. I was abducted against my will when she transferred down here, but I still got a business up there, a house up there, and I'm kind of torn at the moment, but making the best of all of it.
You got to stop on my alma mater while you're down there.
Are you a William and Mary guy?
I am.
They have their School of Law has a new program on veterans advocacy, focusing on a lot on mental health. I just started that yesterday, so in a way, I'm connected to your alma mater, I guess.
There you go. We'll talk more offline. That's great.
Indeed.
Floor is yours.
Good afternoon, Chairman Smith and members of the Senate Judicial Proceedings Committee. My name is Brian Smith. I'm a Gulf War combat veteran, and I'm here today to offer my support for Senate Bill 7. Appearing before a judge in a criminal case can be a traumatic experience for anyone, but the process can be even more difficult for veterans, many of whom suffer from PTSD. The Substance Abuse and Mental Health Services Administration estimates that 1 in 6 Iraq and Afghanistan veterans are alcohol or drug addicted or both, and 1 in 5 suffers from PTSD or significant mental anguish. It's shocking. That represents somewhere between 450 to 540,000 of our post 9/11 veterans. In total, there are over 700,000 veterans of all service periods currently caught up in the criminal justice system. Tragically, that number is growing at an alarming rate as veterans are being arrested for charges directly related to trauma, substance abuse, or mental illness. We have seen the impact that veterans treatment courts have in helping veterans caught up in the criminal justice system, standing between the veteran and a felony conviction, incarceration, or worse, ensuring that when the returning service members are arrested because of a substance abuse or mental health disorder, they receive the structure, treatment, and mentoring they need to get their lives back on track. So how can we improve the Veterans Treatment Court's outcomes for our justice-involved veterans? Add a dog, a therapy dog, or a facility dog. Senate Bill 7 expands the application of the current court dog program to offer therapy or facility dog support to veterans appearing in participating county veterans treatment courts. While not considered service dogs, therapy dogs and facility dogs receive training, but have a completely different type of job from service dogs. Their responsibilities are to provide psychological or physiological support to individuals other than their handlers. These dogs have stable temperaments and friendly, easygoing personalities. Therapy dogs and facility dogs are proven performers in providing a calming influence in stressful situations. These professionally trained dogs are suitable for providing quiet companionship to vulnerable individuals in legal settings without causing any disruption of the proceedings. These working dogs are specially chosen because of their calm demeanor and ability to work in a high-stress environment, thereby decreasing the risk of creating legal issues. There is good reason to believe that providing a friendly canine presence during Veterans Treatment Court proceedings would improve the outcomes for our justice-involved veterans. Our veterans were there when our country called. We should be there for them in their time of need. Give a veteran a second chance and give a dog a job. I respectfully request a favorable report for Senate Bill 7. Thank you.
All right, with Mr. Smith's testimony, that rounds out the panel. Any questions from the committee? All right, seeing none, Senator Simon Ayer, thank you very much. Judge, Mr. Smith, see you all later. Thank you so much for taking the time. And with that, that concludes the hearing for Senate Bill 7. We'll now move on to Senator Patterson. Is Senator Patterson here? There you are. Senator Patterson with Senate Bill 151.
Okay, am I coming through?
Loud and clear.
All right, wonderful, wonderful. Thank you, Mr. Chair and committee members. I do appreciate the opportunity to introduce Senate Bill 151, which seeks to amend the state constitution such that all Marylanders can live and have a right to a healthy environment. And just for a preface, let me just quickly read a line or two of how the United States Environmental Protection Agencies define environmental justice. Thus, the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, and enforcement of environmental laws, regulation, and policies. Therefore, Mr. Chair and committee members, I think the time has fully come to recognize that the environment in which we live and in part produce is not the type of environment that we would like to leave for the next generation that come after us. And so I do not believe that we can continue to sit and rest on our laurels and wait on others to do what needs to be done. We need to do it, and we need to do it now. One thing that COVID-19 brought to light is simply that a vast amount of disparity exists, especially for Black and brown, Marylanders, and poor communities. People of color and low-income population are more likely to live near industrial sites, hazardous waste sites, which release harmful chemicals back into the environment. As a member of the President of the Senate work group. We spent several hours going over environmental conditions that directly impact the lives of many of us, particularly the impact that it had on Black and brown and poor communities. I simply believe that a state that ranks #1 in wealth can do better by its people. And I ask that you fully consider this request, Mr. Chair, and provide a favorable response to this bill. And I should tell you that we have 3 expert witnesses who are there and ready to continue this dialogue in support of Senate Bill 151. And the lead sponsor or the lead witness would be that of Mr. Barry Hill. And again, I thank you and I ask for your full support and cooperation in this long overdue legislation. Thank you very much. Mr. Chair, if I have to admit, I'm working on another bill. I'm running late to go to my vaccine. I have to split, but I do believe the witnesses will be ready and able to respond to questions that you might have.
Okay, well, thank you very much, Senator. I think you're also representing EHE for the next hearing as well. So I guess you'll be back, but we'll move on to your panel. So good luck with your next hearing.
Thank you.
We'll let you back in.
All right.
All right, so then we'll move on to the panel. Thank you very much, Senator. We'll move on to the Mr. Hill, Barry Hill.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Barry Hill, and I've been a longtime resident of Prince George's County and of Montgomery County. Currently, I'm an adjunct professor of law at Vermont Law School, where I've taught an environmental justice course for 25 years. I've written extensively on the topic, and I was the director of EPA's Office of Environmental Justice from 1998 to 2007. In my remarks, I would like to take this opportunity to address 4 points. First, the goal of environmental justice for all and the goal of this Environmental Rights Amendment for all are indeed synonymous. SB 151 declares that each person has the fundamental and inalienable right to a healthful environment, which includes the right to clean air, clean water, and clean land, and a stable climate. This is exactly what environmental justice community-based organizations throughout this country, as well as in Maryland, have been seeking for decades. Since approximately 100 independent research studies have demonstrated conclusively that Black and brown communities and poor communities have been disproportionately exposed to environmental harms and risks as compared to other communities. Absolutely no one can argue with that undeniable fact. The political leadership of Maryland has recognized for decades that environmental injustice was a problem in the state. That was the reason why then Governor Parrish Glendening created on January 1st, 2001, the Commission on Environmental Justice and Sustainable Communities by executive order. Subsequently, that was the reason why the General Assembly codified the commission by statute effective October 1st, 2003. In spite of the good efforts of the commission over the years, environmental injustices still continue to exist in Maryland. Recently, according to last week's Washington Post, House Speaker Adrian Jones and Senate President Pro Tem Melanie Griffith have announced legislative proposals that focus on addressing environmental injustice in the state. In light of the fact that instances of environmental injustice continue to exist in the state, a rhetorical question may be posed. Who can be against environmental justice and the notion that every Marylander has a right to clean air, clean water, and clean land, as well as a stable environment? Put another way, who can be for environmental injustice and the current situation of polluted air, contaminated water, and dirty land, and an unstable climate to continue unabated in some communities in this great state? My second point, you will note that the language regarding each person having a fundamental and inalienable right to a healthful environment is not at all new. In fact, it was lifted verbatim from Section 1301D of the Maryland Environmental Policy Act, MEPA, which was enacted into law on May 24th, 1973. We, the Maryland Campaign for Environmental Human Rights, simply added language regarding clean air, water, and land, and a stable environment to explain what a healthful environment means in actuality in 2021. Thus, the language of SB 151 is consistent with existing law. Third, SB 151 provides that the state is the trustee of the air, land, water, living, and historic resources of the state, and that those resources shall be protected, preserved, and enhanced for the benefit of all the people of the state, including for future generations. Again, this language was lifted verbatim from Section 1-302C of MEPA. Thus, the language of SB 151 is consistent with existing law. But just in case one might argue that we don't need SB 151 if this lofty language of rights and trusteeship are already in MEPA, that would be wrong. Unfortunately, MEPA has sat moribund since 1973. No implementing regulations have been issued by the Department of the Environment. MEPA has been a neglected statute, a forgotten statute. More importantly, MEPA is not even close to being as powerful as a proposed constitutional amendment, which would be the preeminent statement of environmental law and policy in the state. Fourth, SB 151 would provide the state, counties, and municipalities more tools in the toolbox to more effectively protect the natural resources and the environment and health of all Marylanders. For example, in the much talked about Pennsylvania case, Robinson Township, remember, it was 9 municipalities that sued the Commonwealth since the new state fracking law infringed on their ability to protect the environment and to abide by the Environmental Rights Amendment in the state constitution. In conclusion, thank you very much for your consideration of our request and your attention.
All right, thank you very much, Mr. Hill. And next we will have Ms. Bryant.
Hello.
How are you?
Good. How are you?
Good, good. Floor is yours.
Thank you. Mr. Chairman and honorable members of the committees, I am Jayla Bryant, a senior at West Nottingham Academy, a boarding school just north of Baltimore, and a lifelong resident of Maryland. I am testifying in favor of Senate Bill 151, the Constitutional Amendment for Environmental Rights. As I prepared to speak to you all today, my mind raced a mile a minute, thinking of all the things I could say to show you the importance of this amendment for me and the entire state of Maryland. I could simply tell you how I have never gone a year without eating blue crabs with my family, going fishing with my father and brothers, and spending long days in downtown Annapolis with friends, regardless of the season. But I also believe that details matter. I love the way the sun hits the bay as it dips below the horizon, watching squirrels run around unaware of my presence, coming back to my dorm after a hike with sneakers caked in mud, and even laughter filling the air as people enjoy local fairs. In Maryland, there are thousands of high school students like me preparing to enter the next chapter of our lives, college. Whether in state or not, and whether we know how much of an impact growing up here has had on our outlook on life, we all know this is home. I know I'm speaking for many when I say we are scared. We are scared that one day our home will no longer recognize the sun dipping below the horizon or sneakers caked in mud, enjoy long days downtown or at local fishing spots, or even watch squirrels run around freely. These are the things I fear not only for myself, but for my 2 younger brothers, Justin and Josh, who represent a future that goes beyond what we all say and do today. With all these things on my mind, I say the following. Maryland is home, a place where I know I will be loved and welcomed until the day I take my final breath. I have lived here my entire life and formed close bonds with not only its people, but its environment. I am a child of Maryland who only wants the best for her state, like so many others, including yourselves. As you come to make your decisions, I implore you to think of the ones you love, your memories, and the future of this very state. Thank you.
Excellent. Thank you very much. Next, we will have Mr. DePascal. There you are.
Thank you, Mr. Chairman. Appreciate it. Members of the committee, my name is Nick DePasquale, and I've spent 35 years of my professional life working in state environmental agencies and working in the private sector for consulting firm on environmental issues and also working with non-governmental organizations on a variety of environmental issues. My last tour of service was as director of the Chesapeake Bay Program, US EPA in Annapolis, where I served for 6.5 years. I also spent time working as a deputy secretary in Pennsylvania. And the reason I raise that is because one of the 2 states that has an environmental rights amendment is Pennsylvania, one of the first and one that I'll be referring to in my testimony. Today, I'm testifying on behalf of the Maryland Campaign for Environmental Human Rights, upon whose advisory circle I serve. There are a couple of points that I'd like to make beyond my written testimony. And to start with, I'd like to talk about the concerns that some have that having an environmental rights amendment is going to end up in significant amount of litigation that's going to require additional staff resources, attorneys and the like. In the 2 states that currently have an environmental rights amendment, Pennsylvania and Montana, that hasn't actually turned out to be the case. There hasn't been an avalanche of litigation because of the environmental rights amendment. And in fact, you could actually make an argument that having that amendment reduces litigation costs because it provides for not only environmental human rights for individuals, but also that state officials take on a trusteeship role, public trusteeship role in protecting and preserving the resources of the state. And in doing so, it actually puts them in a position of having to anticipate what the environmental impacts might be from any given activity. So in planning and trying to mitigate those impacts, because of the Environmental Rights Amendment, you'd actually reduce the amount of litigation that might occur had you not had that rights amendment in place. So it really turns out to be cost avoidance. The next point I wanted to make is that, and I think Mr. Hill alluded to it, the environmental statutes as they're constructed both at the federal and the state level grew up over time being media regulations. In other words, we regulated air resources, we regulated water resources separately. We had separate laws for dealing with contaminated land, how to handle chemicals. And you may have heard the term stovepiping. So these environmental laws actually are stovepiped, and there's not a lot of communication that occurs among those different programs. Most of the federal programs are managed by the state through a delegation process, so they mirror the federal program. And there are gaps where one law lets off, another law doesn't just pick up automatically. And what an environmental rights amendment would do is fill those gaps. I appreciate your consideration, favorable consideration of the Environmental Rights Amendment. Thank you very much for allowing me to testify today. I'd be happy to answer any questions.
Excellent. Thank you very much for your testimony. We'll now move on to Ms. Jessica Clark, Robin Jessica Clark. I see Clark here
in the waiting room.
We'll move on to Mr. Ferguson, Colby Ferguson.
Thank you, Mr. Chair, members of the committee. Colby Ferguson here on behalf of Maryland Farm Bureau. And we are here in opposition of Senate Bill 151. And it's not that we're in opposition of any of the discussions of environmental justice or any of those kinds of things. It's that this bill is very all-encompassing and has a very wide scope and coverage, and really goes even farther and well farther than what even Pennsylvania's program does. And really, when it gets down to it, agriculture uses, because of the way bills have been passed and laws have been placed and regulations are in place, agriculture is required to get permits from the state to do different things. And then some examples are obviously CAFOs, but also irrigation, hemp, getting new buildings, composting, commercial fishing, aquaculture permits, just different things that we use through regulation to make sure we follow the laws and the rules and both federal guidelines as well as state. And when you open this up, this would basically say if somebody has concerns with one of our permits, that now they would have standing to be able to intervene, whether they live if this is an Eastern Shore issue and somebody lives in Western Maryland, they can still intervene even though they're not in that part of the state. So our worry is that this thing really opens up, and honestly, I could see agriculture being both a plaintiff as well as a defendant. As we can see, we're the tip of the sword when it comes to climate change reactions and impacts with the weather. And we can see that there's opportunities that this would all open up, that if we see that issues within an urban city are not being taken care of, it's unduly messing up our environment, and then we could sue. And so this, to me, is a Pandora's box with a lot of unintended consequences that I don't really think have been fully vetted. So with that, we would respectfully request a unfavorable report on SB 151.
All right, thank you very much, Mr. Ferguson. We'll now move on to Mr. Powell.
Thank you, Mr. Chairman, and I'm here on behalf of NAIOP, the Commercial Real Estate Development Association, and the Maryland Home Builders in opposition to this bill. No one opposes clean environment. Nobody imposes everyone having the right to environmental justice. What we oppose is the litigation that will result. This bill goes beyond what Pennsylvania has. And the prior testimony is right, that only Pennsylvania and Montana even have anything like this. And this bill very carefully goes beyond that. Carefully, because in Pennsylvania, to limit the limitless litigation that this bill could provide, this amendment could provide, they did some balancing. But this bill eliminates that. Says anybody can bring a suit for action or inaction if they believe it has impacted the climate, the environment, scenic or historic values. No limitations on who they sue. If the General Assembly, for example, fails to pass a climate change bill, or in deciding to ban a particular chemical, they decide to allow the farmers an exception to use it in particular situations, that would be an inaction in which someone could sue. Our concern are the amount of litigation that would result if this bill, this amendment, constitutional amendment, was passed. It's one of these causes that sounds very good. Everybody wants a clean environment, but what is the mechanism that this amendment provides? It provides for litigation by anyone against any public party, any county, any state, any municipality. So for that reason, we ask for an unfavorable report on this amendment.
Thank you, Mr. Powell. Next, we'll have Mr. Sanderson, who has a Hollywood caliber away picture. You know, you're probably winning the room raider competition right now for the mood lighting. There you go. Can we hear? You got it?
That's what I'm looking for, Mr. Chair. Thanks very much. Thank you all. Good afternoon, Mr. Chair, members of the committee. I'm Michael Sanderson with the Maryland Association of Counties. We've submitted a written testimony also, and I think our concerns with the bill are, once again, like you've heard from other witnesses, about breadth and the practical application, not the spirit. In the interest of trying to say something that won't just step on toes that you've already heard or we'll hear from other witnesses, I'll make one additional observation about Pennsylvania, and this is sort of a structure of government matter that I think is important for you all as the state legislature who hosts the deliberative policy process for all stakeholders, that we're all able to participate in your process. And here in Maryland, it's the General Assembly who is really the ultimate arbiter of statewide environmental policy. With the amendment that's not even as expansive as what's before you proposed for Maryland, but up above us in the Commonwealth of Pennsylvania, the true arbiter of environmental policy is now the courts. And stakeholders now need to lawyer up and file their briefs and participate in what should be an open policy process but instead they go to the Pennsylvania courts to try and argue that something is within or is outside the scope of their equivalent Green Amendment that's enshrined in the Pennsylvania state constitution. I think what that does is it denies stakeholders, residents, the people who feel marginalized by process today might be even more so if you end up with the real decisions being made only in court, only by those who can afford what is complicated and expensive access to those avenues. Having these issues hashed out before you and the General Assembly is a preferred and more transparent way to do public policy. That's one more argument, I think, against going as far as this very broad and expansive bill. Thank you very much.
All right, thank you very much. And last, we will have Ms. Bailey. Angelica, are you there? There you are.
I am here, yes, thank you. Good afternoon, Angelica Bailey, Director of Government Affairs with the Maryland Municipal League, respectfully testifying in opposition to Senate Bill 151. I'd echo the concerns of the other opponents. Expanding the opportunity for anyone to file a lawsuit against a local government for something like degradation of the state's natural resources, it's just too broad and open to interpretation and really creates an impossible standard for governments to meet. How can we define clean water? How do we define clean air? At what point is it clean enough? This is especially concerning when our resources are degraded by situations out of our control. If polluted air or water flows into Maryland from another state, it would be unfair to hold the local government responsible for another state's bad actions, but that's what this bill would allow. And establishing this right really opens the door to litigation that honestly our local governments simply can't afford to defend, especially excuse me, given our current situation and our current challenges. A potential floodgate of litigation is concerning, but even a trickle would rob municipalities of valuable resources that they could otherwise spend on constituent services. Just like a lot of the other opponents said, you'll never hear MML say that protecting the environment is not important. Climate change is one of our 2 strategic initiatives this year. We're even asking for a seat on the Commission on Environmental Justice and Sustainable Communities this session to partner with the state and communities to address environmental justice issues. But this bill is just too broad, and even though it's well-intentioned, it would have significant consequences for our membership. So we admire the sponsor's goals, but we respectfully request an unfavorable report.
Fantastic, Ms. Bailey. So that rounds out the panel. We now have a few questions from the committee. First up is Senator West.
Thank you, Mr. Chair. I think some of the witnesses have responded to questions I otherwise would have asked, but let me pose another question. Why don't I, since the sponsor of the bill is not here apparently, how about Mr. Di Pasquale? Let me ask it to you because you seem to be knowledgeable about these amendments or these constitutional amendments. So let me give you a hypo. So Northern Calvert County has a tract of land which is partially wooded and partially fields, decides to build a new high school. The high school would mean cutting down the trees and covering over at least part of the fields with asphalt, which means stormwater management has to be installed. Some citizens file suit against the county for its new school, arguing that in the language of the bill, it would cause unreasonable diminution of or degradation to the state's natural resources. You're cutting down trees, you're putting asphalt where there's currently farmland. That would go into the courts and wind its way through the courts. If the Court of Appeals were to agree with the plaintiffs in that case and issue an injunction stopping Calvert County from building their new school, would the General Assembly have any power to pass a bill overturning the decision of the Maryland Court of Appeals? Or because it was a constitutional decision interpreting constitutional law, would the General Assembly's hands be tied and it would have no recourse?
Great question, and it's always difficult to respond to hypotheticals because each circumstance obviously has a set of facts associated with it. But the history has been, and I'm not an attorney, let me just say that right from the get-go. So these issues in terms of legal aspects would probably be better directed to attorneys. But the history, I think, has been that the courts have been relatively conservative in making these determinations. And like a lot of other civil rights and right of free speech and religion, It's an evolution that takes place over a period of time. But the courts have been very conservative in their rulings for the most part. In the one case that was cited by Mr. Hill earlier, actually was a set of municipalities that brought a case. I think they look to existing statutes to see, to the extent that they cover environmental and health issues in a community, and focus more on where there might be a gap or where there actually might be a law that's passed that's determined to be unconstitutional.
So you seem to think that the Maryland Court of Appeals would be conservative. That depends on the judges on the Maryland Court of Appeals, correct?
Right.
You've got some liberal judges, they're going to be more liberal. If more conservative judges will be more conservative. Let's go with my hypo for a moment. Let's assume that because of the current configuration of the court decides that building that high school would violate this constitutional amendment. If that were to happen, and the decision were to be based on the constitutional amendment, is it not correct the General Assembly's hands would be tied because Constitution trumps statutes? So there'd be nothing that we could do as the General Assembly to try to overturn that constitutional decision of the Maryland Court of Appeals. Don't you agree with that?
That is correct.
Okay, thank you.
All right, thank you, Senator West. I'm having bad memories from law exam, from bar exam, hypos. All right, seeing no hands raised, no further questions from the committee. Thank you all very much. And with that, that'll conclude the hearing and the testimony for Senate Bill 151. We'll now move on to Senator Elfreth, Senate Bill 173. Senator Elfreth.
Thank you so much. Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. Senator Sarah Elfreth representing District 30. Here to present Senate Bill 173, a bill that's familiar to this committee. It's been before you the last number of years, been introduced for 6 years. This seeks to correct Maryland's current law that allows children to marry at age 15. It does a number of things. It sets an age floor of 17 to marry and creates a judicial review process for the 17-year-olds who are petitioning to marry. It also grants emancipation to any 17-year-old that is given the authorization to marry. I've had the privilege of working on this bill for the last 2 years. And when I take it back to my district, I haven't met a single person in the real world who thinks 15 is an acceptable age. I know I've been working and speaking with members of this committee. I don't think anybody here agrees that 15 is the reasonable age. I think this bill represents a great compromise between a lot of folks who want 18 and our current law, unacceptable law that is 15. You've seen it in many iterations, but I think you're going to see a different hearing today than in years past. We've worked with stakeholders from across the spectrum on this bill to get it to a place that I think is reasonable for everybody involved and represents the strongest public policy possible. This is a highly emotional issue, and the members of the committee will remember last year, Sasha Taylor, a survivor of a coerced child marriage, spoke. Sasha's unable to be here today, but she did submit written testimony that I would ask everybody to take just a moment to read and remember her story from last year and how unacceptable child marriage is. As I mentioned, current law allows for children as young as 15 to get married with parental consent and if they are pregnant. It then allows 16-year-olds to marry if they have parental consent or if they're parenting. Our current law does not allow for the clerk of a court, and you'll hear from one today, actually my clerk of the court, if they suspect, to intervene if they suspect a parent or partner is coercing that minor. You'll also hear from a priest today to talk from a religious perspective about how the church treats marriage. But nothing under Maryland law prohibits a pregnant 15-year-old from Delaware, a state that has set a minimum age to marriage at 18, from being taken to Maryland to marry a man 22 years her senior. This is not as we just heard, a hypo. This is, and it didn't happen in 1953. It happened here in Maryland in 2018. It's not a small problem. 3,500 minors were married in Maryland between 2000 and 2018. 85% of those minors were women. In 2016, 25 Maryland children married someone in their 20s and 6 married someone in their 30s. We all know we tend to be data-driven policymakers. The data is clear on this. child marriages lead to significantly harmful outcomes for everyone involved. The vast majority of girls who marry before the age of 18 face the following lifelong challenges. Marrying before 18 doubles the chance of living in poverty. Those who marry before 18 are 50% more likely to drop out of high school. Marrying before 18 triples the likelihood of domestic violence. And those who marry before 18 are 70 to 80% more likely to get divorced. Other states have recognized the importance of protecting children. Our surrounding states have stepped up: Delaware, Virginia, New Jersey, Pennsylvania, all of which have taken strides to increase the age of marriage. Delaware and New Jersey have raised the age to 18 with no exceptions. Again, Senate Bill 173 does four main things. It raises the age to 17 with no exceptions. It provides for no more than a 4-year age difference between potential partners. It creates this judicial review process that I mentioned before, appoints an attorney, and allows for the court to do an independent determination and to ensure that the relationship is in fact voluntary and free from coercion, and that the 17-year-old seeking to marry is mature and capable of self-sufficiency. And lastly, it ensures that a 17-year-old who is granted this petition from the court would also be emancipated. This piece, we've kind of had years, we've had an emancipation bill and a marriage bill. We try to stay in one lane this year and give you something that I think is reasonable, which is the 17-child marriage with emancipation, to ensure that those 17-year-olds can enter a contract, sign for a lease in an apartment. Most importantly, petition for their own divorce if that is something they need to do. Again, this is, I think, the best piece of policy we can bring you. We did major work on this bill after this committee heard it last year. You're going to not see some people at the table today that we've been working with in the background to get everybody to a good place. I appreciate the committee's time. I appreciate the members of the committee. I've spoken to most of you in the last 24 hours who have really approached this from a solutions-oriented position to try to make this the best public policy possible. With that, Mr. Chair, I ask that the committee grant a favorable report to Senate Bill 173. Thank you.
Excellent. Thank you, Senator Elfrath, and thank you for your tenacious efforts over the last several sessions. Really appreciated. So we will now move on to Ms. Swegman. You are up first.
Thank you, Chair Smith and honorable members of the committee. My name is Casey Swegman, and I'm the Forced Marriage Initiative Project Manager at the Tahirih Justice Center, and I speak today in strong support of Senate Bill 173. The Tahirih Justice Center is a legal services advocacy organization with offices in Maryland and other states, and since 1997, we have served women and girls who face domestic violence, sexual assault, human trafficking, forced and child marriage. Tahirih has worked on hundreds of forced marriage cases nationwide, including many right here in Maryland. On a personal note, I'm also a daughter of Maryland. I grew up in Burtonsville, and so this bill is near and dear to my heart, not just because of my work and the survivors I serve, but because this is my home. Now, many of you have heard from us before, and you've heard the statistics. Nearly 3,500 minors married in Maryland between 2000 and 2018, most of them girls married to adult men, many of whom were significantly older. Since 2016, every year since this legislation has failed to pass, the data shows more vulnerable minors are married in the state of Maryland with no oversight. Many are now brought from neighboring states with tougher laws. And speaking of neighboring states, at this point, only West Virginia has less protective minimum marriage age laws. Delaware, Pennsylvania, and New Jersey all set the age of marriage at 18 without exceptions. In New York, Ohio, Kentucky, and especially tough for me, Virginia, you have to be 18 or emancipated to marry. In all, 25 states have taken steps to end or limit child marriage since 2016. Many of you have also heard about the heartbreaking dynamics we see in our cases, which often involves insidious forms of coercion, not only physical violence, but extreme psychological abuse and threats. When that comes from a parent or another loved one, it can work just like a gun to the head for a teen who's still very dependent, both emotionally and practically. And you have heard from survivors. Skylar, who year after year shared her story of child abuse, of being forced by her mother to marry a man twice her age when she was just 16, right here in the state of Maryland, and the struggle she faced trying to get help and get safe when she was still a child. And as Senator Elfrath mentioned earlier, Sasha, who last year testified in front of this very committee about her own experience of child abuse and forced marriage when she was just a sophomore in high school, forced to marry a man who was 7 years her senior. Sasha submitted written testimony this year, as was mentioned, but she was unable to testify in person because she's recovering from surgery to finally address injuries sustained when she was a child. In her testimony, Sasha writes that she never got to have her experiences like all other young adults could. Her childhood was taken away from her. At 15, she was groomed to be a daughter-in-law and to think of the kids she was supposed to have, to stay home and to be a wife. And you have heard about the devastating lifelong consequences of child marriage, even if by choice, as Senator Elfreth mentioned. The Tahereh Justice Center believes firmly that setting the minimum age of marriage at 18 without exceptions is the strongest and most straightforward way to protect children from the harms of child marriage. However, we speak today in support of Senate Bill 173, which makes a limited exception only for court-emancipated 17-year-olds, as this bill is a strong step in the right direction. Moreover, this bill represents 6 years of thoughtful and lengthy dialogue, resulting in powerful bipartisan compromise. It has been a long road, and some of you, Chair Smith, I'm looking at you in particular, have been on this journey with us since the beginning. Without question, crossing the threshold into legal adulthood can make a critical difference to the ability of individuals to protect themselves. In Maryland, unemancipated minors face serious obstacles to accessing safety. Runaway youth can be taken into custody without a warrant. Shelters may have to contact parents within 24 hours or petition for legal custody on their own. Friends who offer a place to stay risk being sued for interfering with parental rights or charged with harboring a runaway. And contracts with minors are not legally binding, and adults from lawyers to landlords tend to avoid them. And the marriage of a minor, while it relieves the minor's parents of support obligations, it does not clearly grant the minor the rights of an adult. So Senate Bill 173 incorporates a lot of best practices from model statutes on emancipation, as well as new state laws, 7 in total, relating to the emancipation to the minimum marriage age. Among Senate Bill 173's key features are, as Elfreth mentioned, appointing counsel to advocate for the minor, requiring civil and criminal background checks, allowing no more than 4 years age difference, residency requirement for the minor, a waiting period of 15 days between emancipation and marriage license, enumerating the legal rights and responsibilities that emancipation confers, sharing critical resources like domestic violence and human trafficking hotlines and legal aid information, and crucially, eliminating the harmful parental consent exception, which often conceals parental coercion, and the pregnancy exception, which often ignores evidence of rape. And we know that this kind of law is effective at drastically reducing child marriage. States like Texas, Virginia, and Kentucky that have implemented similar emancipation exceptions have seen about a 90% reduction in child marriage. Let me reiterate that Tahereh strongly believes that the best way to address this problem is to set the legal marriage age at 18 without exception. But I am not here to let perfect be the enemy of the good. Maryland's children are depending on us, and we believe this bill will go a long way to protecting them from exploitation and abuse that can occur under the guise of marriage. And I thank Senators Elfreth and Hedelman for bringing this measure forward, and I would be glad to take any questions after the rest of the panel presents.
Excellent. Thank you, Ms. Swegman. And I'm sure we'll have plenty of questions from the committee once the panel concludes. Next, if we have Mr. Witt, I saw you over there. Mr. Witt, you're up.
Can you hear me?
We can, loud and clear.
Wonderful. Honorable Chair and Vice Chair and members of the committee, my name is Reginald Witt, and on behalf of the Maryland Catholic Conference, I'm speaking in support of Senate Bill 173. Teenage women are frequently, if not usually, dependent, physically, economically, and emotionally on older adults. And this is usually the case because they're still teenagers. They're not adults, with neither the age, nor the means, nor the experience to responsibly make life-altering decisions, most especially the decision to marry and to enter a partnership for the whole of one's life with a single spouse, to voluntarily entrust one's health, one's fate, one's lifetime to a single mate, a mate of one's own mature and graced choosing. Now, Senator Elfreth and Ms. Swegman have already cataloged for you the devastating lifelong consequences of marriages involving minors. Senate Bill 173 is a significant effort toward preventing coercion or exploitation of young women through marriages imposed on them against their will. What's more, This bill is an important means toward preventing young people from imprudently, mistakenly engaging in one of, if not the most serious and important commitments a human person can make, and avoiding the negative results that the collapse of that marriage would likely have on both of the partners and any of their children. And so again, on behalf of the Maryland Catholic Conference, we're expressing our strong support for Senate Bill 173. Thank you.
All right, thank you very much, Mr. Witt. Next, Mr. Poyer, good to see you again. You're up next.
Thank you, Chair Smith and Vice Chair Waldstreicher. And thank you to the members of the committee for this opportunity to testify in support of SB 173. For the record, my name is Scott Poyer, and I am the Clerk of the Circuit Court for Anne Arundel County. My testimony today is not on behalf of the Maryland Judiciary. I am here representing myself as the elected official who is responsible for issuing marriage licenses and performing marriage ceremonies in Anne Arundel County. I am in favor of SB 173 because I do not feel the current laws provide enough protection for minors who may find themselves being pressured into marriage. I believe there's a relative lack of safeguards for minors under the current system. While it takes two to get married, only one applicant needs to make the application, and we may never see the other applicant. We only see both if our office performs the marriage ceremony. If an outside officiant performs this ceremony, we won't see them. We just receive a green piece of paper telling us that the marriage has taken place. And these days, pretty much anyone can be ordained to perform marriage ceremonies in Maryland. It takes about 5 to 10 minutes, costs about $29.99 to go online to be ordained. So under our current system, one spouse can fill out the application, get pretty much anyone to perform the ceremony, and they have a valid Maryland marriage license recognized in all 50 states. And no one else will have ever seen the minor who was involved to determine if that minor was under duress or was marrying against their will. I support the proposed legislation because it provides better safeguards for minors by raising the minimum marriage age to 17, requiring an attorney to be appointed to represent the minor, and also requiring a court hearing for each case. Thank you for the opportunity to comment on this bill.
Thank you, Mr. Poyer. Good to see you again. Final witness for the proponents, Ms. Casemeyer. There you go.
Oh, thank you. So excuse me a second. I want to make sure everything else is quiet. So sorry, my apologies. This is Pam Casemeyer here on behalf of the Maryland Association of, or the Maryland chapter of the Academy of Pediatrics. From the clinical side of this issue, the Academy of Pediatrics is very strongly in support. You've heard very compelling testimony today on all of the respective issues that arise and the negative implications of early marriage. I can't say strongly enough on behalf of the pediatric community how all of the negative implications, consequences, outcomes that have been clearly documented over the years for minors and marriage. The bill is structured. You've been working on it for a number of years. The Academy's been participating. It seems to me that you've now you've gotten to a point where it recognizes a number of different perspectives, but still provides some extremely important protections for young women. And I don't want to take a lot more of your time. I just wanted you to know that from the clinical professional side of things, they cannot overstate how well documented the negative outcomes and implications from childhood marriage are on young women, not only as they're still young, but throughout life and all of the challenges that it poses. So we strongly urge a favorable report on this legislation and are happy to answer any questions you may have.
Excellent. Thank you, Ms. Casemeyer. And now we'll move on to one witness for the opposition, Ms. Rice.
Thank you. I am Frady Reese. I'm a forced marriage survivor and the founder and executive director of Unchained at Last. We at Unchained lead a national movement as states across the US are moving to end child marriage as part of a global movement to end this human rights abuse by year 2030. But with SB 173, Maryland, instead of joining the rest of the world, is clinging to child marriage as a so-called compromise, with some local advocates who have insisted for 6 years now, contrary to common sense, common decency, and all available research, that ending all marriage before 18 would somehow harm children. I have submitted written testimony in opposition to SB 173, and I ask that you read it carefully along with all the footnotes. Everything in it is backed up by evidence and data. In it, I prove that marriage at 17 is a human rights abuse that destroys nearly every aspect of a 17-year-old girl's life. Marriage at 17 brings no benefit. We can help teens who are in an abusive home without subjecting them to a human rights abuse or encouraging them to enter into a sexual relationship and a serious contract. I show in my written testimony that a 17-year-old, no matter how mature, does not have the rights of adulthood and therefore can easily be subjected to the horror that I myself endured, a forced marriage. And I explained that emancipation upon marriage does not solve this problem because it grants some rights of adulthood too late, only after a 17-year-old has endured the trauma of a forced marriage. And I explained that the judicial review process does not prevent forced child marriage. I can tell you this because many other states have tried this approach. And we at Unchained have worked with many survivors who were forced into a child marriage in a state that has a judicial review process. And not a single survivor that we have worked with was ever honest with the court about their situation. They were too scared about what their parents would do to them when they got back home. I point out also that 63% of the children who marry in Maryland are age 17. We cannot end a human rights abuse if we're failing to protect 63% of those impacted by this abuse. We all agree that child marriage is a problem. The solution is not SB 173. The solution is simple, common sense legislation that ends all marriage before 18, no exceptions. And I'm also happy to answer any questions.
Okay, thank you very much, Ms. Rice. Sounds like your testimony will be favorable with amendments. I don't know, but looking around the committee room, any questions for the panel or the witnesses? Okay, Senator Carter. Sorry. Are you there?
Thank you, Mr. Chair. So my question is for the sponsor, Senator Elfreth, or anyone that'd like to answer. Recently, a national organization did a state-to-state survey of children and who are the greatest champions for children's human rights and what states are the greatest offender of children's human rights. And it turns out that they found that Maryland was 50 of 50 states, but not because of this issue, but because we automatically charge children as adults in the criminal justice system as early as the age of 14. And so my problem with this bill, it has been and continues to be that as a state, we need to set a bright line for when someone is a child and when they're not. And the very children that you need to save from marriage, and I say save in quotes, from marriage, are the very children that could be automatically charged as adults, serve their entire life as adults. And in Maryland, we're behind every other state in the Supreme Court decision that we have to give them an opportunity for review if they're sentenced to life. And so while I empathize with your position, the problem is that one, there isn't an epidemic in Maryland of children getting into forced marriage, but there is a huge problem, maybe not to epidemic level, of children being mistreated, abused, tortured in segregated confinement in the criminal justice system. And you know, our justice system in Maryland, because we are the legislators, so we made this law, we make these laws, says that, hey, as early as 14, these very children that you seek to save from marriage, you can spend your life in prison with no opportunity for review. And so I guess my question is, how do you reconcile that with this? And I'm not saying that you can't do one right thing if there is another, but I believe that both must happen. It's like freedom for everybody or freedom for nobody. It's kind of how I'm saying.
I think we're on the path of doing both and, Senator Carter, but let Senator Alfred.
We'll see.
Very good. Thank you. Sorry, I was trying to unmute. Well, thank you, Senator Carter. And I want to thank you for the conversations you and I have had on this, and I continue to look forward to those in your work on juvenile justice reform. That I couldn't agree with you more is in dire need of our energy and this committee's energy. And I'm with you. I will be with you on that. I just also want to your point, I also want to get this across the finish line as well. So I look forward to working with you and every member of this committee and being in your corner in making sure that we reform our juvenile justice system to make sure that it is fair for the children of Maryland.
Thank you. In any of the testimony provided, is there actual data on the number of children under the age of 17 or 18 getting married in recent years? I know you said that it was on the rise, but just can you point to it in your testimony so I can go over it later?
Yes, and I have the number here at, and Casey can please correct me if I have it from up until 2018. I don't have it broken down by 15, 16, or 17, but it's 3,500 minors between 2000 and 2018. And again, 85% of those minors were women. Casey, do you have any in greater detail, or we can get it to Senator Carter after?
From 2018 to 2020, there were 3,500 minors got married?
2000 to 2018.
Oh, over 18 years.
Over 18 years.
All right.
And we do have the data from 2019, I believe. And while each year we see some small reductions in the number of marriages in the state of Maryland, actually year to year since 2016, we have seen an increase every year in minors being brought from out of state, in particular Virginia, to the state of Maryland to be married. And the breakdown of data is all in everyone's written testimony with footnotes.
Well, I won't belabor this, but I will say also that I understand that times have changed. It's my understanding that my great-grandmother and grandmother got married at ages 14 and 15 respectively. They wound up, raising successful children. To my knowledge, they never felt that they were trapped, forced. I mean, at that time, many women were trapped. It wasn't just about marriage. In fact, marriage might have been somewhat of a release. My significant other's parents got married at ages of 14 and 16. He's now 58 years old and he has 4 other siblings. One is successful Hollywood actor. Another is a moderately successful Hollywood actor. Another is a lead chef at a major restaurant. And then my significant other is a successful business contractor. And another is an entrepreneur. So of the 5 children, in their particular situation at ages 14 and 16, getting married, a million years ago, about 60 years ago, I have concerns about lumping every situation and every group into the same situation. That was a different time, but nonetheless, I don't think if you asked them, they would say that they would do something differently based on the fact that they've produced these successful children and had a successful life. So how do you feel about that? Putting everyone in the same category just to save a few, or potentially save a few.
Well, the conversations I've had with members of this committee and hearing, I think everybody has someone in their family that has married before 18. And thank goodness most of those narratives, it's worked out, as in your partner's case, Senator. But again, this was a long time ago, and we're talking about a government contract. That's really my biggest challenge with this whole situation, is that we're having 15-year-olds enter into binding government contracts with no way out. They can't petition for their own divorce until they're 18, as the current law stands. So that's my biggest challenge with our laws. So I think there have been very successful marriages, but for the most part, currently, as Casey mentioned, we're seeing children being brought across state lines because of our weaker child marriage laws in our surrounding states. And that really is to me, an indication that we need to reform here in Maryland.
Thank you, Senator Elfreth. Senator Carter, thank you. Senator Casserly has a question.
I just have a few. I mean, looking through this law and studying it carefully. So this provides for the petition for the emancipation of a minor and authorization to marry, which the person can file when they're 17. And the intent there would be that they could shave 365 days off the date by which they were married. Of course, they're going to have to file a petition, and they're going to have to ask the court for a hearing, and they're going to have to be a hearing, and there has to be a lawyer appointed for the minor, and then the judge has to conduct an in-camera review, and then the judge has to write an order up, and then they sign an order, and then they make their marriage license, and then they have to conduct a criminal background inspection. I mean, look, at this point, this 17-year-old is now like 17 3/4. So, I mean, I don't want to suggest that the intent here was to make this practically impossible. I mean, just frustration of purpose here. But I'm sympathetic with sort of the overall intent of reducing, of increasing the age to marriage. But as a lawyer, this process, I'm sorry, I'm struggling with that one. So maybe somebody can address my concerns. Thank you.
Senator Elba, did you want someone else to address that?
Well,
or
I think Casey indicated, I think she wants to jump in.
Yeah, no, I appreciate both questions. And I think to briefly respond to Senator Carter's question, while I am deeply happy to hear that the circumstances that you explained and shared with the committee turned out well, unfortunately, what we know from the data in our work is that that is the exception and not the rule. And all we are asking is that genuine loving couples wait to get married on behalf of those who are facing abuse and coercion and exploitation and do not have a choice. And to respond to Senator Casserly, you're right. These are some pretty significant hurdles to prove a bona fide couple, to prove consent in a loving relationship, and that this is in the best interest of the minor. And it will drastically reduce the number of children married in the state of Maryland, but it doesn't make it impossible. And I know that because in states that have implemented similar regimes, we still see, genuine couples going forward. When you really want something, you're willing to go through those hurdles and you're willing to see it through to the end. And so, for example, in Virginia, the year before the legislation passed, 182 minors were married. And in the year after, there were 13 minors married, many all in very close age proximity to each other. And what that shows to me is that it doesn't make it impossible. The intention here is not to make it impossible, but it really is to vet out any and all circumstances where it is not a true, loving, consensual relationship with a minor who is empowered with the full rights of an adult prior to marriage. And that is a critical detail here. I certainly don't want that to get lost. There is emancipation prior to marriage, which means that there is a moment where the minor is empowered with the full rights of an adult, and there is a 15-day waiting period between their ability to then get a marriage license, which is another protective factor that I wanted to make sure the committee was clear on. So thank you for the question, but it certainly doesn't eliminate. I think it just makes it much more likely that the marriages will be bona fide and consensual and in the minor's best interest.
Senator Cass, any follow-up or squared away? Okay, great. Looking around the room, seeing no further questions from the committee, that will then conclude the hearing for Senate Bill 173. Thank you very much, Senator Elfreth, and for the panel. Thank you. Next, we'll move on to Senate Bill 355, Senators Carrozza and Lee. Senator Carrozza, the floor is yours. How are you?
Thank you, Mr. Chair and Vice Chair and members of the distinguished Senate Judicial Proceedings Committee for this opportunity to present Senate Bill 355, Custody Evaluators, Qualifications and Training, and to respectfully ask for your support to work with me on this bill, which would help ensure the safety and well-being of children and protective parents involved in state custody proceedings involving child abuse or domestic violence allegations. Serving on the work group to study child custody court proceedings involving child abuse or domestic violence allegations over the past 2 years has been one of the most important public service assignments that I've ever been part of, especially given the magnitude of the trauma that many children and protective parents experience going through the court custody proceedings involving child abuse or domestic violence allegations. Mr. Chair, you were kind enough to give us a forum earlier in the before session. And you know that our work group is made up of experts and advocates with experience with child custody cases involving abuse. And we adopted over 20 recommendations focused on better protecting children through these custody court proceedings and putting the best interests of the child first in these cases. We heard from one family law expert with 41 years of experience and involved in thousands of cases in 46 states. And he noted the weight to which judges are giving custody evaluations, and that while most custody examiners have been involved in dozens of cases, that there is no way of measuring the accuracy and effects of prior recommendations. He also pointed out how problematic it is that a custody evaluator's report can be admitted into evidence without the evaluator's presence and availability for cross-examination. My bill, co-sponsored by Senator Susan Lee, focuses on the work group's recommendations specifically dealing with custody evaluators. After hearing from parents, advocates, and legal child custody experts over the past couple of years, it became clear that there were not consistent qualifications or training for custody evaluators. This is especially concerning when the courts follow the recommendations in the custody evaluations in over 90% of custody cases. The urgent need to establish clear and consistent qualifications and minimum training requirements to serve as a custody evaluator is underscored by the powerful testimony of a protective parent, Katie Spearman. In preparation for this hearing, Ms. Spearman painfully recounted to me in a Zoom call how the custody evaluator assigned to her was a school counselor with no formal training on cases involving sexual abuse. Further, the high cost involved with the custody evaluator and other legal expenses have left Ms. Spearman in a desperate financial situation. She was forced to file Chapter 7 bankruptcy due to extraordinary legal fees. She lost her home, and nearly 6 years later, she continues to pay attorney's fees that amount to over $360,000. Ms. Spearman is just one example highlighting the need to establish basic qualifications and training for custody evaluators, and to require the courts and custody evaluators to provide basic information about custody evaluations. My panel also will include Mr. Paul Griffin, who is the lead attorney for Child Justice, a nonprofit organization dedicated to protecting our most vulnerable children, and Dr. Jennifer Shaw, a founding partner at Gill Institute for Trauma Recovery and Education, committed to providing research and trauma-informed assessments and therapy to children who have been neglected or abused, including sexual abuse in early childhood. Senate Bill 355 establishes that the qualifications of a custody evaluator include having a master's degree in a qualified field and complete at least 60 hours of initial specified training and 10 hours of continuing education and training every 2 years. In addition, Senate Bill 355 also requires the courts to provide information to the parties regarding the role, availability, and cost of the custody evaluator. Further, before the custody evaluation process begins, a custody evaluator must provide in writing information regarding the policies, procedures, and fees and costs for these evaluations. Mr. Chair and members of the committee, Senate Bill 355 takes a targeted, common sense approach to improve the custody evaluation process, resulting in better protection for the safety and well-being of children, many who have experienced trauma going through a custody court proceeding involving child abuse or domestic violence. Mr. Chair and members, I'm also aware there's both favorable and unfavorable testimony for the bill. I vow to work with the judiciary and other parties to work through this. I believe there is an urgent need here, and after 2 years of going through the work group with these recommendations, this to me seems the bare minimum that we can do is put in some basic qualifications and training for our custody evaluators. Thank you, and I ask for a favorable report.
Thank you very much, Senator Carrozza, and thank you for your work on the work group and then also in the interim and your dedication to the issue. So thank you very much. Next, we'll have unless Senator Lee wants to say anything, we'll go off to Mr. Griffin. Sorry, Senator Lee, we'll just unmute you. There you go. Senator Lee, we actually missed your statement because you were still muted, but if not, we'll go on to.
Can you hear me now?
We can, yes.
Okay, thank you, Senator Carrozza. That was an excellent testimony. Let's hear from the witnesses too, because of the time.
Excellent, okay.
Okay, thank you.
You are up. You were unmuted, but we cannot see your camera's off now, but we can still hear you. So you'd like to just testify. There you go.
Is this me?
There you go. You're up.
Thank you, Chair Smith, Vice Chair Waldstreicher, Senator Carrozza, Senator Lee, and the members of this distinguished committee for this opportunity to testify on Senate Bill 355 regarding child custody evaluators. We respectfully ask for your support for this bill that will help the courts provide an outcome that ensures the safety and well-being of children and protective parents involved in Maryland custody proceedings involving child abuse or domestic violence allegations. My name is Paul Griffin. I'm the Legal Director of Child Justice Incorporated. Child Justice litigates free of charge child custody cases in Maryland involving domestic violence or child abuse, including child sexual abuse. We are one of the few, if only, organizations in Maryland that solely focuses on this narrow issue. I personally have been doing these cases for 20 years. A significant portion of that I did pro bono when I was a private sector attorney, but now as a legal director for at least 6 years, I've been doing them exclusively, almost all in Maryland. I was also a gubernatorial appointee to the work group to study child custody court proceedings involving child abuse or domestic violence allegations, along with the 2 senators who already spoke on that. That work group consisted of multiple subject matter experts who met over many months and heard testimony from several prominent nationally recognized experts in the field. One fact that had an impact on the work group, which met for over a 2-year period, was that an estimated 58,000 children each year in this country are ordered by a court into some form of unsupervised contact with a physically or sexually abusive parent. Some of the children end up abused again, undoubtedly, and others are subsequently killed by the abusive parent. Now, this is a national number, the 58,000, but we have no reason to believe that Maryland is somehow doing any better than other states. In fact, those of us who deal with these cases firsthand can attest that we are not doing any better than the national level. Maryland courts, which are often following the lead of the custody evaluators that court have appointed, will often award unsupervised contact or even sole custody to abusers, even if they've been adjudicated an abuser by the court. This unfortunate outcome can be directly connected to the inadequate training on the part of those evaluators, is our belief. For that reason, the work group recommended changes to the custody evaluation process, which have been captured in SB 355. A clear strength of the bill is a requirement that evaluators have 60 hours of initial training and 10 hours of continued education every 2 years on the topics they need to make more scientifically sound recommendation. Now, research shows that ongoing training is necessary for effective responses to domestic abuse. The science changes, the understanding of things change over time, and people need to be kept up to date on those things. Not only will this help them to be more aware of the signs, symptoms, and effects of domestic violence, child abuse, but it should help lower the gender bias that we often see in custody cases. That bias consists of the deeply held belief that victims and protective parents are simply lying in order to get an upper hand in litigation, or even that a person who abuses his child's other parent can still be a wonderful parent in his own right and may be deserving of sole legal physical custody even after domestic violence has been proven. Unfortunately, the science and past experience don't bear out either of those beliefs. We think that they are incorrect and the science shows it, and we think custody evaluators need to be updated on this thinking. What we are not trying to do is usurp the courts of their role as a final decision maker. It is still up to a judge to decide whether a custody evaluator will be appointed and what weight will be given to that evaluation. That is entirely the judge's decision. We are simply trying to ensure that this tool, should a court decide to use it, is appropriate for the task at hand. And requiring increased training will accomplish that goal, we believe. Now, I understand there's opposition to the bill. Some allege that it's superfluous and that the rules of civil procedure currently mandate sufficient training. I can assure you the current training is not sufficient. I constantly deal with mental health professionals in this field, and who are shockingly ignorant about domestic violence and child abuse issues. Indeed, many of these professionals still use tools that are ill-suited for these cases, such as the Rorschach ink blot test or the Minnesota Multiphasic Personality Inventory, the MMPI. I know it's a mouthful. These are tests that may be appropriate in a clinical setting, but are woefully inappropriate in custody cases with potential domestic violence or child abuse. There's simply no test that can be given that will determine whether someone is an abuser. There is none. Conversely, an abuse victim might suffer from PTSD from the abuse, and it's been established that PTSD on an MMPI, which custody evaluators often use, may erroneously show up as borderline personality disorder, which is a fairly major mental health issue. So we have two competing parents now. One who took the same exam, one who shows up as relatively normal and healthy, and the other who supposedly, erroneously, is shown to have a mental health disorder, which was actually based on the domestic violence and is not a mental health disorder, but PTSD. So of course, a custody evaluator is likely to recommend custody to the supposedly healthy parent, despite his or her being an abuser. And it's shocking to me the number of prominent custody evaluators in the state who don't know this fact. And it's because of their lack of understanding of the effects of domestic violence that we hope that this training will help rectify. Indeed, I know of one case where a mother lost custody to an adjudicated abuser, a father who had twice been found on the old clear and convincing standard to have committed domestic violence against the mother. She lost custody largely based on the mother's responses in a Rorschach test. Now think about that. The evaluator was more concerned about what the mother saw in ink blocks than he was about the father's proven violence. We believe additional training can only prevent that type of misguided thinking. I'll wrap up. I'm sorry. We hope that this body will vote to increase the current training for custody evaluators, and I wish to thank Senator Carozza and Senator Lee for their leadership on this issue, and ask that this committee post a favorable vote on SB 355. Thank you.
Much appreciated, Mr. Griffin. Thank you very much for your testimony.
Thank you.
We'll now move on to Ms. Spearman.
Hi, good afternoon. Thank you, Chairman Smith and committee members for the opportunity to testify. Thank you, Senators Carozza and Lee, for sponsoring this really important legislation. I am a protective parent. On July 2nd, 2015, my then 4-year-old son disclosed to me that his biological father, my then husband, had been playing a game with him called Poisonous Snake. My son acted it out and told me that he had to drink the milk from the snake or Daddy won't play baseball with me anymore. In the weeks following, my son explicitly recounted this story at different times to 2 other adults, including a therapist at a nationally accredited child advocacy center. Like any Maryland citizen should, I reported the abuse to police, to Baltimore City CPS, Child Advocacy Center, lawyers, judges. In total, spending over $700,000 to even get the case to trial. And it was not enough. What is most pertinent to Senate Bill 355 is the custody evaluator in my case, Dr. Gina Santoro, who was a school psychologist. When Dr. Santoro was asked under oath involving her qualifications, did you take any course only focused on any type of sexual or domestic violence? No. Did you do any work evaluating or investigating or treating child sexual abuse? No. Did you ever evaluate a child to determine if he or she was a victim of sexual abuse? No. Did you ever evaluate a child to see if he or she was a victim of any type of abuse? No. Have you ever been qualified as an expert in child sexual abuse? No. Have you ever been qualified as an expert in any type of child abuse? No. Have you ever been qualified as an expert in domestic violence or in intimate partner violence? No. Judge Michael DePietro, the presiding judge for my case and the now judge in charge of Baltimore City Family Court, in his own words said, I know that there was testimony suggesting that Dr. Santoro did not have the requisite knowledge, training, and skills to perform this evaluation, or the evaluation in this case, given the nature of the allegations. I disagree. Judge DePietro further stated, so testimony was received from Dr. Santoro that it was extremely unlikely that abuse occurred. I do find her testimony credible and I afford it great weight. As a result of reporting what my son told me, I lost legal custody of my children. I lost 50% physical custody. I had to file Chapter 7 bankruptcy due to the extraordinary legal fees. I lost my home. My wages still to this day are garnished by the best interest attorney, Renee Aids, who charged over $360,000 for just over a year's work. And while my story is tragic, my children and I are not alone. Legislation is the only fix to a system that is not functioning to protect victims of family violence. This is exactly why Senate Bill 355 urgently needs to be enacted, and so that no other protective parent and her children have to endure what we have. Thank you.
Thank you, Ms. Spearman, for taking the time to testify and for sharing your story and for your work. Next, we'll go on to Ms. Shaw.
Okay, can you hear me okay?
You can.
Okay. Well, thank you, Mr. Chairman and Senator Lee and Senator Carrozza. Thank you for that introduction. I appreciate the opportunity to share a child-centered perspective in support of this bill. I am with a group private practice. We are providers who do assessment and therapy for children. So that's the voice I'm going to give today. It's imperative that all stakeholders in a position to change the trajectory of a child's life understand that abuse is a traumatic brain injury. And whether that injury is a temporary disruption or a wound that neuroscience confirms will persist throughout the lifespan depends on what we do once the wound is discovered. When a court defers to a custody evaluator, an injured child's rehabilitation must be the priority of anyone tasked with determining the environment best suited to meet those needs. The request of you today is that this only be made by a professional with sufficient training to identify signs of abuse and understands what is needed for those injuries to begin to heal. On behalf of all of those dedicated to the protection and restoration of children, please accept the science. Children can't heal until their home is a safe, predictable, and nurturing environment. Providers can't begin trauma therapy when safety is postponed or under consideration or secondary to an adult's right to parent. For providers and court advocates, our most important job is to put adult words to the suffering of children. And some are too young to know the words, others have learned their words won't make a difference, and still others reserve them for when the world proves safety is actually the priority. We serve as trained translators for children. And today we ask that all custody evaluators be asked to learn the same language before offering a recommendation in cases involving an abuse allegation. When a custody evaluation is ordered, this bill proposes that those be based on what injured children need most, not the perfect parent or the one with more resources or the one most equipped to articulate a case, but one with the greatest capacity to create an environment most conducive to rehabilitation, one that can be reasonably predicted to do no further harm and has demonstrated capacity to invite this injured brain to resume development. This decision-making process requires specialized training. We all know children are resilient, but we can't rely on that resilience as justification for a passive response to an active threat to that very capacity. A developing brain either explores or retreats, it thrives or survives, it attaches to a healthy ally, or it learns the risk of harm is too great to do so. They are resilient, but creating conditions to activate that resilience is our responsibility. One last line. If an evaluator is to be given such an awesome responsibility, let's at least make sure the ones who take these cases know what to look for and know what needs to happen next to allow a child to resume childhood. Thank you for your time.
Thank you very much. Now we'll move on to Ms. Marjanovic.
Yeah, Marjanovic, Dr. Marjanovic. First, judicial discretion is the problem. Training has not been working. This has been going on since the 90s. with the Social Security block grants that are incentivizing all of this for the state governments. I lost contact with my son due to a licensed social worker, Patty Cummings. So she's been trained in everything that is specified in this bill, and yet this still happens. So training is not the issue. I also, like Ms. Spearman, I've also had trouble with Gina Santoro. She actually recommended that I lose custody of my son because she claimed my Sioux culture. I'm Native American. Sioux is actually a slur regarding my tribe, but she said my Sioux culture would alienate my son, and that's how I lost custody of my son to our abuser. Senate Bill 355 will fundamentally change nothing for survivors, just like the termination of parental rights bill of 2018 passed and signed into law by the Maryland General Assembly, fundamentally change nothing to protect children from rapists. The reason it will fundamentally change nothing is because the court already has discretion to decide qualifications and training by custody evaluations. When the bill states that the court may not appoint or approve an individual as a custody evaluator, instead of stating that the court shall not appoint or approve an individual as a custody evaluator, nothing will fundamentally change in these courts. Nothing else in the bill matters after that statement that the bill because the bill is a political theater to make survivors who don't know any better go chase our tails for a while before we come back to you crying that nothing has changed. This bill is meant to kick the can down the road and providing any accountability in the courts. Shame on all of you for that. And you've seen me here many times before. My name is Dr. Sophia Marjanovic. I have a PhD in immunology and microbiology. I trained at NIH in Bethesda. I'm of the Ocheti Shakopee tribe. I'm a survivor of domestic violence, police misconduct, and legal abuse that led me to lose custody of my 28-month-old breastfeeding son. In 2012, I was attacked holding my 10-day-old newborn son. I lost custody to our abuser. I've suffered for years. I've even become homeless and enslaved in human trafficking in Maryland as a result of becoming completely disabled from the physical and emotional pain I've sustained in dealing with the inability to protect my son from abuse. I've been in therapy for years trying to heal, but when the system is so unsafe, I need the system to be repaired to be safe. And this bill is nothing but political theater at this point, because like I said, Patty Cummings was a licensed social worker, licensed clinical social worker, and she still has recommended that I have no contact with my son after he disclosed sexual abuse.
All right, thank you very much. Our last panelist will be Ms. Van Roden.
Thank you. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and I hope I'm not butchering that. My name is Eleni Van Roden Bickley. I am testifying on behalf of the Family and Juvenile Law section of the Maryland State Bar Association. We are opposing this bill. And let me preface by saying that our opposition of the bill is not the opposition of the contents contained therein. We understand that custody evaluations and assessments in the matters are critical and useful tools to ensuring that the best interests of the child or children are being maintained, or if not maintained, that they are being held at a top priority above all else. With that being said, as far as the qualifications and the training that the bill addresses, there is currently a rule, Maryland Rule 9-205.3, that I urge you all to take a look at. And I actually have with me some of the, or available to me, the rule itself. But We believe that it should remain in the Rules Committee. The difference between the Rules Committee and it being enacted through the legislature is that statutes are passed by the legislature. So this would be a statute. Rules are promulgated by the Court of Appeals. So this was a rule that was designed by judges within the courts who are dealing with and working with custody evaluators. I also understand that there have been issues, and we are not maintaining that there aren't. However, this rule is also went into effect in 2017. So I would note that while we have a long way to go, we've come a long way since some of the accounts that you all have heard today. One of the things that I would like to note specifically is that there is currently education and licensing that is required of the evaluators for custody evaluations. That includes training and experience. The training and experience includes domestic violence, child neglect and abuse, family conflict and dynamics, child and adult development, and the impact of divorce and separation on children and adults. While there is a waiver requirement for a custody evaluator, we would urge an opposition against this, and noting as well that there is a difference between parenting evaluations and custody evaluations. I look forward to any questions that you may have regarding this. Thank you.
Thank you very much. Looking at the committee, no, we have one hand raised. Senator Carter.
Thank you, Mr. Chair. So I can appreciate the spirit of the bill. I just had a couple of questions for Ms. Spearman because I'm trying to assess how the ostensibly incompetent custody evaluator, like the role that they played and how that played into your outcome. So with respect to your case, so you had, I'm assuming, you had a divorce and custody case or just custody?
Sorry, it took a second to unmute. So it was a custody case first and foremost. As I mentioned at the time, my son made the disclosure. I was married. There was no prior case. So he told me, I fled and I reported it, and my now ex-husband initiated the custody and divorce proceedings. I reported it, but my ex-husband initiated the divorce.
Were Child Protective Services and or law enforcement involved?
Sorry, I had to wait till I could unmute. Yes, it was reported to both Child Protective Services and the police. The Baltimore City police detective who opened the case was moved to a different division the very next day, and no further investigation was conducted. So Baltimore City police never interviewed my children. Child Protective Services ruled it out. However, they falsified the records and they backdated it. So my son disclosed to a therapist on August 11th, 2015. They interviewed my ex-husband on August 13th, 2015, and they ruled it out dated as of August 7th, but in their reasoning for ruling it out stated the interview that they had with him. Baltimore City Child Protective Services never interviewed any of my children.
Thank you. I was just trying to figure out how so much weight was placed on the custody evaluator when it seemed like there should be a multitude of other entities that weighed into the ultimate decision. Thank you.
All right, Senator West is next.
Thank you, Mr. Chair. So, and one of the proponents, could you?
Yeah, I think we got your sheriff in. I'm mute. Sorry.
I'm sorry, can I be heard?
You can, go ahead. Sorry about that.
Okay. So the State Bar Association Family and Juvenile Law section filed an opposition, says testimony on opposition, and they call our attention to, find it, Maryland Rule 9-205.3, which they seem to feel should be sufficient. So could one of the proponents explain what 9-205.3 does and why this bill is needed?
I can address that if you'd like, Senator.
Thank you.
Simply put, the rules don't require sufficient training. I've seen some of the opposition. On the one hand, they say we've already got all this stuff, we don't need it, we're good. And in the next paragraph, they'll say you're putting burdensome training on this. This be so burdensome that no one's going to want to become a child custody evaluator. So I've seen an inconsistency there. Either we're adding extra stuff or we're not. But the answer is we are adding. I think the list that we have in there is much more exhaustive. And it includes more than just training on child abuse, domestic violence, but further the effects of it, the effects it have on people, the effects it have on why perhaps someone who's been battered will talk differently or testify differently. It may affect their credibility. This is training that's not currently provided. That is, and one thing that I'd like to address kind of dovetails with Senator Carter. Also will train them on some of the limitations that Child Protective Services have and the police department have in their investigations. And I'm not criticizing them. And they were beyond the scope of our committee, our group. So we didn't get into them except to point out that the courts and custody evaluators will give great deference to a rule out, when in fact the rule out is very common. The training and the techniques they use are a subject of another day for another bill, but we also think are not sufficient. But evaluators need to realize that. And in addition, parents who report abuse are not a party to the investigation. They report the abuse, it's between the abuser and Child Protective Services. They are not allowed to present evidence. They're not allowed, they're not part of the process. They may be interviewed, they may not be interviewed, but they're not part of the process. So they don't have any control in it yet. Often when the rule out happens, the custody evaluator and the court will give such great deference. They'll say, well, it's already been looked at by CPS and it's ruled out. I think we're done here. That unfortunately happens far too often. But getting back to the crux of your question, the level of training and the list that we have is much more than what the rules provide. But we also don't think it is so burdensome that's going to be the straw that breaks the camel's back that will prevent people from wanting to be a custody evaluator.
Thank you very much for your answer.
Yes, sir. Thank you.
All right, thank you, Senator West. Looking around, seeing no further questions, that will then conclude the testimony in the hearing for Senate Bill 355. Thank you, Senators Carozza and Lee. Did you have a question?
Oh, if that was me, no, I'm sorry. I was touching the camera.
No worries. From the MSBA. I thought there was an extra comment there.
Yes, sorry. I just, in piggybacking off of that, it appears as though within what is being asked of within this bill, there are other legal remedies that a parent, a party, or somebody advising or the court could take, such as psychological evaluations, parenting evaluations, and other things that go way past a custody evaluation and past the training and qualifications of a court-appointed evaluator. So with some of those things in mind, it would appear to be more efficient to build upon the rules that are already in place through this rule and utilize the other systems in place rather than try and conflict them out with each other. Thank you.
Got it. Okay, thank you. All right, with that then, that concludes the hearing for Senate Bill 355. We'll now move on to Senator Lee, or Senate Bill 331. You are next, Senator Lee.
Okay. Can you hear me okay?
We can.
Okay. Thank you, Mr. Chairman. This is SB 331. It ensures that adoptees have access to the same basic vital records and information about their origin as any other person. This bill, if you remember, passed the House of Delegates last year, and it has had wide bipartisan support. In the past, social workers were concerned about the bill, but modern science have made their concerns very much moot, as anyone can use genealogical programs to find their ancestry very easily. Supporters such as Congressman Jamie Raskin has backed this effort year after year, including now when he is engaged in a fight for all our rights in Congress. We are fighting for some of the fundamental rights for individuals who deserve access to their own birth records. Current law limits requests for pre-adoption birth records to adoptions finalized after January 1st, 2000. This date-based discrimination is arbitrary, and our bill eliminates the date-based approach in favor of an unrestricted right for all adult adoptees to obtain their own birth records. States as politically diverse as New York to Alabama to Alaska, even to Oregon, have already taken this step. And it's time for our state of Maryland to do the same thing. Why should someone born in the 1930s be treated differently than someone born in the 1960s, or who is differently treated from someone born in 2005? We should all have equal rights under the law and access to our government documents about our lives, documenting our existence to society and nation and state where we are born. Current law allows a biological parent or an adoptee to file a disclosure veto that bars the disclosure of information about the parent or adoptee in a birth or adoption record. We do away with that veto power and replace it with a preference. However, this bill is about access to the document and does not force the meeting between the birth parent and child. Those meetings already occur with genealogical technology. The state has no excuse to stand in the way anymore. The sealing of birth certificates was never meant to ensure permanent secrecy. And even if it was, that secrecy has been wholly undercut by technological changes. To rely on the what about the privacy of the birth mother response when this issue is raised is to ignore the fact that inexpensive DNA testing like 23andMe rendered the guaranteed privacy of a birth mother essentially impossible. And given that reality, our current law stands as a barrier to adoptees claiming their full identity for the sake of protecting a privacy that does not, in fact, exist. Our bill also recognizes that the age at which an adoptee should have access to their vital records should be the same age of majority. Therefore, we lower the age requirement to request an original birth certificate and other vital records from 21 years of age to 18 years of age. But we do have some flexibility here if required to match other appropriate age restrictions until 21. Birth records belong to the birthed and not to the parents of the birth. With no group other than adoptees does the government give permanent right to parents of a child to seal vital records once that child becomes of age. For these reasons, I respectfully urge a favorable report on SB 331. Thank you.
All right, thank you, Senator Lee.
The witnesses too.
Yes, we'll now go on to your panel and then we'll open it up for questions. So Ms. Samuels is up first.
Hello, can you hear me?
We can.
Chair Smith, Vice Chair Waldstreicher, members of the committee, and Senator Lee, thank you very much for this opportunity to testify and share some of my research. My name is Elizabeth Samuels. I'm a professor of law emeritus at the University of Baltimore. The law, in fact, had never guaranteed lifelong anonymity for birth parents. As courts held 2 decades ago, laws restoring access don't violate federal or state constitutional law, state statutory law, like Maryland's, or contract law. Adoption records have been accessible by court order without participation by birth parents. It's typically been up to the adoptive parents whether to even have a new birth certificate. Birth mothers were not and could not have been offered a choice of lifelong anonymity in the last century. In the surrender documents that I collected and analyzed that were signed in 26 states between the late 1930s and 1990, the years eventually all but 2 states cut off access to adult adoptees retroactively and prospectively. The birth mother didn't retain or gain any rights. She wasn't even promised the child would be adopted rather than placed in long-term foster care or even institutionalized without notice. 40% of those documents did include promises about future information. The birth mother promises that, and I quote, "She will not induce the child to leave the family or institutions in which he is placed. She knows she has no right to know the child's new name or whereabouts. She will not interfere with or harass the adoptive family." The evidence is that birth mothers generally in the last century sought to conceal pregnancies from their families or their communities, not to foreclose any chance they'd have of later learning about how their child had fared in life. Maryland's Governor Commission in 1980 reported that although women were advised to forget about this mistake, none were so easily able to forget the child they had born. All said they would welcome a reunion. The overwhelming majority of birth mothers today, up to 95% and above, are open to some form of contact with their now adult children. In today's domestic adoptions, openness is the norm in infant adoptions. Birth mothers are among the most vigorous advocates of restoring access to their adult children. Those records in the United States were closed in the last century to protect adoptees and adoptive families' privacy from the possible stigma of illegitimacy and from possible interference or harassment by birth parents. In those 2 states that never restricted access, and in all of the 20 states that have now restored access to all or to almost all adult adoptees, access has provided many benefits. Adult adoptees aren't arbitrarily in 2 groups: those who can find information without access, increasingly, as Senator Lee pointed out, through DNA databases, as well as through traditional search methods, and those who just can't. Adult adoptees have been able to get fundamental information about themselves, including medical information. And when adoptees and birth relatives have wanted to connect, access has led to countless very fulfilling reunions. I think it's really easy to understand why this access has been beneficial when you have an accurate understanding of the history I've been privileged to study of adoption records laws. I'd be delighted to answer any questions that I can.
Thank you very much, Ms. Samuels. We'll now head on to Mr. Luce Gregory.
Thank you, Chairman Smith and Vice Chair Waldstreicher and members of the committee. I appreciate the opportunity to speak in favor of Senate Bill 331. My name is Gregory Luce, and I was born and adopted in the District of Columbia into a family that then lived at 213 Normandy Drive in Silver Spring. I'm also an attorney and the founder of Adoptee Rights Law Center and the president of Adoptees United, Inc., a national nonprofit adoptee rights organization. My written testimony provides historical context to Maryland's current law and its discriminatory framework. It also includes a chart that illustrates how this bill, if enacted, would greatly simplify that law and restore equality for all adopted people. Today, however, I'd like to provide a more humanizing context. Let's take 2 adopted people born in Maryland. One is born in 1965 at the Florence Crittenden home near Baltimore. The other is born in 2000 in a hospital in Queen Anne's County. Both apply for their OBC, their original birth certificate, and both are denied. One because she is too old and needs a court order, and the other because a birth parent filed the disclosure veto, one of the very few that ever been filed. This is by far not the end. It's because it spurs on, they are spurred on by that initial denial. Today, there are thousands of search angels, PIs, and DNA detectives who use one thing to bypass these laws: inexpensive consumer-facing DNA testing. So both adoptees spit in a tube and send it off to the lab, and in several weeks, the results come in. Multiple matches with first, second, and third cousins, and increasingly, in DNA databases now contain tens of millions of people, a match to a half-sister, an uncle, or even a parent. For those with matches, you or a DNA detective or even a friend do one thing: contact those matches to determine who the parent may be, and that likely means one very specific question. Do you know of an aunt or a niece or a cousin who relinquished a child for adoption in 1965? And then each person asks their aunts or nieces or cousins, who then ask others, who continue to pass that same question around the family through texts and even posting on social media. Suddenly, when punishing secrecy was a method to shame and coerce a birth mother to relinquish a child decades ago, that secrecy is blown apart and used to make her name known more publicly. That's wrong. Senate Bill 331 does away with the discriminatory and punishing framework and provides equality to all adopted people, greatly simplifying the law. In addition, any prior disclosure vetoes are replaced with contact preference forms, which inform all parties whether or not contact is welcome or not. That's how the law should work and how it works today in a number of diverse states. It is fair, it is simple, and it restores a right every adopted person in the United States once had, a right to their own vital record. I ask that you support Senate Bill 331. Thank you.
All right, thank you, Mr. Luce. And next we will have Mr. Diepenbrock.
Hi, thank you, Chairman Smith, Vice Chair Waldstreicher. My name is Tom Diepenbrock. I submitted written testimony. I'm not going to read it to you, though I expect that everybody can read it. I do encourage you to read it, but I am going to highlight a couple things that are in there for you today. I'm an adoptee. I was born in Cheverly, Maryland in 1969. About 12 years ago, I did a search for my birth parents and encountered a lot of bureaucratic hurdles that I had to overcome. I had to get a court order to unseal my records. Even once the records were unsealed, I'm not allowed to see them. They were sent to the original adoption agency, which was a religious agency, a religious organization. I'm no longer a member of that religion, but nonetheless, I had to deal with them. When I met with the social worker from that adoption agency, she dangled a number of tantalizing details about my life, non-identifying, but nonetheless details. And then she said to me, well, if you are willing to make a donation, and it was a large donation to me at the time, if you're willing to make a donation, we can do a search for you. And I said, well, what if I don't have the money for such a donation? What if that's too difficult for me? She said, well, no donation, no search. And I was essentially strong-armed into giving a donation to a religious organization that I didn't support anymore for them to do a search. I also asked her if I had a different name when I was born, and she pulled up and held in front of me so that I could not see it. She held my original birth certificate up and said, yes, you had a different name. And I said, could you tell me what that name was? And she said, no, Maryland law bars me from telling you what your name was. And so I want that to sink in. Maryland law prevented me and still prevents me from knowing my own name. This is a human rights issue that we're talking about and that this bill addresses. So you're going to hear opposition to this that says the privacy of the birth parents is more important, or that it will lead to a surge in abortions, which, by the way, is completely debunked. The statistics show exactly the opposite of that. When you are confronted with the choice between human rights and between privacy, you have to come down on the side of human rights. This is a human rights issue, and you have to vote that way. So I would urge you to please support this bill. It is also common sense. There is no reason why, just because I was an adoptee born in a particular year, that I should be treated differently than any other adoptee in the state of Maryland born outside of those years.
Time.
Thanks. Thank you very much for sharing your story. We next have Ms. Smith-White.
Yes, good afternoon. Thank you for this opportunity, Chairman Smith, Vice Chair Waldstreicher, respected members of the committee, and thank you, Senator Lee. I'm here to speak in support of Senate Bill 331, but my story is a little bit different from others you have heard. I have always known who gave birth to me, but the adoption laws in the 1950s sealed my OBC, and there are some unintended consequences, which I'd like to explain. I was born in Baltimore City in 1952. My mother, Alice, died after giving premature birth to my sister in 1954. I had my third birthday 5 months later. We were in a loving family. My new mom, Cass, married my dad in 1955. Cass had had a hysterectomy 5 years prior to this marriage. She felt that my dad and me and my sister were just a gift from heaven. So later in life, she told me that she wanted to officially go through the adoption process because my dad's business required him to travel. And if anything had happened to him, she didn't want us to be taken away from her. So the decree of adoption was issued to my sister, to my dad and mom in June of '56 in the Circuit Court for Baltimore County. This meant that my official birth certificate would be amended to reflect Cass as my birth mother. To this day, I've never been able to obtain my original birth certificate, despite my appeal in 2013 to the Circuit Court for Baltimore County that contained 12 documents to support that Alice gave birth to me. So 5 years ago, my grandson was born with spinal muscular atrophy. It's the leading genetic cause of death in infants. He died in November of 2019. He had just turned 5 years old. Now, our family had never heard of this neuromuscular disorder, and as far as we knew, there was no history of this genetic condition in the family. However, I apparently am a carrier of this gene. It is critical that there be open access to original birth certificates for my future generations so that they can understand better their own medical conditions. In closing, I want to make it clear that although I've always had knowledge of my biological parents, I feel it's a travesty of justice that the only birth certificate I have gives the incorrect information as to which woman gave birth to me. I fail to understand why there can't be two legal documents, one that accurately has Alice giving birth to me and one that shows Cass as my adoptive mother. Senate Bill 331 would hopefully solve this issue for me and many others seeking to obtain what is rightfully ours, an accurate, legal, and official birth certificate. I would very much appreciate your thoughtful and deliberate consideration of Senate Bill 331. I give my favorable testimony to this bill. Thank you.
Thank you very much for hanging in there with us today. I'm looking at the committee and seeing no hands raised. That will then end the testimony and the hearing. Oh, yes, Ms. Smith-White, let me unmute you here. Go ahead.
I just want to say that last year, the Senate had to disband after we had given testimony. One of the senators, but I don't remember who, said, well, why would you need genetic history from your family? You can just go have a genetic test. You have to be very specific with your doctor as to what they're going to test for, the amount of money that it would take, what panels do you want run, what is your history? Are you Jewish? Are you a member of a group of people that, a particular ailment is a part of? And we wouldn't know what to say. Consequently, my daughter never had genetic testing. I have two other children that are not married, and they, of course, will know now one of the tests to ask for. But I wanted to research that after the senator brought that up last year. You cannot just walk in and ask for a genetic test to test for everything.
I appreciate that. Thank you for that perspective. Thank you. All right, and with that, that'll conclude the hearing for Senate Bill 331. Our next bill is Senate Bill 57, Senator Lee.
Okay, thank you, Mr. Chairman. SB 57 is largely a codification of existing best interests of the child factors that Maryland circuit courts currently use in child custody decision-making. Child in need of assistance cases subsequently adopted these thresholds as well, but there's a disparity with how they are being applied when the court suspects that an allegation of abuse is merely a tactic in an adversarial process. That's a lose-lose proposition. This committee received the briefing from the work group to study allegations and the disclosure of abuse during child custody and visitation proceedings. And this is merely one bill in a package, but this is a fundamental bill for protective parents. The best interests of the child factors listed in this bill were not pulled out of thin air. They are merely a codification of existing Maryland case law, notably Taylor versus Taylor. Laws are codified to educate parties about the standards applied, but these rules are only found in case law, and worse still, judges are not held accountable for explaining their reasoning when applying those rules. Parents, I believe, deserve to know why custody has been withheld from them, and protective parents deserve to be allowed to report abuse if it happens without the fear that it is a poor legal strategy in the eyes of the court as they currently interpret the law. It is surprising to see any opposition from the judiciary, since we sought their input throughout the process, but only got it for this bill today. Worse still, they seem to think this bill restricts judicial discretion, which we believe it does not. It doesn't. Beyond clarifying that you cannot hold it against a parent for trying to protect a child from real physical harm or sexual abuse. JPR was briefed on the work group's report in December, if you recalled, and that report has also been included in the written testimony for the benefit of our new members. Please look through those recommendations before evaluating this bill on its own, as this is a part of a package of measures designed to protect domestic violence victims as well as children from abuse, and the rationale is essential to understand. Unfortunately, parents are routinely advised to not report abuse during a child custody proceeding because it would be held against you as being uncooperative, which some judges appear to hold on equal weight with the Family Law Article 9-101 or 9-101.1. Listing those other factors is helpful because it could also be clear that there is a prioritization of determining first that there is no abuse before turning to other determinative factors. SB 57 has several measures in addition to the codification of the best interests of the child factors, notably beyond codifying current case law. It also clarifies 9-101 and 9-101.1 without changing the substantive meaning of the law, which is good on its face. If there is opposition to this, there is a misunderstanding of the existing law, which is why we're trying to clarify those thresholds. The exception to the cooperative parent factor is essential and balanced because a reasonable good faith allegation disclosure of abuse or imminent harm is not only a parent's duty, they could be found to have failed to report TP, their child, if they were negligently allow harm to come to them by the other. Our law is so unclear right now, and perhaps partly because it's not codified. And even the American Bar Association wasn't sure where Maryland stood on cooperative parents. It is clear you have to be one or it is held against you, but it is not considered whether this lack of cooperation was to protect your child from abuse. Instead, these protective parents are told to get a protective order. That is not an effective remedy for many people, and the court should accommodate victims. If there is no allegation of abuse or clearly false allegation, the failure to cooperate could and should be evaluated by the judge, but not when the child's safety is at risk. That is the purpose of this bill, protecting children and victims of domestic violence. This legislation is certainly not a cure-all for child abuse or domestic violence, but in a time when we have less mandated reporters interacting with children and victims are stuck inside with their abusers, we need the courts to have clearer guidelines to protect children and domestic violence survivors when they have a custody dispute before the courts. So to avoid being re-victimized by the very institution that should be protecting them. The CINTA carve-out was a suggestion from the Office of Public Defender, and while it is important discussion for a later date, especially when the abuse is not physical or sexual, we can see that there are some unintended consequences that deserve a separate look at that provision as it relates to the threshold to be allowed unsupervised visitation. Notably, perhaps there should be a difference between a parent's right to protect the child from the other parent and the state to be able to step in. The concern is always that there is an imbalance in power of the parties. Who has the burden to prove the child is safe is important. There are also some technical tweaks to the bill that should be examined with new input that we have received from more experts around the country. While the work group established a great recommendations, the legislative process has only begun, and we are open to some tweaks, including adding to the list of best interests of the child factors. These other factors were not considered by the work group because it was beyond the scope of their charge. We encourage looking at the factors first as they exist in common law, but then considering recommendation from groups such as the Child Custody Decision-Making Report from 2014. There are far more similarities with the approaches than differences, and the gap should be filled with a prioritization of the safety of children and fidelity to the law that already exists to do so. For these reasons, we respectfully ask a favorable report on SB 57 as amended. Our children's safety must be a high priority. I'd like the witnesses to be able to testify as they spent 2 years working on this work group, devoted a large amount of time, and we should consider what they have to present today. Thank you, Mr. Chairman.
All right, so thank you, Senator Lee. We'll hear from the panel, and then we'll open it up for questions from the committee. Next, we have Mr. Griffin, sorry, you were up.
Thank you. I know I was just here 2 bills ago, but I'll reintroduce myself. Thank you, Chairman Smith, Vice Chair Waldstreicher, Senator Lee, Senator Carozza, and the members of this committee. I'm here to testify on behalf of Senate Bill 57. Again, my name is Paul Griffin, and I'm the legal director of Child Justice. Child Justice, we litigate free of charge anywhere in Maryland, child custody cases involving domestic violence, child abuse, and child sexual abuse. Again, we're one of the few, if only, organizations in Maryland that focuses solely on this narrow issue. I was also, along with Senator Lee and Senator Carozza, a gubernatorial appointee to the work group to study child custody and involving child abuse and domestic violence. And we heard from many experts over a 2-year period. We brought people in from our other parts of the country who came here, gave us their time, and testified and provided us with a wealth of knowledge. And one of the recommendations that we came up with was to codify the factors in a custody court that a custody court should determine in making custody decisions. Currently, as Senator Lee pointed out, these standards are laid out in various cases, and we believe that pulling them together would be helpful, particularly for pro se litigants, parents who don't have attorneys who are there on their own. But we also made some changes. For example, currently, if a parent makes an allegation of child sexual abuse that is subsequently disregarded or ruled out by the court, that's often held against the parent. And we're not talking about bad faith. We're talking about good faith allegations. The parent reasonably believes something happened. But it's held against the parent subsequently, and the parent is deemed not to wish to co-parent with the other parent. Specifically, one of the standards is the court should consider giving custody to the one party who will, quote, maintain, foster, and facilitate relationships with the other party. I've had courts say, I believe mom believes that this happened. She did, and there's a good reason for her to believe it, but it didn't happen. And she still believes that, and she's going to be resistant. And I don't think she's going to facilitate the relationship between the child and the father. Therefore, I'm going to award father to be to have either sole legal custody or tie-breaking authority or what have you. And the court will couch it as not a punishment for the parent, but it's citing to one of the factors in the current case law. We think that should not happen. We think if someone makes a good faith allegation, and if the court even does rule it out subsequently, that should not be a factor that's used against in determining custody. That not having that is stifling things for parents. I can tell you, I have a number of times told parents not to go forward with an allegation because we didn't think there was strong enough evidence, and it would only rebound against them. That's a very, very hard and horrific discussion to have with a parent, but it happens so often in these cases, I can't even begin to tell you. We also think that when the court does make a finding of abuse, under Family Law Article 9-101, which this body enacted the legislation, that before they can give unsupervised contact to the abuser of any child, not just the child he or she abused, but any child, the court has to make certain findings that abuse is not likely to happen. And that process should not be in a black box. Our proposal is that the court should be required to articulate why it makes a finding and why it believes that there's no further likelihood of abuse. Now, I've been involved with cases before where the judge made a simple statement. I don't think dad or mom is likely to abuse again, therefore I'm not going to have any supervised visitation. And that was it. No explanation, no other reasoning, nothing I could refute, nothing I could rebut, because there's nothing there. Again, it was in a black box. It shouldn't be that way. If those judges were required to articulate how they have come to that decision, perhaps they would have given the issue a little more thought, and perhaps they would have come with another outcome. Maybe they would have come to the same outcome. It's hard to say. But as it is, again, it shouldn't be a black box, and this shouldn't be controversial. We're simply asking that a provision that this body has already created, that some thought be applied to this. It's an already required process. We simply think that some thought ought to be applied to it, and the reasons need to be articulated. We don't believe that this is an undue burden on the court, as some have alleged. So those are some of the things that we are pushing for and asking for in Senate Bill 57. Again, we had 2 years of expert testimony. We met a minimum of twice a month, except for when COVID hit for a period of that before we finished our report. And we think a lot of thought has been given to these recommendations, and we ask that this committee give a favorable report to SB 57. And I again want to thank Senator Lee and Senator Carrozza for their leadership on this issue. Thank you.
Thank you, Mr. Griffin, and
thank you.
Thank you, Senator Lee. Hey, we have Delegate Flanagan here. Mr. Flanagan, how are you? Unmute you.
Am I unmuted now? Good to see you, Senator, Mr. Chairman. Good afternoon. Another long afternoon for the committee. I know how hard you work. Vice Chairman Walstrecker and members of the committee, good to see all of you. Some of you know me from my time in the House of Delegates, but today I'm appearing as an attorney who has practiced law for over 40 years, just as Senator West has practiced for over 40 years. I heard you mention that. And a lot of my practice has been in the area of child custody and visitation issues. My written testimony outlines line by line those parts of the bill that I support. I heard Senator Lee talk about certain common law parts of the custody issue that maybe the committee is going to work on. But I'm here to tell you, I think that for me, the most important part of the bill is, or the part that relates to my experience is 9-101. I've been an attorney of record, mostly pro bono, in a case about visitation that has been ongoing for 6 years. My client was granted custody, sole legal custody, and primary physical custody. So the issue really has been visitation, and if visitation, whether visitation should be supervised. We had a little over 10 days of trial. We had supporting testimony from a psychologist who was court appointed. We had testimony from a social worker who was also court appointed. Again, both of these experts were uncontradicted and supported our case. There were corroborating witnesses who talked about intimate partner violence and child abuse that had occurred over many years. The court made findings that both children had been abused, and later found that my client has been subjected to, had been a victim of domestic violence. My client and the oldest child have been diagnosed as suffering post-traumatic stress disorder. The circuit court order for unsupervised visitation has been reversed twice in unreported decisions, but the decisions have been reversed twice. The issue and my special concern is addressed by Senate Bill 57. If I can try to boil it down. When there is a custody or visitation dispute and the parties and the court has found that a parent has abused a child, what steps should the court be instructed to follow to ensure the protection of the child? In my experience, the current statute, which is Family Law 9-101, provides an unclear and incomplete roadmap. A more detailed roadmap is needed to protect the child. And I think that if the circuit court had had the benefit of this more detailed roadmap, it might have avoided one or both of its erroneous orders. And it certainly would benefit in the part of the case that is still pending on remand.
Time.
All right, well, I think Senator Lee and Paul Griffin have explained the issues, but my support on a line-by-line basis is in my written opinion or my written testimony. I just say that there is one error. My reference to 9-101 is on page 2 of the bill, not page 1, so I don't want anybody to be confused. Thank you very much for your consideration.
Fantastic. Thank you very much for your testimony. It's good to see you. It's a Navy veteran.
Yes.
You, Patrick Henry. Were you on the Patrick Henry?
Right.
There you
Yes.
go. That's right.
Good for you. Thank you.
All right. Well, good to see you.
Thank you.
We're now switch over to Ms. Shaw.
Hi, yes, I was also here 2 bills ago, but just quickly, thank you, Mr. Chairman and Senator Lee. I'm coming from the perspective of a provider, which means try to be a voice of a child. So thanks for an opportunity to share the potential impact of failing to recognize the importance of this bill. So let me offer an adult voice to just one of many unheard or disbelieved voices that I've seen. And wow, this was years ago. This is not necessarily rare in our field. So Liam had done, it's a child, Liam, 5 years old. He had done what we tell children to do, to tell someone you trust if you're hurt or touched inappropriately. He told his mom, his teacher, he started touching his pre-K classmates, and he asked his therapist to play the penis game like he did with his daddy. Considered insufficient to separate a child from his father, 5-year-old Liam was ordered to continue his Wednesday evenings and every other weekend schedule. The forensic interviewer was well qualified but had no relationship with him. He sat playing silently, and the result was an unfounded allegation. We seem to forget we don't tell children to wait for a forensic interview before disclosing abuse. We don't tell them to stop sharing with us because we could be accused of coaching if there are no witnesses. And we don't direct young children to wait until their visit with an expert stranger to ask for help. He had already told his trusted adults, and it was difficult to explain why that was not sufficient. Asking him to repeat it again was risky, as that could be interpreted as coaching. Once labeled unfounded, Liam's abuser again argued he was a victim of alienation. Alienation is a term too often used to discredit protectors and embolden abusers. His mother did seek to alienate her child, as would we all if we discovered our child was being harmed. Failing to do so is failure to protect. The person with the most information about Liam's decline in functioning was his mother, yet her data was considered an opinion as valid as the abuser's denial. His mother had no choice but to drop him off when he screamed, pleaded, and hid when it was time to go. Taking time to console him resulted in another court date to defend her failure to fully comply with a court order. Liam's father had money to take his mother to court again and again and again. While waiting for a custody trial, his father showed him a gun, threatened to kill his mother and therapist if he continued to talk. He lost control of his bladder, he clung to his mother, and he started hitting other children. He had chronic headaches and stomach aches. He stopped learning in school, and the only thing that helped him sleep through the night was a trained guard dog. He stopped sharing the abuse and his feelings, as doing so made his father angry, his mother sad, and made him feel less safe. The court ordered child therapy once a week for 45 minutes as if Liam could heal when his injury was ignored or reopened in between sessions. I would ask you to consider that if any of us were assaulted, I doubt we could function if we were then ordered to have dinner with the assailant on Wednesdays and trust him not to do it every other weekend. Liam was not safe until he was 8 years old, only after evidence was disputable. I'll just wrap it up with SB 57 is a part of a comprehensive but a common sense effort to ensure no child citizen's right to safety is postponed or compromised because the signs and impact of abuse are not identified quickly by those with the training to do so.
Thank you very much, Ms. Shaw. Next, we'll turn to Ms. Ruth. You're up next. How are you?
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. Thank you for having me here today. I am the legal director at the Women's Law Center of Maryland. We are a statewide legal services agency. I also agreed to mention that MLAW, the Maryland Legislative Agenda for Women, has voted this one of their priority bills, and they are fully favorable. They had problems submitting their testimony, so I agreed to let you all know that. I am here to say favorable with amendments. I was also a participant in the custody work group that gave rise to this legislation. You know, if I could just take a minute and explain that the work group was a very interesting group to work in. It was composed of people with a variety of experiences, but not all or even many had actual boots on the ground experience with the judicial system in cases, and not many were lawyers. I count, Paul Griffin as one of the true experts that was on that work group. So there was a very large learning curve in the initial meetings, excuse me. It was a very dedicated group of people, and I myself learned a lot from people who are involved from a non-legal different perspective of therapy and whatnot with children, especially in child abuse. Respectfully, and Senator Lee, we appreciate the efforts that you've made, but we do see some problems with this bill as drafted. First and foremost, the custody factor provisions within this bill are not, in our view, the correct method or the correct language to codify the custody factors. SB 57 arises from the work group that specifically was addressing cases where domestic violence or child abuse was alleged. The custody factor issue that we've been forwarding in Annapolis for years is broader than that. And so this seems like the custody factors here were put in as an afterthought to the idea of around 9101 and 9101.1. We much prefer Delegate Dumais' HB 505. This is a bill that came from the massive effort of the Custody Commission that met in 2012, 2013. I was also a member of the Custody Commission. HB 505 is more comprehensive. It addresses language use in an effort to modernize thinking around child access. And we just think it's a better product, and actually that these ideas should be separated. As Senator Lee said in her introduction, the work group was a narrower scope. It was supposed to be looking at cases where domestic violence or child abuse has been alleged. The Custody Commission had a broader scope, and the product from that Custody Commission seems like a better product. I'll just take two brief seconds to say, we have some concerns about 9101, 9101.1 not applying to SINA cases. I agree with Senator Lee. It was a public defender who wanted that. Of course, the public defender represents the parents. But I defer. I do not have expertise in that area. And in 9101, 9105 for the protective parent, we absolutely think there's a problem in courts with protective parents being treated improperly. But the language as drafted is very, very broad, and we're concerned about misuse of it. For those reasons, we ask for a favorable report with amendments. Thank you.
All right, thank you very much, Ms. Ruth. We'll now turn to the opposition, and we've got, we have one more favorable with amendment, Dr. Marjanovic.
Yeah, Dr. Marjanovic. First, judicial discretion is the problem. In all of our cases, I'm a survivor of all of this legal abuse. Training doesn't work. Accountability works. Senate Bill 57 will fundamentally change nothing for survivors, just like the termination of parental rights bill in 2018 fundamentally changed nothing to protect children from rapists. The reason nothing will fundamentally change is because the bill frequently allows discretion to decide supervised visitation by stating in the bill the court may approve a supervised visitation arrangement. The bill will not protect my son, me, or anyone else trying to escape abuse from being labeled parental alienators, which is considered psychological or emotional manipulation by the courts. This bill doesn't specify custody or visitation arrangements, leaving the discretion up to the courts, which has been and will continue to be the problem. Mind you, someone mentioned that parental alienation is a problem in these courts. That parental alienation syndrome was invented by a pedophile, Richard Gardner, and it has been used throughout the courts in the United States. Social Security block grants actually incentivize us to be stuck, survivors to be stuck in these situations. I've outlined in my written testimony what else needs to be amended in order for the bill to have teeth and truly protecting children. As you know, I've been here many times before. Over the years, I actually was part of the working group. I actually left in 2019 because the working group was not listening to survivors. I ended up leaving the state of Maryland to go work for the Bernie campaign because I realized I was not going to get accomplish anything in the state of Maryland because of the way the working group was not listening to us. It was completely glossing over us and being able to draft these bills. As you know, I'm a survivor of domestic violence, police misconduct, and legal abuse and lost custody of my son, 28-month-old breastfeeding son, to my abuser. I've suffered for years from this. This happened all in 2014, but I'm wrapping up. But over time, I've become completely disabled from what I've endured in the courts in Maryland. Eventually, I became homeless and enslaved in human trafficking, despite having a PhD in immunology and microbiology and training at the NIH in Bethesda. Thank you.
Thank you very much. And for the last proponent, we have Miss Kenny. I think I saw you there.
Okay.
Floor is yours.
Okay, is it working now? Can you hear me?
Yes, we can. Loud and clear.
Okay. All right. So my name is Annie Kenny, and I am a single mother to 3 daughters from St. Mary's County, and I will not take much of your time. Several years ago, I discovered that my husband was abusing one of my daughters. He was indicted on felony child sex abuse charges, and he is now a Tier 3 registered sex offender for life. I mistakenly thought that I just had to survive his conviction in our divorce, and then I could move forward with my life and focus on the healing of my children. However, nearly 4 years later, I am still in family court. I've lost count of the court hearings where I've been encouraged to include my ex-husband in my daughter's mental health treatment, where I've been instructed to discuss all things relating with my children with him and include his opinions in my decision-making. I've repeatedly been told that I have an obligation to maintain a relationship between my ex-husband and my daughters. At one point, I learned that he was sleeping alone with my daughters during his supposed supervised visits. My mother-in-law, the supervisor, was allowing it. And at my next court hearing, the judge still wanted me to continue sending my children, that we would just try to get them to do better next time. My constant court battles trying to protect them has drained me. I spend hours each week preparing, uploading documents, talking to lawyers, domestic violence experts, therapists. I spent 2 years fighting alone and over $30,000 before I managed to find Paul Griffin of Child Justice. He doesn't know I'm here today. And I would guess that we're well over 100,000 now. We've been fighting for 2 more years, and even with his assistance, the best of the best, we're still in family court. I'm never given the opportunity to get to the other side of this. It's my ex-husband who made us victims, but it's society that has prevented us from growing into survivors. I'm trying to teach my daughters that real love doesn't hurt. But what they're being told repeatedly is that they are obligated to maintain relationships with people that hurt them. Chair Smith, imagine waking up tomorrow and being told that you are no longer in control of the decision-making for your daughter. Because someone else hurt her, you are losing your right to make choices for and protect her as you see fit. Imagine sitting down with her and explaining why a judge has decided that her biological connection to an unsafe person nullifies her basic human right to safety. Family courts should not have so much discretion when it comes to child custody cases that involve a history of abuse. I understand that there are two sides presented in court, and one of them has to carry the weight of the burden of proof, but the current system is doing it wrong, and it's failing children in the process. When there is a history of abuse, it should be up to the abusive parent to prove that they can be safe going forward, not up to the protective parent to demonstrate how dangerous they are. This current dynamic is literally telling the abusers that the protective parent is the one standing between them and their children, not society as a whole. It's worth mentioning that 2 weeks ago, my ex-husband was arrested for molesting. Just one more second, please. My ex-husband was just arrested for molesting 2 other little girls. They are the same ages as my 2 daughters that I've been repeatedly instructed to continue forcing visitation with. I still have an active court order with a visitation schedule that I'm just not complying with at this point in time. I just keep fighting off contempt charges left and right. And even in the midst of this news of his new crime, more than anything, I'm relieved because I think this might mean that we are finally free, that we finally demonstrated that he is unsafe. But I got to tell you, I know exactly how many years before my youngest daughter turns 18. And if he's sentenced to anything less than that, and the law doesn't change, I will be packing up my children and disappearing before he gets out of jail, because the family court has continued to endanger them, but I will not. We need to get rid of the idea that an unsafe parent is better than none at all. Thank you for your time.
Thank you, Ms. Kenny, for your time and your testimony this evening, and for sticking with us all day, and for sharing your story. Now we will turn to the opposition panel, and we'll start off with Ms. White.
Hello, my name is Rachel White. My apologies that you can't see me. My video is not working for some reason, but I am the Child Welfare Policy Director. Hold on one second. Yeah, okay, yes. I am the Child Welfare Policy Director at Advocates for Children and Youth, and we have submitted testimony in opposition. And it should be noted that we would have supported with amendments, but we feel like there's language in the bill that makes it egregious to youth in foster care, specifically children in need of assistance. So the bill as written eliminates Family Law 9101 protections for youth in foster care and youth in the child welfare system. And this particular statute has been applied in Senate cases for over 2 decades to protect children in need of assistance from abuse and neglect. And we have examples of case law from decades to present that indicates how the bill has been used to protect children from future neglect and abuse. And so we would be inclined to support the legislation if lines 5, 6, and 32 on page 2 are eliminated, as well as line 1 on page 3. And thank you for the opportunity to present testimony today.
Excellent. Thank you very much.
You're welcome.
And finally, we have Ms. Van Roden. You're up next.
Thank you. Good afternoon again, Chair Smith, Vice Chair, and to the rest of the Senate. I appreciate you guys taking the time to listen to our opposition today, and I am on behalf of the Family and Juvenile Law section of the Maryland State Bar Association. We do oppose this bill, and honestly, I'm not going to take up too much of your time because we've sent in written testimony regarding the same. And as somebody earlier said, you all can read. But I would note as well that much of Ms. Ruth's testimony, the favorable with amendments, much of her testimony is where the family and juvenile law section is coming from. I would urge you all to look at House Bill 505, which deals with not only the custody and visitation factors that are within this proposal of SB 57, but additionally note and take into consideration the recently enforced Maryland parenting tool that's gone into effect for parenting time and decision-making, which is physical and legal custody. The other thing that I would urge everybody to keep mindful of is when you've got language that deals specifically with abuse or with protection, it eliminates or excludes those that are otherwise eligible. One of the things that I saw specifically was as far as contempt proceedings, as far as the reasonable effort and the word protect, it takes on the connotation that refusal or interference is limited to just a safety measure. I would also note as well that there are plenty of, and this doesn't make it a great thing, but that's another time and another issue for another day, that there are plenty of protective order matters that get dismissed into consent orders or that get consented to, that the consent of a protective order does not necessarily mean that the person against whom the protective order is issued agrees or is found to have done the alleged acts. So within these, within the language, it would appear as though you are looking more towards, thank you. It would appear as though you're looking more towards somebody who has been found to have abused or where there is that history of abuse, as opposed to all of the other cases that that this is excluding. For those reasons, we would urge that you issue an unfavorable report on SB 57 and instead take a look at House Bill 505, as that carries not only these issues, but others that could additionally help. Thank you.
All right, thank you very much. And with that, seeing no questions, that'll conclude the hearing for Senate Bill 57. Actually, I'm sorry, here we go. Senator Castley has a question. Senator Castley.
Thank you. Briefly, Ms. Bickley, where I'm looking at the testimony, I don't see anything from the Maryland State Bar Association or from you. Who submitted it? What name am I looking for? Hello? Yeah.
Give us a second to unmute her here.
Okay.
Thank you. Sorry, I'm not allowed to unmute. So I had prepared the testimony. It was submitted by Eileen Glickman, so by Ms. Glickman, but it was submitted last week. I'm
Eileen
looking at the
Glickman?
printout.
Okay. Okay. I think. Okay. Good. All right. Now I see it. Thank you. That's my first question. All right. So now I do have that now. Thanks. I just couldn't figure out where you said this testimony was. Okay. And then it's really a question for you and for Ms. Ruth. Maybe you can just, so as I understand the position here is, and I look at this bill when it's proposed by a work group that's charged with dealing with issues of child abuse and neglect, and yet the bill, the first page does address, the first two pages do address the sections of the law dealing with neglect and abuse, and it's but then everything else under 9109 is just your standard family law article dealing with run-of-the-mill child custody and visitation cases, right?
Yes, that's right.
So we have a work group that was charged with really looking at abuse, and we end up amending the key provision in the family law article by which we resolve all custody visitations, the absolute vast majority of which, fortunately for all of us, don't involve physical or sexual abuse or mental abuse. Isn't that fair to say?
Yes, that was exactly what the point of my testimony was,
Gotcha.
Senator,
Okay.
is I think that, with respect to Senator Lee and the work group, they're sort of jamming in this bigger issue into a bill that really is supposed to be arising from a focus on cases where there's been domestic violence and sexual and child abuse.
Okay, and then so the first part of this is just dealing with child abuse. I actually diagrammed this out. I'm trying to. There's a lot of words, but in the end, it sort of seems like we said the same thing that was already there under section 9101A, this regarding abuse. We took language out, we put language in. I'm trying to see exactly what the key difference on that provision is. Can somebody tell me? Yeah.
I'm sorry. I mean, Senator Lee herself said it's really clarifying language. How I would which I agree with, how I would characterize it is it's trying to put some meat behind the use of 9101 and 9101.1 to encourage judges to actually pay attention to this issue. And I think, you know, anecdotally, and I think Ms. Bickley and maybe even Mr. Griffin and others would agree that too often we see the courts just ignore it. They don't address 9101 and they don't address 9101.1. So we thought that, I think the bill drafters, and the idea was if we articulate that the judge has to articulate why they think there is no likelihood of future abuse, it will sort of twist the arm of the judiciary and the judges to make them put on the record what their decision making is. Okay. And you know, as to Mr. Flanagan, I think I know which case you're talking about, Mr. Flanagan, and it's really a travesty what's going on.
Let's not go too far off. Let me pull this back because we're trying to wrap this up. Can I ask real quickly, Ms. Bickley, does MSBA, I printed your thing, I haven't read it yet. Do you all specifically address whether you have any concerns about the page 2 of the bill and 3 that really are on that 9101A, B regarding child abuse? Do you have any, do you address?
I was about to say court's indulgence, but give me 1 second.
I mean, because as I understand your concern that we shouldn't have this work group propose a bill on the general child custody visitation law. But now if we just take that out of there and we focus just on this beginning piece, did you all review it? Do you have a position on that part of the bill?
Just on 9101,
Yes.
I think if we were, that would be in the kind of answer that people like everybody else in the world except for lawyers hate. It depends. Because if you're looking at 9101, there's also 9101.1. It's not that we disagree with the efforts or with it being separated from SINA. It's the fact that, this takes into specific account and requires the court to be specifically looking at things that they already are looking at in other areas or in other specific sections of the law. Additionally, I think, that was kind of our general hesitation with this, is that it takes so many different areas and factors and puts them all into one, attempting to make it one comprehensive bill. Our big issue, and I will be candid with you, Senator Casserly, our big issue is the top of page 4, lines 1 and 2, with the presumption that joint custody is in the best interest of the child historically. And because I'm nerdy enough that I read into the history, since 2008, this has been proposed with the custody factors, and it's not passed because of the language regarding the presumption of custody. The issue that you have with the language in SB 57 specifically is that if you take any of these specific factors that are being proposed, it can lead to a slippery slope. Does 9101?
I'm more comfortable. That's because I'm more comfortable on my own on the 9109. So I don't really. Yeah. I'm focusing really. I don't do child abuse cases and neglect, so I'm more at your all's mercy. But okay, thank you very much. Thank you, Mr. Chairman.
Of course, thank you very much.
Problem in general is there's no accountability in this bill for judges when they.
All right, so we're going to give. Sorry, just please wait to be recognized before you get you start speaking. Mr. Griffin, you are. I know you have your hand raised. You've got something that's responsive to Senator Cassidy's question. So go ahead.
Yeah, I just want to clarify, and maybe I misheard her, but top of page 4, lines 1 and 2 make it clear that there is no presumption that joint custody is in the best interest of the child, which has been consistent with the legislation that's come out of this body. I would add that the 9101 information, the standard that we're having in here, is truly not as much of a change as people seem to think it is. This body has already required the courts to make a finding. All we're asking to do is to take the next step and articulate the reasoning behind it. Hopefully, then it will cause that court to give more mindfulness to its decision, which is the health and safety of a child, after the court has already made a finding of abuse. So the issue on protective orders that was raised earlier doesn't really apply. If someone stipulates to protective order, she's correct. If they don't make there's no finding of abuse. It's only if the protective order in that instance is found against them after a fair hearing that they've abused, or in a custody matter that a court has found that they've abused, that 9101 would kick in. So there's no kicking in if there's no finding of abuse. So this is when a judge has already said, you have abused a child. I have to decide what to do going forward. I find there's no further likelihood of abuse. I'm required to explain why. Here's why. Because you went to classes. You are now in an AA. You were drinking that. Lots of people have done stuff to show that they're not the same person they are. Courts should be required to articulate these, not just say, "Oh, I don't think there's any further likelihood of abuse. I'm done." That's all we're really asking. This body's already decided that this is a necessary step. We're asking that it take it to logical conclusion and require an articulation of that thinking. Thank you.
One last rejoinder here from Ms. Bickley, and then we're going to move on to Senator Carter's question.
Thank you. And just in response to that, with the no presumption that joint custody is in the best interest of the child, that then opens up the doors that sole custody is in the best interest of the child. And you've just opened up the doors for a lot more reopenings, modifications, et cetera. So, that's part of the other part of this too, is that, the language needs to be specific with what it is that you're trying to convey. If there's no presumption as to custody being in the best interest with one party over the other, then state it. And actually, HB 505 does state it. That's why we say unfavorable report to SB 57 and look to House Bill 505. Thank you.
Thank you very much, Ms. Bickley. All right. Senator Carter, you're up.
Thanks, Mr. Chair. I promise to be brief. I know it's getting late. This is a really significant issue that's being raised by this bill. And I would ask the sponsor how it happened that all of the prior work that had been done on, like, the prior commission that I sponsored, I think in 2013, on the Commission to Study Child Custody, where there were recommendations that we move away from terms such as custody and visitation to legal decision-making and parental time, for example, much more modern terminology that's more fitting. It appears that your report and your bill, subsequent bill, just completely ignored all of that prior work that this legislative body had done. How did that happen?
Would you like the senator to respond to that, or you want Mr. Griffin?
Either one. I wanted Senator Lee, but if you've got an answer.
Okay. Paul Griffin could probably follow up on what I'm going to say. I think that nothing in this bill changes any, of the factors that are in case law right now. And we're not trying to invalidate anything that your commission had worked on. The purpose and intent of this bill was to concentrate on the issue of abuse and neglect and domestic violence that occurs in custody and visitation. We're not trying to touch those factors that you all had talked about. And as we indicated earlier, we're open to work with you all on this.
I understand. Senator, I don't want to cut you off, but I understand your answer. I think I'm going more toward conceptually moving into a space of more sensitivity toward.
Yeah, this is not a substitution for the other bill. This is not a substitution. And that's not our intent. Our intent is.
Let Senator Carter finish up.
Oh, I'm sorry. Okay, go ahead.
My other question is regarding the parade of horribles with our current system, our current judicial decisions. I didn't see in either report or any testimony the specific data in Maryland where courts are awarding custody to abusers and neglectors happening on a repetitive basis. So I would like to see the actual data on how frequently this happens, and perhaps if it's more common to happen in a certain jurisdiction, that would also be helpful. I saw, stats about America in general and the horrors about abuse and neglect, which we all agree abuse and neglect are terrible. However, I'm not comfortable with this bill because I need to understand where the failings in the current system are and how often it happens. Judges make mistakes, but is it happening twice a year? Is it happening, every 10 out of 12 cases? I'd like to know that. So when you get a chance, I'd love to be provided.
Of course. What the purpose of this bill also was to provide some kind of accountability when they do make those decisions in cases where there has been prior abuse or neglect or domestic violence in custody cases. And, by just merely asking the judge to articulate their findings.
Articulating the findings is the least problem that I have with the bill. I'm good with that line. Okay, that's fine. That's my issue.
Well, with respect to specific examples, I'd like to turn it over to Paul Griffin because his organization is boots on the ground.
Hear like cherry picked examples of horribles.
No, that's not what we're going to offer you. Okay.
Yeah.
I'm going to give you cherry picked.
We have
some specific data. Okay.
That's all I want to know. Did you, at any point, did anybody actually look up the frequency with which this happens? And if so, is it provided in a report or a document anywhere that we can take a look at?
Okay. Mr. Griffin, do you would respond to that?
Ms. Griffin, you are ready.
Yeah, I could tell you, I mean, Maryland doesn't keep track of this information, and that's not on us. That's the court system. I can't control that. I can tell you
I hear you, but the only thing that I would take issue with, I remember years ago when we were arguing about these issues, I remember securing information from the Maryland judiciary that actually broke down the number of situations in which cases custody is awarded to mothers versus fathers versus jointly. So I actually believe with a little work that we could actually come up with that data. And I would hope your commission, if you're looking at changing an entire body of law, that you would at least come up with the data from which to premise.
I can't come up with data that I have control over.
I don't want to argue about it. I'm saying we don't have any data.
If I could just finish, I would appreciate it. I mean, I don't think I'm going to get the court's going to be able to convince the judge to say I gave custody to an abuser. We might. I'm very open to that, but that's the administrative office of the court, so I'm happy with that. I would like to point you though to page 16 of our report. So I have to disagree with what you said. Let me quote this to you. The work group recommends for best interest factors to be specified in statute and notes that this recommendation echoes that of the state's 2014 Commission on Child Custody Decision Making. As noted in that commission's final report, a comprehensive list of what a court is to consider will enable the public, particularly those who do not have access to legal representation, to better understand what evidence and testimony will be needed in a court proceeding. We think the 2014 Commission did a great job. I don't know why all those recommendations weren't enacted into the law. I wasn't a part of that. I do know that
I was thinking about the concepts and the terminology, but I don't want to belabor this because I promised the chairman I wouldn't be long. I just want to, if you had the data and you don't. So the other question I had is with regard to the commission, who on the commission represented the interest of fathers in particular? Was there anybody on that commission that was representing a father's organization or group?
My understanding is that they could not get any people to do it who that would pass the vetting process. I mean, that wasn't our area. We were members of it. We weren't part of the appointment
There
process.
was nobody on the entire commission representing a father's organization or advocacy group.
Or a mother's organization. Neither one of them. Neither mothers nor fathers.
It seems to me like
actually there was someone who was actually selected from a father's group, but he had to withdraw because of a pending conviction.
Of domestic violence conviction. So we got the one guy who wanted to do it, but he had a domestic violence conviction.
So he had to withdraw his.
I understand. Well, I mean, all the time when we replace people that can't serve, but I won't get into that. It just looks like the bill is very overly broad. It's been even testified to by Ms. Ruth and other people, the person, Ms. Bickley. And so it's overly broad. And it also seems to provide major changes not premised upon specific data. And so that is my concern about it. I think that the commission may have a little bit more work to do than what you have put in. And I don't negate the time that you put in, but I don't see any evidence of a broader perspective or greater diversity within your input.
I wish I knew what some of that meant. All I can say, Senator, is that.
Would you like me to break that down for you? Because
absolutely.
I'm saying there doesn't appear to have been great diversity. There does not appear to have been broader perspectives. For example, what Maryland experts were used in concluding some of the things that you concluded? I saw a very broad language, but I didn't see that. So, I mean, if you want me to go into it, I can.
I'd happily refute those if you'd like. I mean, I haven't seen no evidence that Maryland is an exception compared to the rest of the country. I mean, there's nothing special about Maryland.
And changing our laws.
Yes, changing our laws to bring them to a better place for the kids. I mean, I've been to funerals for 4 kids that were murdered. You say I'm cherry picking. That's not cherry picking. That's a serious problem we have.
This is really outrageous. I'm asking questions. I am not here to argue with you. If you can't provide the answers, that's fine. But don't go and bring up some horrible event.
Well, please don't minimize it. I'm asking you not to minimize
that you can't make.
I'm just asking not to minimize that. That's all I'm asking.
Got it. Appreciate it. I don't have a literal gavel here today, but so we're going to thank you very much. That'll conclude this round of line of questioning. Senator Carter, if you have more questions, and then Mr. Griffin, and I see Ms. Bickley and Mayanovich, if you could just respond in writing. If you've got something else to say for the committee's benefit, I'd appreciate it, but I want to go ahead and cut this off here. All right. And with that, we will end the hearing for Senate Bill 57 and move on to Senate Bill 210. Senator West, you were up next. Thank you all very much.
Thank you, Mr. Chairman. It's been a long afternoon, and I really don't want to prolong things. Unfortunately, my bill, when I took a look today at the amount of testimony submitted on this, it's been a long time since I've seen quite so much testimony submitted by so many different organizations on a single bill. So let's try to go through this as quickly as we can. I am pleased to introduce Senate Bill 210, which is an important bill of the bipartisan Senate Small Business Jobs Caucus. You will note that the 4 sponsors of this bill are Senators Hester, Carrozza, Peters, and myself. I also understand that this bill is the top legislative priority this year of the Maryland Chamber of Commerce, the National Association of Independent Businesses, and the Maryland small business community. Senate Bill 210 is a direct response to the COVID-19 pandemic, which has so devastated so many Maryland businesses, both small and large. No business has been immune, but many have been especially hard hit. Numerous bars and restaurants have closed permanently. Others are boarded up and may never reopen. Most have seen sharply diminished income and are barely hanging on. The same is true of retailers, as so many Maryland citizens have gone online to purchase desired goods rather than patronize brick and mortar stores. The same can be said about nearly all of the state's business establishments. Walk through the offices of law firms, accounting firms, and most other firms in Maryland, and you will travel deserted corridors and pass by empty offices. Most officers of these firms will tell you that working remotely is an inadequate substitute for the synergies of having your workforce physically present each day in the company's offices. This disastrous situation is not limited to the state's for-profit businesses. The same distress has afflicted its nonprofits, its schools, and its colleges. Healthcare facilities across the state have been hard hit as well, the more so as their heroic personnel have had to work harder than ever while endangering their own lives in order to care for others. And now, at the 11th hour, after so many Maryland businesses have closed their doors altogether or are just hanging on, they face the prospect of having to defend lawsuits filed by the families of Maryland citizens who have died or others who have survived the virus, but whose long-term health has been gravely impaired by the collateral effect of COVID-19 on their bodies. It is expected that many lawsuits will be filed, alleging that those felled by the COVID-19 virus contracted the virus at the time they were on the premises of the defendants in the lawsuits. Of course, it will be exceedingly difficult for the plaintiffs in those cases to establish by a preponderance of the evidence that the virus was caught at the time the plaintiff was on the premises of that defendant, as opposed to at any number of other locations visited by the plaintiffs in the weeks prior to their getting sick. Nonetheless, every case has a settlement value, and faced with the necessity of paying defense counsel to defend such cases, many businesses in Maryland will knuckle under and pay a negotiated amount of money in order to get out from under such COVID-19 cases. For Maryland businesses already barely hanging on financially, the prospect of paying large sums of money to get out from under expensive COVID-19 litigation could be the last straw. Senate Bill 210 is a deceptively simple response to this situation and is intended to throw a lifeline to Maryland organizations that in good faith have endeavored to adhere to COVID-19 guidelines promulgated at the federal, state, and local levels. It defines the term person very broadly to include an individual, a business entity, or other legal entity, including corporations, partnerships, limited liability companies, business trusts, estates, joint ventures, Section 501c3 nonprofits, schools, institutions of higher learning, and healthcare facilities of all types. It also includes employees, agents, and independent contractors. Now, I have 3 amendments that I have filed with my testimony. One is the product of a conversation I had with Senator Heddleman's husband. It's nice to know that even the spouses of the legislators can contribute to legislation. That one adds the requirement of good faith to the bill. The other 2 are really technical amendments, and I commend them to you. Also, in the testimony, I see that a couple of other people have suggested other amendments that don't appear to be very complicated, but nonetheless, some work needs to be done on this bill to incorporate these various amendments, all of which I think sound fine. So Senate Bill 210 is limited to COVID-19 claims that arose between March 5th of last year and 180 days after the governor's executive order expires or is rescinded. That's the order that proclaims the emergency. The bill states that a person who, in the exercise of good faith, that's the amendment language, in the exercise of good faith, acts in compliance with all federal, state, and local statutes, rules, regulations, executive orders, and agency orders related to COVID-19 is immune from civil liability for a COVID-19 claim unless the person's actions amount to gross negligence or intentional wrongdoing. The bill also provides that a deviation from compliance with the rules that's unrelated to the plaintiff's injuries does not deny a person the immunity provided under the bill. Now, I had a very productive conversation with Mr. Waldberger, who will be here to testify against this bill. He called my attention to the Maryland Court of Appeals decision in DUA versus Comcast. It's a 49-page decision, but I read it. In that decision, various Comcast subscribers who had paid Comcast late fees exceeding the permitted rate of 6% under the Maryland Constitution sued Comcast for the recovery of the excessive late fees that had been paid. The General Assembly then passed a law authorizing higher late fees and extending the new statute retroactively for 5 years. Comcast then moved to dismiss the actions of the customers. The court held that the Maryland Constitution prohibits legislation which retroactively abrogates vested rights, in that case, the rights of the subscribers to sue Comcast to get their money back. In the DUA case, the statute passed by the General Assembly purported to completely extinguish the rights of the Comcast subscribers to sue to get their money back. In the case of this bill, however, the proposed legislation does not extinguish the rights of people allegedly injured due to contracting COVID at a particular business location to file suit. Rather, what this bill does is to raise the level of proof that must be introduced at a trial for the plaintiff to prevail. If this bill should pass the General Assembly, the plaintiff would not only need to establish that the defendant acted negligently, but also that the defendant failed to act in good faith and failed to comply with federal, state, and local COVID guidelines. Unlike in DUA, therefore, this bill does not extinguish rights. It merely increases the level of proof that the plaintiff must establish in order to prevail in court. To be clear, this bill will not prevent any plaintiff from filing a lawsuit. It may discourage such suits due to the higher evidentiary burden that will be required in court. But if a Maryland business failed to act in good faith and failed to act in compliance with federal, state, and local COVID guidelines, such a business will have left itself open to suits by people who caught the virus while the people were present on the premises of the business. Let me just give you an example. There are 10 bars on Broadway in Fells Point. 9 of those bars complied with the governor's COVID guidance, which is that to be served, a patron must be seated at a table, and when the person is not seated, the person has to wear a mask. The 10th bar didn't comply with the guidelines. If you walked into that bar, you would find people 3 and 4 deep at the bar, standing at the bar, unmasked, laughing, carousing, having fun, in complete defiance of the COVID guidelines. Under this bill, the first 9 bars probably would have a very successful time defending themselves, and it'd be very hard for the plaintiffs to recover. But with respect to that 10th bar, where the owner did not comply with the guidelines and did not act in good faith, this bill would not preclude a plaintiff's lawyer from filing a suit on behalf of people who caught COVID while in that 10th bar. I was asked by an email if I could ask a question and then respond to it, so it's part of the legislative record in this case. So the question is, in cases where housing providers comply with all applicable laws, regulations, and orders, could they still be held liable for their tenants' non-compliant actions? And my answer would be no. Pursuant to this bill, if tenants choose not to comply with applicable requirements, nothing in this bill would subject their housing providers to liability. So to sum up, I think I would suggest to the members of the committee that this bill is fair and reasonable and balanced. And for these reasons, I ask the committee to vote favorably on the bill. I have 3 witnesses prepared to testify: Andrew Fox, Ben Seidel, and Carvel Collins, and I turn the proceedings over to them, and I think we'll all answer questions at the end.
Excellent. Thank you, Senator West. The first witness you have signed up here is Mr. Fox. So, Mr. Fox, you're on.
Thank you. Good afternoon, Chairman Smith and all committee members. My name is Andrew Fox, and I'm here today to support the passage of Senate Bill 210. I'm the owner-operator of Vita Taco Bar's 3 locations in Annapolis, Severna Park, and Baltimore, as well as Fox's Den here in Annapolis. I spent my entire life in the restaurant industry. Our company goal is to provide our guests with the best possible experience, show gratitude that they've chosen to spend their hard-earned money with us. Like all others in my industry, I've experienced firsthand the hardships and uncertainty this pandemic has caused. I've gone from 136 Maryland employees down to a flexible 44 since last March. If economic conditions do not improve in the next 6 months, 1 in 4 small businesses say they will close their doors, and nearly half of restaurants say they will shut down permanently. Our industry has made huge changes in how we operate, from being forced to close our indoor seating to seemingly arbitrary capacity restrictions. Restaurants are struggling as a whole, and all have been affected. Despite these unprecedented challenges, an overwhelming majority of small businesses are not only doing everything that's been asked of them to keep our workers and customers safe, but are also innovating on a daily basis to go above and beyond the required precautions. Just to give committee members a sense of what I'm doing at my restaurants to help stop the spread of COVID-19, we require all guests to wear a mask whenever they're not seated. Our staff wears masks at all times. Disposable masks are preferred for regular changing. Created a digital menu where guests can use their smartphones instead of touching a menu. We're abiding by strict capacity limits. Vita Taco Bar in Annapolis, I am currently allowed 9 guests. Staff is cleaning all highly touched areas. We've engaged a local company that electrostatically sprays a revolutionary food grade product that kills viruses up to 90 days at a cost of $400 a treatment. We've installed ozone air treatment devices inside our HVAC motors, which clarifies the air as it circulates. And we've added mainly disposable utensils and packaging for one-time use. which has driven the product costs significantly. All businesses are making similar adjustments on how to operate and more than likely need to keep on making adjustments as we deal with the fallout. But it worries me as a business owner to think that despite my best efforts, despite everything I've done to ensure the safety of my employees and customers, I could still become the target of what amounts to legal extortion. Civil liability from COVID-19 is a serious threat to small businesses like mine. According to a recent survey, 70% of small business owners are concerned about the increase of liability claims stemming from this crisis. Senate Bill 210 addresses those concerns by making sure a person, business, or nonprofit that adheres to all federal, state, and local guidelines, like I do, will be protected from the threat of frivolous lawsuits that exploit the already damaging effects of COVID-19. Small businesses have been under a tremendous amount of pressure these past 10 months. The last thing we need to be is greeted by a letter threatening legal action if we don't settle out of court for thousands of dollars because of an unsubstantiated claim by someone to exposure of COVID-19. I need to be focused on my business and keep people employed. I shouldn't have to spend time defending myself in court, spending several thousand dollars in legal fees when I've done everything that's been asked and more to keep guests and employees safe. We're learning more about this disease every day. It's not right to leave small business owners holding the bag if they're following the guidelines for what is the best defense against the spread of COVID-19. Thank you, and I ask the committee to give Senate Bill 210 a favorable report.
Mr. Chair, I think Mr. Seidel is up next.
Thank you, Mr. Chairman, and thank you, Senator West, for your leadership on this incredibly important issue. Good afternoon. My name is Ben Seidel, and I'm the owner of founder of Maryland-based Real Hospitality Group. We're a hotel operating company operating over 100 hotels and restaurants throughout the United States, an industry that has been obviously devastated. At the peak, we employed just over 3,000 people, but currently almost half of those are still sitting on the sidelines. Like many others, my business provides the needed goods and services. That doing so provides opportunities for Marylanders to continue, and now at this point, hopefully return to work, and have taken our extraordinary measures to protect the safety and well-being of our customers and our employees by following government health guidelines. We did it primarily dictated by policy and statute, but most of all, good faith. Even with extraordinary protective measures, however, our employees and guests, all of us, continue to be at risk to contract COVID-19 due to the extremely contagious nature of this virus. But I think I speak for all of us in business when I say that just like the fear of the virus, I too equally fear the risk of lawsuits that are born from this. I fear that the potentially frivolous litigation for all organizations, both nonprofit and for-profit companies like mine, that have been and continue to faithfully follow state and federal public guidelines will compromise our recovery and negatively affect the economy as we start to reopen. In all cases, the top priority for all of us have been the safety of our associates, our guests, and vendors, as we're doing all that we can to safely and responsibly keep our doors open or prepare them to reopen, and to welcome back our associates, as I said, that are currently still sitting on the sidelines. Evolving information about COVID-19 and the never-ending changes in federal, state, and local guidelines have created legal uncertainty for us. And as a result, companies that diligently implemented safety protocols and rely in good faith on public health recommendations nonetheless face the prospect of substantial litigation and the cost of it based on this virus transmission. But such lawsuits don't do anything to reduce the transmission of COVID-19, but they do threaten the ability of companies just like mine to provide much needed opportunities for Marylanders to return to their pre-COVID lives, and to so many people that are still sitting on the economic sideline to return to work. Customer-facing businesses should be able to rely on the safety guidelines and reopening parameters issued by experts without the threat of liability for implementing that guidance. I'm not naive. I know that in every sector, there are bad players that look primarily out for the short-term dollar, and sometimes at the expense of others, kind of like that 10th bar. That said, Most all successful business owners and job creators are good people and rely on their valued staff. Such businesses should instead be permitted to focus on their strained resources on revitalizing their operations and growing jobs for Maryland workers while adhering to guidelines. Thank you.
And now I think we have Mr. Collins.
Thank you, Senator West. Can you hear me okay?
Yes.
And thank you, Mr. Chairman and Mr. Vice Chairman and members of the committee. My name is Carville Collins. I'm an attorney with DLA Piper, representing the Maryland Employers for Civil Justice Coalition, a group of Maryland's largest businesses and employers. We're here in support of Senate Bill 210, along with an array of other professional and business groups that the sponsor has mentioned. You've heard from real business owners as to the practical reasons for Senate Bill 210. From a legal perspective, why is the relief contained in Senate Bill 210 necessary? And why is it necessary now? The answer is Maryland law has no answer for a key question in our tort system that has arisen due to this pandemic. That question is, how does a business or a property owner or a local government or a healthcare provider or a nonprofit organization fulfill its duty of care to protect others from the pandemic? The problem is Maryland law cannot reasonably establish a duty of care under current circumstances. A simple example. When there's a spill in a supermarket or a retailer aisle, store owners understand their duty to warn their customers and clean it up. They know what to do. But how do those store owners protect their customers from a pandemic? Another example. How can we know if a business owner fulfilled her duty by requiring masks on all employees and visitors starting on July 1, but not on June 1 when a person alleges exposure? What is needed as Maryland seeks to regain it and reopen its economy and save every possible business and job is the certainty that Senate Bill 210 provides. Senate Bill 210 provides assurance during this unprecedented time to those who play a vital part in Maryland's economy, that if they try their best to operate safely, they act in good faith, they would temporarily not be liable in pandemic-related lawsuits. Now, my friends in the plaintiffs' bar who you'll hear from, they're going to testify to all the abuses, all the loopholes, and all the bad actors this bill will create. But those concerns are all unfounded, because those who engage in misconduct will continue to face legal consequences, as assured by the many safeguards in the bill and as explained by the sponsor. Of course, in Maryland, the General Assembly has always done what is best for Maryland and not determined our laws based on what other states have done. However, I do wish to note what is going on in the other states. So far, 22 states have enacted liability immunity legislation in response to the pandemic. Further, 20 states have invoked existing liability protections or instituted new protections by way of executive order in response to the pandemic. And I'll conclude with this. A number of other states, like Maryland, have liability immunity legislation pending. The failure for Maryland to act would place Maryland in a distinct minority. So for these reasons, Mr. Chairman and members of the committee, we thank you for your consideration. We urge your favorable report on Senate Bill 210. Thank you.
Thank you, Mr. Collins. And Senator West, my apologies for the technical difficulties on my end. So we will now move on to Mr. Sanderson.
Thank you, Mr. Chair, committee members. My name is Michael Sanderson with the Maryland Association of Counties. We've submitted written testimony in support as well. I'll just try and add comments that would complement what you've already heard. I think the sponsor and other panelists have already laid out the case for the bill, I think, quite well. The scenario for local government is a bit different than private business or even nonprofit organizations that we need to be there. There's not a question of a business that might be teetering on going out of business and being unable to serve clients or customers. The local government needs to answer the phone when you call 911. When you and your residents need the social safety net and the support of a local health department or those sorts of things, we need to respond to those needs and those calls. It's times of distress like these that actually even more people look to state and local government, particularly the front lines local government, for assistance in difficulty. And it ends up being those services exactly that get compromised if we end up having to direct resources to plaintiffs rather than public services. The vision of this bill is not precisely the same as Good Samaritan protections, but I think it's very much the same spirit. And the language of in the exercise of good faith, in my judgment, is an excellent idea and a very good place to draw the line. We want to promote these kind of best practices. We're not out of this yet. And for the months ahead, you pass this bill and you let everybody know there's a clear incentive to do the right thing and continue to act in good faith. You're promoting exactly the right behavior that's going to help us get to the other side. We support the bill. Thank the sponsor and the other supporters.
All right, thank you very much. And now we'll switch to the opposition panel. Mr. Wildberger, you're up.
Good evening. It's been a long day for all of us. I'll try to be as concise as I can. Thank you, Mr. Chairman, Mr. Vice Chair, and committee members. I am David Wildberger. I'm here on behalf of the MAJ to urge you to report SB 210 unfavorably. I will also say I am a small businessman. I have a small law firm in Pasadena. I understand the problems small business people have, and I will tell you, this bill is not going to save any small businessmen. It's not even going to save litigation costs. There's 4 reasons that this bill should be reported unfavorably. First, the language of the bill is so vague, it's hard to even figure out how to interpret it. The bill doesn't accomplish what it's intended to accomplish. The bill is unconstitutional under Maryland Constitution sections 19 and 24, as well as more than 150 years of Court of Appeals precedent, and it's just bad policy. Let me deal with 1 and 2 quickly. My understanding from what I've heard from the proponents is that the purpose of SB 210 is to relieve businesses of the need to spend money defending COVID cases. This bill doesn't do that. What this bill says is if a person, business, can show that they have complied with all federal, state, local statutes, rules, regulations, executive orders, and agency orders related to COVID-19, they are immune. Now, that's something that's going to have to be litigated. Frankly, a lot of those regulations, executive orders, statutes are going to be in conflict. That's all going to be litigated by the people that bring these suits. Now, thankfully, I don't think there's going to be many of these suits, and I don't think there have been many. Because frankly, as Senator West said, the causation proof burden here is going to be really, really high. Frankly, I think the better way to defend these suits is to rely on having been reasonable in your approach to COVID. Reasonable under the circumstances, not negligent. That's the way to defend these. It's the way I would defend it. But all of these issues are going to have to be litigated in court under this bill or not under this bill. This bill actually may increase litigation. Now, SB 210 is clearly unconstitutional. And I'd cite to you, as Senator West said, Dua versus Comcast, 370 Maryland 604, says that it is unconstitutional to retroactively impair, interfere, or abolish an accrued cause of action. An accrued cause of action is an action that a plaintiff is aware of or should be aware of. That's what
Time.
All of these issues are time. Negligence gives rise to a discrete cause of action. This bill seeks to put an intentional cause of action substitute. You can't do that. You can't take away a vested right in a negligence cause of action and raise the bar retroactively. That's unfair and it's against our Constitution. And this bill, I urge you to report it unfavorably.
All right, thank you very much, Mr. Wildberger. And with that, that'll conclude the testimony. Looking around the room for questions. Senator Castley has a question.
Thank you. I'll just make the observation off the top that I don't know what's constitutional anymore, because up until, June or so, I would have sworn that it would have been unconstitutional for the state to close down my business or to make me wear a mask. But so we've moved beyond that one. So I guess my real question here is to Mr. Collins, and looking on page 3 of the bill, and it says that a person who acts in compliance with all these statutes wouldn't be liable. What if there are no statutes or regulations? What if at the time that this person entered my senior living facility and contracted COVID and died, that there were no applicable federal, state, or local statutes and regulations governing conduct relevant to COVID? Would this still provide relief for them?
Senator, I think the clear inference from language such as that is if there's no violation, then there is immunity. I think the objective of the bill and of the sponsor is very good in this regard, because as one of the earlier witnesses mentioned, it does encourage people to do the right thing if the right thing has been established. But in the absence of any such standard, then I think the clear inference would be the immunity would still apply if you hadn't violated any of those rules or regulations or guidance from, say, our state health department or the CDC or other federal authorities.
And maybe you're right. I'm just not sure, because on the one hand, it can be interpreted as saying, look, we told you to do these 5 things in order to open up your senior living facility or your kindergarten or whatever it was. You did all those things. If you did all those, we're not going to hold you liable because maybe the state screwed up and told you stupid things to do. So we're not going to impose liability on you because, we told you to do some things that in retrospect, what the heck were we thinking? And so we're not going to hold you liable for that. Or is it saying, well, I think it'll be read either way. That's my only point. That I'm not sure. I guess finally, we don't have market share liability, do we?
We do not.
So basically, the idea that somebody's going to say, I got COVID in your bar or restaurant is like, okay, dream on. There's that lawsuit ain't going nowhere. This is really about people. I would imagine the main target here would be senior living, nursing homes and the like, where the only place granddad got this, he hasn't been out of your nursing home in 3 years. He died in your nursing home. So it's all about your nursing home, right? And that's what this is really about, I guess, right?
Yeah, and I know that market share liability has been proposed and considered by your committee in a number of different settings, but I do not believe it is the law of Maryland in any sector.
Okay, thank you.
Hate industry just rolled over when you said that, Senator Castley. Oh Lord! All right, Mr. Wildberger, did you have something responsive to that, or?
Yes, it's very clear that from what everybody has said, the way to defend these cases is to show that you acted reasonably under the circumstances. That's what our system allows. You don't need blanket immunity. That is, by the way, unconstitutional in order to take care of these cases. You can't, you're still going to have to litigate them. The bill is unconstitutional because once a cause of action accrued, and all these causes of action have already accrued because the harm's already happened. Once they've accrued, you can't take that right away from them. That's the law. It's been the law for 170 years, and it's been upheld dozens and dozens and dozens of times by the Court of Appeals. This bill in some ways is a solution in looking for a problem. I haven't heard anyone say that we've had a flood of these cases. I don't think we will have a flood of these cases. Let the system work. Thank you.
Thank you,
Mr. Chairman, may I address the constitutionality issue?
I'm sorry, go ahead one more time.
Thank you. Mr. Chairman, I'm just asking if I may briefly address the constitutionality issue that Mr. Wildeberger has raised.
Yes, of course, and that'll close the loop on this. So yes, go ahead.
To close that loop, we respectfully submit to the committee that the DUA versus Comcast decision does not prohibit retro application of the Senate Bill 210. That case is a case I argued as an amicus, and it can be distinguished from our circumstances here. And thus it has no application to the effective date outlined in Senate Bill 210. It's distinguishable for at least 3 reasons. First, in the DUA case, there were underlying claims filed against Comcast, some of which had further been certified as class action lawsuits. These claims remained pending, and they were fairly mature and far along in the litigation process. And hence the court ruled the plaintiffs there had vested rights, which could not be affected. There is no such circumstance that applies here. The second reason, DUA was the first time that the Court of Appeals formulated its vested rights theory. And it did so because the statute enacted in 2000 by this General Assembly that was at issue in the case had just overruled an earlier 1999 ruling of the Court of Appeals itself. That's another clear distinction from what is presented before us in Senate Bill 210. And third and finally, we are facing a state of emergency. This is a once-in-a-century pandemic and public health crisis that justifies extraordinary action by the General Assembly. These circumstances were not present whatsoever in DUA. That's a case involving the mere imposition of late fees on persons paying their bills later than the due dates. That was not an emergency. This is. And for those reasons, we believe there is not a constitutionality problem. DUA is not controlling here, and we ask for the committee's consideration of those views. Thank you.
All right, thank you, Mr. Collins. We'll go back and forth. I know Mr. Wildberger wants another one, but let's just, if you could just, let's have this discussion. Let's furnish that response in writing. I don't want to go back and forth too much. So each side has had a little bit of play here. So I just want to, with that, if any of the senators don't have another line of questioning, Senator Sidnor has a question. And you're labeled as Smith, so that's good.
Now that happened.
You're my brother. You're my brother from another mother.
There you go. A question for Senator West. I was looking at page 2, lines 18 through 22 as to what a COVID-19 claim does not include. And it references an administrative proceeding. And I'm wondering if that would include workers' compensation cases?
Yes.
Okay, so then this bill isn't necessarily about foreclosing employees from filing claims against employers. It's more customers and things that are coming into the business. Is that what
Yes, that's why we included that subpart 3 to make it clear that employees who got sick on the job can file a workers' compensation claim. This bill would not preclude those claims.
And second, something that is probably a bit, in my opinion, maybe surplusage. When you look at lines 25 through 27, and I'm curious why you felt a need to expressly include 501c3s when for the most part, those types of organizations would fall under section 2 as either a corporation, association, or limited liability company.
I couldn't agree with you more. They're not excluded, they're included. And I started to work on this, and then people said, yeah, but you got to include the nonprofits, the 501c3s. And my reaction was, well, they're already included.
They're already there, right?
Because they're incorporated in some way or another, but well, nonetheless, you should include them. So there's an awful lot of redundancy, frankly, in section 4, which is the definition of the person. I wanted to make sure it was as broad as I could make it to protect people who were in business in whatever way they were in business. And that includes nonprofits, their businesses, hospitals, colleges, private schools, you name it. If they're in business, if they're serving the public in some way, they should be included and covered by this bill.
And then the final question, looking at page 3, lines 19 through 23, I'm just curious what you're thinking about when you say an isolated minor deviation.
Well, if someone was supposed, they're only permitted to have 25% capacity, a restaurant, for example. And so what is 25% of? I guess it depends on the square footage of the restaurant. And so if a restaurateur does the best he can to comply with the rule, but then a lawyer were to come in and say, actually, you had 27% capacity, and now you violated the rule, therefore I can go ahead with my lawsuit. This was intended to say, let's not be picky. So long as they in good faith attempted to comply with the standards, then they are covered by the bill.
Thank you very much.
Sure.
Thank you, Mr. Chair.
Thank you, Senator Sidnor. Senator West. Seeing no further questions, I suspect we'll be in touch. I see Senator Huff has a question, but I suspect we'll be in touch with Mr. Wildberger and Mr. Collins after this. But go ahead, Senator Huff.
Sorry, I put it in the chat box. I guess I got to figure out where the little hand thing is on here. So
it's under participants.
Under reaction.
Reactions, right.
Reactions. Okay. Also, I just want to PSA.
I just do that. I'm doing the physical hand.
I saw you. We got you. It works just as well.
Just real quick for Carvel on the Dual decision. In fact, I never even, the first time I became aware of it was we were dealing with last year. We're going to have the bill again this year with, it was churches, these private organizations. It was imposing civil liability on them for past actions. And the AG gave us a letter saying that basically it was very constitutionally questionable and parts of it were unconstitutional because of that Dual, that they said that decision, that basically to go back and impose civil liability on folks because of that decision would be probably unconstitutional. So I guess I'm still stuck on that because I don't know if MAJ was to bring in a bill and they would say, we want to impose civil liability for past actions, I would imagine that you all would argue, Dual would say no. So in the inverse, isn't it kind of correct that we can't eliminate, why is it we can eliminate civil liability and we don't affect Dual, but if we go back and impose civil liability, according to the AG, we are, in constitutionally questionable territory.
Thank you, Senator. I'm not familiar with those opinions or that issue in great detail. I think the process here is we have a case that interpreted the state constitution under a set of circumstances back in 2000, but it was in response to quite a volley back and forth. First, there was a decision by the Court of Appeals, and then a year later, there was an overturn by the General Assembly. And then 2 years after that, the court came back with another volley in the Dual case. And so I think all of that circumstance has to be considered here. We don't have anything like that. This is not a case that's come before the Court of Appeals. This is not questioning whether the court got it right or not. It's a completely different set of circumstances. The sponsor articulated the extent and the nature of the emergency, and we've heard from some of the business owners. So because of this distinction, I really think it's an entirely distinguishable set of circumstances for the committee to consider. It should not be influenced by a decision 20 years ago with such background and such a colored history of back and forth between the branches.
Mr. Chairman, may I respond?
Absolutely, yes.
Thank you. This is misleading. The Dua case, over 49 pages, analyzes the entire history of retroactivity and vested rights. Yes, vested rights. This is not the first time that vested rights have been a constitutional issue. This has been going on for 170 years. The law is very clear. If you look at Dua, I dare say there are probably at least 36 cases that have dealt with retroactivity in all kinds of contexts. And uniformly, it has been found that you cannot pass a law that retroactively limits rights or creates new rights. There's one case where the legislature extended the wrongful death statute. That was unconstitutional for the same reason this is unconstitutional. You can't take away people's rights retroactively. You can do it prospectively, but you can't do it retroactively. This, it's very pointed. This right is not just for abrogation of accrued cause of action. DUA makes it very plain. It is for interference with an accrued cause of action, impairment of an accrued cause of action. And if this bill doesn't impair and interfere with an accrued cause of action, I don't know what would.
All right, thank you, Senator Huff. To your satisfaction, any follow-up? Okay, great. You do have a follow-up, okay.
I was just going to say, I mean, it might serve the committee well for one of us to seek an Attorney General's opinion on this before we push forward. Just a suggestion.
We'll get on that. Thank you, Senator Huff. All right. Seeing no further questions, that then ends the testimony and the hearing for Senate Bill 210. We'll now move on to Senator Wallstreicher, Senate Bill 232. Vice Chair Wallstreicher, you're up.
Thank you, Mr. Chairman, members of the committee. SB 232 is an important bill. So Maryland Legal Services, as many of you know, provide important services in our community. And here's why they're critical. I think many of us on the committee would love to move to a civil Gideon model where people don't enter court for either civil or criminal cases without an attorney. But the cost of doing so is very challenging. And so that's why we rely on folks like Maryland Legal Aid to service those who are most disadvantaged, the poor and the impoverished in our courts. And while so much of what they do is not in the headlines, I know a lot of what we've been talking about is how they represent tenants under our current circumstances, and that's critical. But you should also know that they represent folks in family law, in public benefits, in bankruptcy, in debt collection, foreclosure prevention, access to health care, veterans issues, barriers to employment, domestic violence. What they do is so critical to our community and the people that we represent back home. Here is where Maryland Legal Services gets their money from. They get their money from filing fees, and they get their money from IOLTA accounts. And this is the cruel irony of where we are today. Like those of you who served during the Great Recession, I know that IOLTA accounts go almost to zero exactly when legal services by the poor are needed most. And so the Fed has rates almost at zero. IOLTA accounts are very low. And then of course, our courts have been closed for many, many months for most cases. And so there's very little filing going on right now. That means we need to fill the gap for Maryland Legal Services Corporation. That means it's on us to try to fill that funding hole. And that's what this bill does. This bill provides a modest filing fee increase to make sure that we can fund legal services for the most vulnerable in our community. That includes my community, that includes your community, and I hope we can pass this bill without controversy. And Mr. Chair, I know time is short, so with that, I'll ask for a favorable report.
Thank you, Mr. Vice Chair, and thank you for spearheading this effort. We will now turn to Ms. Ehrlichman. How are you?
I am fine, and thank you, Chairman Smith, Vice Chair Waldstreicher, members of the committee. I'm really delighted to have the opportunity to speak to you this evening. I thought we'd be speaking today, but it's nice to be with you tonight. I don't want to keep you here much longer, any longer than necessary. And actually, Vice Chair Waldstreicher did such a terrific job of describing the issues and why we're here and what we do that I'm going to abbreviate my testimony. And I did also submit written testimony as well. As Vice Chair Waldstreicher indicated, we are the major funder for civil legal aid in the state of Maryland. We were created actually by the Maryland General Assembly in 1982, along with the IOLTA program at that time as our sole funding source. Filing fee surcharges were added in 1998. It became clear that IOLTA, consisting entirely of interest income, was really not a stable funding source that could support the fundamental critical needs of low-income Marylanders throughout the state, and enter filing fee surcharges. And up until the COVID pandemic, that had really been a quite stable source of funding for us. But as the Vice Chair indicated, that ended in March. So we are seeking truly modest increases in filing fee surcharges to help fill this hole. We anticipate it's going to be, we thought it was going to be around a $6 million loss for the coming year. Now it looks like it might be closer to $8 million. But in any event, what this bill will do is it will enable us to move forward without making additional cuts to the 36 programs that we fund. We had to cut grants by 9% back in June. And then between June and September, we watched our income go so much further down. It really took our breath away. We had already made grant commitments to 36 programs who were seeing increases in need, and we realized we were not going to have the money to meet our obligations. What saved us was we were really, truly blessed by money. It seemed like pennies from heaven, but it wasn't pennies. It was millions of dollars that was approved by the Maryland Attorney General's office, and the our governor provided emergency funding so that this current fiscal year that we're in now, we did not have to make further reductions. So that was wonderful news, but that was for this year. So next year is another story. We're looking at this large, this large hole in our budget, and passage of this bill will go a long way in helping us at least maintain the system at pre-pandemic levels. So it's not very ambitious in that we know that the need is skyrocketing, but this will definitely do what we need to do at a minimum. So we knew there would be many competing needs this year that you would be considering. I'm happy to answer any other, any questions you may have. We have the support, you'll hear, of the Maryland State Bar Association, the Maryland Attorney General's Access to Justice COVID-19 Task Force, the Maryland Access to Justice Commission, obviously the legal services community, and many, many other entities and organizations throughout the state. So we really do need your help. We appreciate all the support over the years. Almost 40 years ago, you created the Maryland Legal Services Corporation. So great wisdom and foresight in that, and consistent support throughout many, many years that we are extremely grateful for. So again, thank you very much for your time, and I'm happy to answer any questions.
Thank you very much. We'll take questions at the end. And so next we have Judge Scruti for the Bar Association. Judge?
Thank you, Chair Smith and Vice Chair Waldstreicher, members of the committee. I appreciate your time this evening. I'm testifying as my role as president of the Maryland State Bar Association. And our Board of Governors did pass, and we support Senate Bill 232. This bill is one of the Maryland State Bar Association's priority bills this legislative session. When I thought about what I wanted to talk to you all about tonight, I thought about the words of stabilization and investment. These are two words that I think you're going to hear throughout the testimony regarding this bill. You heard from Ms. Ehrlichman about the need for and the numbers, and how this will provide the level of stabilization for MLSC, and more so the grantees, the programs that the money provides support for. I also wore another hat. I was on for 8 years, a board member of MLSC. And I look back at the time that I spent with MLSC meeting with many of these programs, 36 plus programs, about the needs that each of these organizations have. And anytime that there's any concern that there's going to be a cut or even stable level funding, these programs can't grow. They cannot respond to the needs of the community and with any initiatives to deal with some of the current crises. So the funds are absolutely critical and are needed. As you heard, 1982, actually, this body founded MLSC, and the last surcharge was in 1998, nearly 23 years ago. And I think that's significant. But during the time that I served as the board member and listening to the different grantees, operational expenses are one of the things that organizations just can't get funding for. And that's why it's absolutely critical. MLSC funds are there to help with their operational expenses, whether it's domestic violence, consumer protection, landlord-tenant, immigration. I've heard story upon story about the work that these organizations do in providing tremendous access to justice to low-income Marylanders. The one thing I do want to point out is the language about the surcharge not being able to be passed along to tenants in the summary ejectment cases, I think is critical language to this bill. In the district court, I've seen firsthand situations where some landlords have filed repeatedly month after month after month because the filing fees are so low at that for these summary ejectment cases. They file on the 6th day of the month, and you've got about 600,000 cases are filed statewide, but only 10% of them actually result in evictions. So in one aspect, we see that many of these cases are being used, the courts are being used as a collection agency, and that's not really the proper function for the court in many ways. This slight increase will cause a landlord to exhaust their remedies, tenants to try to come up with financial solutions to be able to get the cases to full adjudication. What is important for us to know is what are your concerns? What are your questions? And I'm happy to respond to provide you with any information that we can to help you make a better informed decision, more so in support of Senate Bill 232. We've also provided written testimony that goes in more detail. So I thank you for your time and your consideration.
Thank you, Judge. And now we'll move on to Ms. Fasanelli.
Chairman Smith, Vice Chair Waldstreicher, and members of the committee, it is a pleasure to be here. I am Antonia Fasanelli with the Homeless Persons Representation Project, which provides statewide civil legal aid to persons experiencing homelessness and housing instability. We urge a favorable report on this bill. HPRP is one of the 36 grantee organizations funded by MLSC, and MLSC funding constitutes 30% of our budget. It is critical funding for us. We would not be able to do the work that we do without MLSC funding. And this bill would actually simply be the bare minimum to maintain the status quo. And that delivery system, that civil legal aid delivery system of attorneys and paralegals and support staff have worked tirelessly during the pandemic to protect some of the state's most vulnerable citizens. This committee has done tremendous work around eviction protection, and my colleague Matt Hill from the Public Justice Center is going to talk about our work in that arena. I'll be sharing with you other areas, like the work of Sally, the Sexual Assault Legal Institute, that works with survivors of sexual assault around the state. Their excellent written testimony is in your packet, but they describe cases such as James's case, where they represented a 7-year-old child and survivor of sexual assault, as well as his family, and helping them obtain safe housing away from his abuser. The pandemic has also brought to light the tremendous need and the reality of hunger in our state. And in HPRP's own written testimony, you will hear about our response to hunger in the state. In the early months of the pandemic, a significant computer error caused thousands of families to be wrongfully terminated from the food stamp program. We found out about it at HPRP when over 2 days in early April, we received over 150 phone calls from hungry families desperate for resources to be able to buy food for their children. We responded by setting up a statewide free legal help bilingual food stamp hotline to help hundreds of those families. And in the early months of the pandemic, March, April, and May 2020, our caseload was so large, it constituted 140% of our entire caseload in calendar year 2019. One quick point that I want to make is our community has not been without closures. The unfortunate reduction that MLSC had to make of funding on July 1st to our programs did result in the closure of a major civil legal aid program. And I really have to thank my colleagues at the Women's Law Center, Maryland Volunteer Lawyer Service, and Midshore Pro Bono for stepping up with HPRP to volunteer to handle the hundreds of cases that program left behind on divorce, child custody, and expungements. We're doing the very best we can, but we need to maintain the system that we have. This bill will do that. Thank you for passing this bill.
Thank you, Ms. Fasanelli. Always good to see you, and thank you for your work. Thank you for hanging in there with us. We'll now move on to Ms. Thompson from Catholic Charities.
Thank you, Chair Smith. Mr. Chair, Mr. Vice Chair, and members of the committee, my name is Kelly Thompson. I am a supervising attorney for Catholic Charities Legal Network, a program of Catholic Charities of the Archdiocese of Washington. Thank you for allowing Catholic Charities to offer testimony this evening. Catholic Charities is one of the largest and most comprehensive social services providers in the DC area. We serve Montgomery, Prince George's, Calvert, Charles, and St. Mary's counties. Our doors are open to anyone in need, regardless of background, belief, or circumstance. Two of our programs, the Legal Network and Immigration Legal Services, provide life-changing legal services to low-income Maryland residents, and both have done so for over 30 years. As an established legal services provider in Maryland, Catholic Charities understands the importance that pro bono legal services make in the lives of low-income Marylanders, and we have seen the increased need for services since the beginning of the pandemic. MLSC provides critical funding to many legal services agencies throughout the state, including some organizations you heard from earlier today, and our collective ability to serve our clients means the difference between housing or homelessness, a job or joblessness, and chaos or stability and safety in a child's life. For instance, one Montgomery County mother who suffers from multiple sclerosis and is confined to a wheelchair sought the Legal Network services in February of 2020 after she separated from her emotionally abusive husband. 1 month later, the pandemic hit, and she and her estranged husband were eventually forced to live together again in the home they jointly rent because they have no other options. Her pro bono attorney, with the guidance of our staff attorney, retired circuit court judge for Prince George's County, Leo Green Jr., continued to help her negotiate her divorce and custody matters while ensuring that she and her young son remain safe. This story is not uncommon, and if you ask any of the other legal services providers throughout the state, they would share similar stories, as well as those of unscrupulous landlords and families struggling under crushing debt. Modest filing fee surcharges have served as an important, though not the only, source of funding for MLSC since 1998, with the first bill actually sponsored by Leo Green Sr. as vice chair of this committee. With vital funding in place to make up for current shortfalls, legal services providers throughout Maryland will have the necessary resources to continue making a real difference, resulting in more just and equitable outcomes for the most vulnerable Marylanders. Thank you for the opportunity to provide favorable testimony this evening.
Thank you very much. Next, we'll have Mr. Hill. You're up next.
Good evening, Chair Smith, members of the committee. My name is Matt Hill. I'm an attorney at the Public Justice Center. Public Justice Center is a statewide legal services and advocacy organization, and we're in full support of SB 232. Now, the committee is going to hear a couple of filing fee surcharge bills this year, which the Public Justice Center supports. SB 232, I want to distinguish as really the bare minimum needed just to avoid drastic layoffs at the Public Justice Center, legal aid, and the other legal services organizations because it fills that critical budget gap for MLSC, which then fills a critical budget gap for us. I'm going to speak briefly about grounding this in the context of evictions, where the Public Justice Center does most of its individual client work, providing legal services to approximately 700 tenants each year. And it has continued to represent clients facing eviction throughout the pandemic. It's been many times landlords attempting to illegally evict tenants by shutting off their utilities or changing the locks while they're out. We've done quite a bit of enforcement of the CDC's order around eviction, the governor's order around eviction, sometimes showing up to court the day of the eviction to try to get a last-minute stay. All of these things are important, and they're critical to preserving the public health, particularly at this time, because we know that evictions in the middle of a pandemic mean that folks become homeless. They crowd into other houses of their friends and family or into homeless shelters where transmission of COVID-19 is more likely and therefore contributes to community spread. So by funding eviction prevention and legal services, you are in effect doing a significant effort to combat the pandemic. But we know that we're not out of the woods by any stretch. We're facing a tsunami of COVID-19 related evictions. You all have heard much of this data before, so I'll be very brief. At least 200,000 households in Maryland at risk, having a tremendous impact on Black households. The 36% of Black renter households are facing an eviction compared to 14% of white renter households. We know that rental assistance is incredibly needed, absolutely. The federal government now has allocated $400 million to Maryland for rental assistance. This is a huge amount of money, and we think it'll be very well spent and necessary. Probably not enough, but definitely a step in the right direction. Providing counsel in eviction cases is the other piece to ensure that this money is used properly, to make sure that landlords, for instance, we've had clients where the landlord has taken the rental assistance prevention money and still gone forward with the eviction, enforcing the CDC order, making sure the property is habitable. There are a number of studies showing that eviction prevention legal services are effective in doing what they're supposed to do. Really quick, just one more sentence. There's an amendment. The reason I have an amendment is simply that we appreciate and we think it's very important that this fee not be passed on to tenants who already can't afford their units in many cases. And so we want to work to strengthen the language of that pass-through to make it very clear that tenants have a remedy if a landlord tries to violate that provision. Thank you very much.
Excellent. Thank you, Mr. Hill. And with that, that'll conclude the proponents. We'll now switch to the opponent panel. And first up, we have Mr. Enton.
Thank you very much, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Multi-Housing Association. Let me say very, very clearly and very, very categorically that my client, which is a trade association of residential property owners, they rent over 300,000 units to Maryland citizens, over 300,000. They're small landlords, they're large landlords. And let me say on their behalf that they absolutely have no problem whatsoever with the increase that's in the bill for summary for ejectment cases on account of failure to pay rent. And that is why we're opposed to the bill. We are opposed to the bill for one reason and one reason only. And that's the language that you heard reference to from the judge and from Mr. Hill. And that's the language that is aimed at landlords and says, unlike any other business that utilizes the courts, whether it's to file a lawsuit because someone didn't pay their bill at a retailer, whether it's Baltimore Gas and Electric Company or an oil supplier, a pet shop, you name it. Unlike anyone else, we can't recover our court costs. Why? What have we done? Are we somehow inherently evil that we should be singled out like this? And that's what we find objectionable. You know, the notion that somehow we shouldn't be able to recover these fees because we're using the court as a collection agency. We shouldn't be able to recover these fees because we need to exhaust our other remedies. Well, let me ask you, what is our other remedy? Unlike someone who sells someone a product, unlike someone who provides someone a service, when that customer doesn't pay his bill, what does the creditor do? It says, I'm not going to sell you any more goods. I'm not going to provide you any more services. We can't do that. What are we supposed to do? The person is occupying the building that we own, the unit that we own, and not paying their rent. So the remedy that's provided, unlike some states where there's self-help for landlords, is we have a very detailed and a very cumbersome process by which we can go to court. But what choice? Is our remedy to if they owe us 3 months rent, and let's say it's $3,000, is our remedy to go to district court and file a lawsuit? And maybe we get that case heard 2 or 3 months from now, and maybe we get a judgment, and then we're going to have to try to figure out how are we going to collect this judgment. So meantime, if the tenant stays in our property for 2 months, 3 months, 4 months, 6 months, that's why we have an ejectment process. But that ejectment process, unlike the process in any one of our surrounding states, and part of the reason that we have repeat evictions is that in Maryland, in every county, other than Baltimore City, and I'll wrap up, Mr. Chairman. Thank you. In Baltimore City, the tenant gets what we call 4 bites of the apple, and every place else they get 3 bites. So they don't pay their rent. We have to go to court before the sheriff comes or after the court proceeding. And it's a question of fact, one way or the other. Did you pay the rent or didn't you? Then they have the ability until the sheriff shows up to pay that rent and stay in the property. So I'll sum up just to say, Mr. Chairman, that we have no problem with the increased fee whatsoever, but we find the language that says that we can't pass it on to be totally, completely objectionable. Thank you.
Thank you very much. And thanks for hanging in there with us. All right, our last witness is Mr. Wiggins. You're up.
You have to unmute, Grayson.
I'm trying to do it. There you go.
Thank you, Mr. Chairman and members of the committee. For the record, Grayson Wiggins on behalf of the Maryland Multi-Housing Association. Since it's late in the evening, I will just note a resounding me too to Mr. Enton's testimony, and I would be happy to assist in answering any questions the committee may have. Thank you.
All right, fantastic. Looking around, Senator Castley has a question.
I'll keep it brief, Mr. Chairman. Just as a member of the bar, though, I'm troubled by the bar's testimony because we got a bill that says that we're going to increase surcharges on all kind of lawsuits, and then the only ones that they can't pass that on are the landlords, the private landlords, who personally I find very valuable because public housing has failed miserably in the state. If it weren't for private landlords, we'd have a drastic, horrible housing shortage. But let's just ignore that and call them bad names because it's fun. But the challenge I have is why should we let lawyers pass on these increases? I mean, I realize, you know, I currently we're paying about $165 right now on a civil suit just to get it filed, and we're gonna dump these charges on people who are come to us because their lives are falling apart for whatever happened. They have serious problems, so we're going to target them for a tax increase. Why shouldn't we just penalize lawyers like we're penalizing landlords? Shouldn't we just say, well, we're going to put these additional fees on every filing fee, and that's just going to come out of the lawyers, and because we're just as lovable as landlords? Shouldn't it come out of our share instead of the share of the poor client who is only come to see us and file the civil case because there's something amiss in their lives? So I just throw that to the bar because I'm sort of perplexed on how the position was arrived at.
Thank you, Senator. If I may respond, Mr. Chair.
Absolutely.
Thank you. These are in rem proceedings. These are not in personam. And I think the difference here is if a person does not file their, pay their BG&E bill, BG&E doesn't come to court every month and file a collection action against an individual. These are summary ejectment proceedings or in rem proceedings. There is no monetary judgment that's being entered against the tenant. It's just a finding as to the amount of rent due and owing by the court. And my statement earlier was with respect to what we were seeing in court is that you've got serial filings. And what happens is the tenant is late on the 5th, the landlord, and this is not directed to any organization or any particular landlord, but the landlord files on the 6th of the month. Tenant now has to pay the filing fees, they have to pay their late fees, and it adds an increased burden for many of them. What I was suggesting earlier about the remedies is to have the landlord and the tenant to be able to try to work out payment plans. These are going to be large amounts of rent due and owing, particularly since the courts have been closed for hearing landlord-tenant cases. And so my point being with regard to the Bar Association's position was they support the bill as it's drafted. And I hope I've explained the reason behind it. These are.
I hear that, but the reality is that the landlords come in because he really has his only remedy is that he holds a 1-month security deposit, and as he delays that to gauge in whatever these other alternative remedies you're mentioning, which I really don't see any of them as practical. If the landlord delays, then that security deposit is. There is no other remedy. They can't, unlike BG&E, they can't say, look, eventually you're going to need my electricity somewhere. I'm a monopoly. Someday you're coming back to me and I'll get my money out of you. Landlord can't say that. There's plenty of tenancies. There's plenty of rental properties out there. So you don't pay me, you eat up the security deposit. I can get judgments till cows come home. They're all worthless. And now you go on. So what remedy does the landlord have? Because he's got, the free time the tenant's sitting there, the landlord will never get that back. Once they forego that time, they've got to get in promptly. Otherwise, the free days the tenant's there they'll never be recovered. So I'm just, we go through this incredibly convoluted process that's like 20 pages long in the Real Property article about how landlords have to do it, incredible protections for the tenants, and then we're going to turn back around and say, oh, landlord, because you follow this incredibly detailed, rigorous process that we said, we're going to penalize you for that. We're going to start to tax you for following this process. I'm just totally mystified that the bar would take that position. Seems just.
Well, I appreciate your comment, Senator. Again, I go back to these are in rem proceedings. These are for possession of the property, and nothing is prohibiting the landlord from filing these actions to get the possession of the property back. So, and I appreciate where you're coming from. Thank you.
Yeah. I'm just.
Thank you, Senator Cassidy. Thank you, Judge.
Never ceases to amaze me.
Yeah.
Thank you.
I'm going to give Mr. Etten a chance just because he's got something that's responsive to the question, and then I'm going to move on to Senator West. Mr. Etten, you muted yourself again. Just here you go. One more time. Here you go. There you go.
I would disagree. These are not in rem proceedings. The defendant in the case is the tenant. This is not an in rem proceeding. Secondly, I would say that there's no landlord out there that wouldn't rather have the tenant pay the rent. Our landlords are bending over backwards right now. Can you imagine how much the decrease in rent is right now? Our landlords are struggling to maintain their properties, struggling to keep them open, and working with their tenants in every way possible. There are no eviction cases right now. The soonest there may actually be eviction cases heard could be May, June, or July at this point. President Biden is talking about a federal legislation to stay all evictions. And what are the property owners supposed to do? How are they supposed to possibly collect the money? It's not, once again, the tenant gets to live there rent free for as long as they want under this strategy, and for as long as they want. You can't collect the rent. Sue them for a judgment. Try to collect it. Meantime, they're in the house. Once again, This bill is about Maryland Legal Services. I've worked with Ms. Ehrlichman for many, many years. I know her well. We support legal aid. We support the right to counsel. But why should we be singled out and punished because we own rental properties? It's just not fair. Thank you. I'm going to have a debate. But I couldn't restrain myself. Thank you.
No, understood. It's good. Ms. Ehrlichman, did you have something that was responsive to Senator Cassidy's question, or did you? I saw your hand up earlier, just very, very quickly, and then I want to move on to Senator West, and we're close the loop on this.
Yes, no, I just wanted to comment quickly with regard to the increases. A point I did not make earlier is that our filing fees compare very favorably, even with the increases, to contiguous states and are well below the national average generally. With regard to the filing fee in summary ejectment actions, even with a $5 increase, it remains one of the truly lowest in the nation. So I did just want to share that information.
Thank you very much.
Thank you.
All right, so Senator West, you're up.
Thank you, Mr. Chair. I just have a question to follow up Mr. Anton's line of conversation. Judge Skirty, my old friend, Judge Skirty, preceded me by 1 year as the president of the Baltimore City Bar Association. So he and I have worked together for 25 years, would you guess? Long time. And we both have the highest respect for each other. I'm a little confused as to whether the State Bar Association agrees with the last provision in this bill, which precludes landlords from passing on the surcharge. And if you do support that, why does the State Bar Association single out tenants uniquely and say only, landlords uniquely and say only landlords are not permitted to pass on court fees to people that they deal with?
Thank you, Senator West, and I have tremendous respect for you as well, as we've been through the bars together. I can tell you that the Committee of Laws reviews the proposed legislation. They then make that recommendation to the Board of Governors, and it was unanimously approved at the Board of Governors level. There was not that detailed discussion by our members of the board that I have been made aware of as to any concerns or questions with regard to that language.
Okay, so I guess it's fair to state that when the board approved the bill, the board did not specifically have its attention called to that provision, the not passing on, and therefore was not aware of that provision at the time that they passed the bill, correct?
No, I can't say they weren't aware. They were provided with the bills. So I can't say that they were not aware. What I can say is there was no discussion during our Board of Governors meeting with regard to that specific language.
Great, thank you very much.
Thank you, Senator West. Ms. Fasinelli, this is the last comment on this exchange. So I guess so you are.
Thank you so much. I did want to respond to Mr. Enton's comment that eviction proceedings are not going forward. That actually isn't the case. Tenant holding over matters and some other select proceedings are going forward. There's a group of us that are handling eviction matters in Baltimore City. We also do evictions in Montgomery County. One of those organizations, the Pro Bono Resource Center, has, as recently as a week ago, received quite a number of phone calls from tenants whose tenant holding over proceedings are continuing. It is not true to say that tenants can remain in housing forever and not pay their rent. That is actually absolutely not true right now.
All right, so that's good. Let's do this. We're looking for any questions from senators. Thank you very much, Mrs. Fasinelli. If you have something that's responsive, go ahead and just furnish it in writing, and we will consider it during a voting session. All right, seeing no further questions, that concludes the hearing, and we'll now move on to the last bill of the day, Senator Carter, Senate Bill 334. Senator Carter, you are up.
Thank you, Chairman Smith, and thank you, members of our committee, for your endurance. I promise to make my testimony brief. I am well aware that I am the last bill of the day, and I am the only thing between this committee and its evening. So I will spare you the 7 or 8 pages worth of oral testimony that I initially intended to present. And I will simply tell you what the bill does and why we need it, and then defer to my panel of experts, which include the lead proponent, Betsy Nicholas, who is the Executive Director of Waterkeepers Chesapeake, Sylvia Lamb with the Environmental Integrity Project, and Hannibal Kemmerer with the Attorney General's Office. What the bill does is it allows for a citizen right of intervention in Clean Water Act enforcement efforts in in Maryland, state of Maryland. If a case were brought federally, we citizens would have an absolute right to intervene. But because of a court case in Maryland some years ago, citizens' rights were deemed restricted. And so what this really does is close a loophole and bring Maryland closer to what the Federal Clean Water Act intended, which is that citizens would have a right to intervene. When I say citizens, I mean citizens, organizations, individuals, cities, counties. And I want to just mention that why we need it, of course, is one, it brings us into compliance with the Clean Water Act. About 8 other states have already implemented legislation to ensure that they are in compliance and that their citizens have a right to intervene, whether it's in federal court or state court. There is one very minor amendment to the bill, which the advocates thought that would be helpful to the committee. I actually do not think it's even necessary. It just clarifies the language of what the bill does already, and it should be in your packages. With that, I'm going to limit my testimony and defer to the panel and be available with them to answer any questions the committee has. I have pretty extensive written testimony that you should also have in your packet. Thank you.
Excellent. Thank you, Senator Carter. We'll now move on to your panel. And Ms. Nicholas, you are up.
Good evening. My name is Betsy Nicholas. I'm Executive Director of Waterkeepers Chesapeake. We're a coalition of 17 different waterkeeper, coastkeeper, harbor keeper organizations throughout the Chesapeake Bay watershed. We've also submitted pretty extensive written testimony on this that's also signed on to by another dozen or so organizations, including the Maryland Sierra Club, Chesapeake Bay Foundation, Chesapeake Legal Alliance, and many others. I just want to give you a few examples of why this is actually really important to us in our work to ensure everyone has the right to clean water. And I'll give you a couple of instances where intervention has led to good results. And these are in federal court because it's allowable there. But one of them would be our Chesapeake Bay cleanup plan. So that was challenged by the Farm Bureau and a number of other agencies back in 2011. And it was being defended by the Environmental Protection Agency. Chesapeake Bay Foundation, Midshore Riverkeeper Conservancy, and about 12 other organizations were able to successfully intervene and join EPA in the defense of the Chesapeake Bay TMDL. And that was particularly important because there were so many briefs filed there. And these other organizations could take some of the load off of EPA in defending that action. And it was ultimately successful. Another example is one where it was an organization I previously worked for, Chattahoochee Riverkeeper in Atlanta. Atlanta was subject to just terrible sewage overflows into the Chattahoochee River for decades. And you may be aware that a couple of their mayors went to jail for some misuse of funding there. And our organization, Chattahoochee Riverkeeper, filed suit in federal court. The U.S. Justice Department then took action in federal court, which cuts off any action that can be taken by citizen groups. But Chattahoochee Riverkeeper was then able to join and intervene in that federal action. And this resulted in one of the most significant cleanups that's ever been accomplished of an urban city. And the mayor of Atlanta, Shirley Franklin, said this never would have happened. she never could have gotten the funding or the political will to do that cleanup, no matter how much she wanted to, without that lawsuit and without the river keepers there to ensure that they met all the timelines and the deadlines for the suit. In contrast, what we have here in Maryland is a situation where we have river keepers, community members, lots of other folks who are documenting raw sewage discharges, strange odor and color coming out of different facilities and plants, and sharing this information with Maryland Department of the Environment. When MDE, Maryland Department of the Environment, investigates a case, they cut off all communication and contact with any organization because they say it's in enforcement mode. Well, virtually none of these ever actually end up with an enforcement. And in the rare occasion when they do, for example, a facility in Baltimore County that was discharging more than 35 documented situations of raw sewage into the water supply. For years, it was documented, and MDE entered into a consent decree eventually with no deadlines, none at all. Just clean it up whenever you can. And that's really why it's so important to have other voices involved in this process. Those community members who are impacted, who are suffering from the pollution. But it also benefits cities and counties. Back again, when I was in Georgia, I was with an inspector who found this weird colored liquid coming off of an industrial site. The state agency there brought an enforcement action in state court. The city of Atlanta intervened in that because of their MS4, their municipal system that it was discharging into. What was originally going to be a $20,000 penalty ended up with $2 million because of the intentional willful nature of this and because the city of Atlanta intervened there. And all that money went to help restore the streams that were impacted and help the city of Atlanta to clean up their MS4 system that was bothered by this. And I'd like to say again, Senator Carter mentioned that we had a few technical amendments that were requested by some folks, and we have a friendly agreement that we're going to make sure that all of those get into the bill. So I know it's late, so I'll cut my testimony there and say thank you, and we really appreciate a favorable report on Senate Bill 334.
Thank you, Ms. Nicholas. Good to see you. Next, we have Ms. Lamb. You're up.
Thank you, Mr. Chairman and members of the committee. I'm Sylvia Lamb with the Environmental Integrity Project, testifying in support of this bill. I'm here to discuss how Marylanders are essentially prohibited from intervening in clean water cases against the polluter brought by the state in state court. Because the state Clean Water Statute doesn't offer a right to intervene like the Federal Clean Water Act, citizens have to meet a separate test to get a conditional right to intervene. So in other words, whether or not they can intervene depends on them passing the certain test. The problem is that there's a Court of Special Appeals decision, EIP versus Murant, which was a state case against a coal ash facility that was unlawfully polluting the Potomac. And the court in that case construed this test, making it virtually impossible to intervene in this exact type of lawsuit. In Murant, there were 5 people and 2 environmental groups who tried to intervene. These 5 folks lived as close as 5 miles downstream. They fished in, they sailed in the river, and they said that they were worried that the pollution was driving down their property values. But their intervention was denied. The test for conditional right to intervene requires that a person have an interest in the case. And the court found that their interests weren't good enough, finding that they were the same as the general public's. The court said that the 5 folks are not personally affected in some way different from anyone else living that close downstream. The court also said the state covered their interests because they all wanted to protect the environment. This is even though the state who supported the intervention confirmed that they had potentially conflicting interests. It is difficult to see how any Marylander can intervene in these cases if the court found that a person living as close as 5 miles downstream from the source of illegal, toxic pollution just wants to protect their river in the same way as the general public or the state. Meanwhile, they would have been able to intervene if this were in federal court. The Clean Water Act gives these folks a right to intervene, and they meet federal standing requirements, which requires 1, at least a threatened harm from pollution, 2, the facility is dumping that type of pollution, and 3, this harm would stop if the pollution stopped. Here, they worried that the toxic pollution was harming the fish they catch and their home values. It was clear the facility was dumping the harmful pollution, and their worry would stop if the pollution stopped. But in Merritt, the court created an impossible test to intervene in state court for these cases, and this bill would fix that problem. Thank you for your time.
Thank you, Ms. Lamb. And next we'll move on to Mr. Kemmerer. There you are, Attorney General's office.
Thank you, Mr.
Good to see
Chairman,
you.
and Vice Chair Waldstreicher and distinguished members of the Judicial Proceedings Committee. My name is Hannibal Kemmerer, and I represent the Office of Attorney General as its Chief Counsel for Legislative Affairs. I'm here today to urge you to favorably report Senate Bill 344. I was going to make 2 points, but in the interest of time, I think I'll just make one. Everything that you've heard thus far from Sylvia and Betsy's absolutely accurate. Indeed, in the Myrick case, our office filed an amicus brief supporting the individuals that lived on the stream and or the river rather, and wanted to intervene, supporting their motion to intervene at the Court of Special Appeals, but it was all for naught. The second point I want to make is that this bill doesn't change standing requirements, certainly not the three principal requirements in federal court, that you have either an injury in fact or imminent threat of injury, that the injury or the threat is fairly traceable to the defendant, and that it's capable of judicial redress. So we think that this is a good bill, and we definitely support it, and we think it also harmonizes our law with the requirements of the Clean Water Act. Without further ado, Mr. Chairman, I conclude my remarks by, again, urging a favorable report, and I'll take any questions.
All right, fantastic. Thank you, Mr. Kemmerer. We'll now move on to Ms. Schmidt.
Hey there, my name is Caitlin Schmidt, and I'm a policy analyst at the Center for Progressive Reform here in support of Senate Bill 334. Thank you so much for the opportunity to testify on behalf of the Center for Progressive Reform. So given a lot of confusion and misinformation about this bill, I'd like to spend some time discussing what this bill does and does not do. So citizen intervention under this bill only applies to Clean Water Act enforcement cases where the state files the enforcement action in state court. It applies to no other type of case. If Maryland were to file a Clean Water Act enforcement action in federal court, citizens would already be provided this right of unconditional intervention. Through this bill, we are asking that this right of intervention is extended to state court proceedings, as it is in virtually in every other state in the country. This bill does not create another cause of action if the government has already begun or is diligently pursuing legal action in court in order to require compliance with the Clean Water Act. A citizen cannot sue independently. In every other state court besides Maryland, the citizen can still file a motion to intervene in that case. This is what Senate Bill 334 seeks to address, solely the ability to intervene in state court in Clean Water Act enforcement actions. Intervention does not provide any independent right to bring a lawsuit. It is not standing, and in fact, standing must be met by any party seeking to intervene. Again, in order for this bill to apply, the state must already have brought a case in state court. Therefore, this bill does not increase the cost of burden on the state. In fact, intervention helps relieve these burdens by supplementing state enforcement authority. This bill does bring Maryland in line with federal compliance with the Clean Water Act. This is because whenever a state is delegated Clean Water Act authority, like Maryland and almost every other state in the country, the state must at least provide as much public participation, including things like intervention, as the federal law provides. There are 8 other states that have had to do this type of legislative fix that we are asking for here to avoid possible federal withdrawal and takeover of their permitting programs. So without this fix, Maryland's Clean Water Program is currently out of compliance and could be deauthorized. In fact, as we speak, there is a case pending before the 4th Circuit Court of Appeals that is considering revoking Maryland's Clean Water Act permitting authority due to the fact that it does not provide adequate intervention rights. This is not what the groups involved want. MDE, EPA, and the appellants, including Waterkeepers Chesapeake and Environmental Integrity Project, have all requested that the court put a stay or a hold on this case to resolve this problem through the Maryland General Assembly with this legislation. So it's really imperative that this bill passes this session. And with that, I'll conclude. Thank you so much for your time and consideration.
All right, thank you, Ms. Schmidt. We'll now move on to Mr. Powell.
Sorry, the unmute button didn't work at first. I'll be extremely brief. I'm here on behalf of NAOP and the Maryland Home Builders. We had simply sought amendments that would make it clear what the bill did and did not do, but we've had discussions with the supporting panel that you just heard from, and they're supportive, I think, of one of our very technical amendments. They proposed language in place of our first amendment that I think would be acceptable to us. So we believe that with a little discussion with the sponsor, we can resolve this issue with common language. Frankly, the panel members and myself and my clients have already agreed to if the sponsor is also supportive. So with that, if there are any questions about it, be happy to answer.
Fantastic. Thank you, Mr. Powell. And our last witness of the day, Mr. Sanderson. Hold on one second. Here you go.
Thank you, Mr. Chair. I'm Michael Sanderson with the Maryland Association of Counties. We too have been in exchanges with supporters of the bill, and I would hope to share some optimism on that front as well. I just want to share a couple perspectives. One is in a back and forth and talking about, I'll reference Mr. Powell's testimony, what the bill does and what it doesn't do. I think we've had some hopefully productive exchanges on that front. As nearly as I can tell from a non-lawyerly perspective, part of the two-way conversation has revolved around, does the bill affect standing per se? No, it doesn't affect standing per se in the sense of who may sue, but it does affect her twin sister in who may intervene in these cases. And county governments, particularly with a variety of discharge permits, have this basically negotiation and legal framework with the state. The potential to open up to a variety of interveners can make these cases a great deal more difficult and expensive. And I think that's the foundation of our concern. More mouths to feed, even if those mouths are not directly affected or have a direct interest under the Mirren case and so forth. I'll also say in these conversations, we've heard some back and forth about that the EPA might be concerned about Maryland's law and that Maryland's primacy in enforcement might be at stake. And I would certainly say if there's a letter or a witness from the EPA saying that without this bill, Maryland will lose primacy in enforcement, I think that would be a matter of really serious consequence for Maryland. And that would be a really high stakes game to be discussing here. But the testimony tonight was more along the lines of there are a handful of states who have done this, and this aligns some state laws with federal laws. And I think that's closer to what I think the local government community has read about the bill. So it's not quite as simple as EPA is going to cut us off unless this bill passes. I don't think it's quite that cut and dried. I will join the optimism that it may be that the language Mr. Powell spoke to might be able to satisfy local government concerns, but we are concerned about the door opening substantially in a number of cases we're involved in, and at the moment oppose the bill.
All right, thank you very much, Mr. Sanderson. We did have one other person signed up, Ms. Bailey, but she is not here. So I'm going to go ahead and go to the committee questions. First of all, Senator Jackson, Senator West, and then Senator Hellman. So Senator Jackson, you're up.
Thank you, Mr. Chairman, and thank you for the testimony. I guess I have a question to direct to Mako. So it seems, I mean, I guess I'm trying to figure out where's the opposition of a citizen having a concern. So let me qualify that. So I live in southern Prince George's County in the rural tier, right? And when we moved there 21 and a half years ago, old farmland, we had the issue of rubble fields. And I think one of the things that was startling to us is when does the public, or when do the true stakeholders when are they allowed to engage? And so how does the citizen getting joined in a suit when they're true stakeholders? And I guess it's a little disconcerting when the county governments speak, quite frankly about too many mouths to feed in certain cases. We also have, in that area, it's sort of the last yet to be developed land in our vast county, these power plants. And so, and flooding. So I guess I'm a little concerned. This doesn't expand standing, but I guess my concern is, citizens having the right to hold potential polluters accountable. So if you could respond to that, I'd appreciate it. Thank you, Mr. Chairman.
I'll do my best, Senator, to respond. Just by saying the standard right now, as I understand it, is that of an interested party. And it may be that there is an open question about precisely what one stakeholder or another might want there to be an interested party. We're not trying to close the door and say that no one but in the example I'm discussing with like our stormwater permits or NBPDES permits, that it's merely the state and the county, but a stakeholder that has a direct interest in the outcome of the case already has an avenue to intervene under state law. What this bill does is adopt a much, much broader framework. And we're worried about folks who are not just a mile further up the stream, but just broad stakeholders on behalf of the whole universe. Similar to a bill you heard earlier on the schedule today that allowed any person, even without any claim at all, an opportunity to sue under the constitutional amendment. We're concerned about that same expansion. And that's our central issue. It's not about wanting citizens out. It's that we want interested parties to be the ones at the table.
All right, Senator Jackson.
Yeah, and I'll make it quick. I guess my challenge is this. I mean, I'm not sure how disinterested a person can be if their property value goes down. I think, I hope you all would take that in consideration. If that does make the citizen an interested party. But I look forward to seeing the amendments if Mako has any for this piece of legislation. Thank you, Mr. Chairman.
Thanks, sir.
Thank you, Senator. All right, Senator West.
Thank you, Mr. Chair. I just have two questions. First of all, for Mr. Kemmerer, does this bill expand standing? I've seen various statements in the testimony that it does not expand standing. Do you agree with that?
I disagree. I don't think it expands standing so much as it just ensures that people under the Federal Clean Water Act are able to intervene pursuant to our rules, even when a case is brought by our enforcement agencies, MDE, in state court.
But for them to intervene, they would still have to establish that they have independently that they have standing. In order
yes, they would have to independently establish, Senator, that they have either a harm that's already occurred or an imminent harm, and that it's traceable to the defendant, and that it's also something that a court could give them a remedy for, judicial redressability.
Okay, and then secondly, maybe Mr. Powell could try to address this. In my legal practice, I never ran into a case with an intervener party. There might be plaintiffs, but there's not an intervener party. Typically, the plaintiff's counsel develops a strategy for how he or she is going to pursue the case and then executes that strategy. And then I suspect in clean water cases, most of the resolutions of these cases are through agreements that are hammered out between the plaintiff and the defendant.
Yes.
So in the case where you get an intervener coming in, what powers does an intervener have to try to tell the initial plaintiff, your strategy is wrong, I disagree with it, I think we need to pursue a different strategy, and if you don't, I'm going to, on the one hand, and what rights does the intervener have on the second hand to say, that settlement that you negotiated, I totally disagree with, and I'm going to go to court and try to persuade the judge not to accept it?
There actually is, it's considerable power. An intervener who has standing, and I disagree a little bit with some of the conclusions on standing, but understand I'm supportive of the bill with the amendment, and I can explain why if you would like. But the has as much right to object to a settlement as the plaintiffs did. If the court is considering a consent order, then all of the parties, including the intervener, can come in and say, I don't think the terms of that consent order are acceptable. The reason that my clients, NAIOP and the Maryland Home Builders, are nevertheless willing to support this is because with the amendments, it's clear that we're only talking about cases filed in court, not the administrative penalties and cases. And as the fiscal note notes, there are relatively few cases that are filed and in court. And those cases would be only those that are frankly a pretty serious allegation. Otherwise, the Attorney General's office would, as you know, I was principal counsel there and served at the Department of the Environment for 10 years as their AG's office. It would only be a relatively rare cases where this was brought. But in those rare cases, there is no question that the intervener would have just as much right to object to a consent order as the plaintiffs did, and just as much right to insist that they want to go to a full trial as the plaintiff would.
Well, then in that case, let me turn to Mr. Kemmerer again. You're with the Attorney General's office. Or if this bill should pass, are you prepared to accept the fact that people are going to intervene in your clean water suits and try to dictate the strategy that you file, try to overturn settlement agreements that you have negotiated with the defendants in these cases because either they're too strong or they're not strong enough?
So yes, Senator West, I think we're okay with that. We don't have any quarrel with either impacted Maryland citizens or nonprofits, environmental NGOs intervening in cases in appropriate circumstances. In fact, as I might have mentioned, we filed an amicus brief supporting intervention in the Myron case, but the Court of Special Appeals disagreed with our position.
Thank you very much for both your answers.
It's my pleasure.
Excellent question. Thank you, Senator West. Senator Hedelman.
Thank you, Mr. Chairman. I wanted to follow up on the question of my colleague, Senator Jackson, and it actually has been brought to light even more by the response of Mr. Kemmerer with regard to that there needs to be harm or imminent harm in order to be, I'm sorry, this is for Mr. Sanderson, harm or imminent harm. I'm just wondering, you seem to imply that you are concerned about kind of this really opening up the floodgates for citizens, and harm or imminent harm seems to be a pretty narrow scope to more, clearly define who is affected and who would therefore be able to sue here. I wonder if you could just comment on that, because I don't see, it seems to me that citizens would have citizens who are directly affected, like Senator Jackson mentioned, and who are facing harm or imminent harm, seems like fairly narrow scope.
So I'll do my best to carry the water on behalf of a number of our jurisdictions who both in their environmental protection office and in legal offices have tried to raise concerns about where this could go. And I may easily spill some of the water in the bucket in the process of doing so. But counties right now, the easiest to understand, I think, is the NPDES permit, pollution discharge permit, where this is a routine circumstance where the state is the enforcer, the county is the developer of the permit, and it's a two-party negotiation on what it should encompass, what the provisions ought to be, and the like. And right now, as I understand it, they're players within the affected county in Baltimore County or Frederick County or a jurisdiction who has to have one of these permits, works with the Department of the Environment, who basically is handed the gavel by EPA and tries to work out, okay, we think we've accomplished the goals these ways. The state says, we're concerned about these two things. It eventually works its way to some sort of a compromise. This is frequently a negotiated settlement, that sort of thing. And then you end up with a consent decree or some other document that guides how the county will go forward. Right now, the stakeholders who would be at the table to intervene are relatively narrowly limited to the folks who are in the county and around the county, sort of narrowly defined, but not necessarily an environmental NGO on behalf of the entire Mid-Atlantic region, or another entity who can't show, well, we're not really in Frederick County. We don't really have that direct a stake, but we're here on behalf of all the stakeholders of the larger watershed. And I think that's the nature of what would happen. As you heard from Mr. Powell, if you bring those interveners in the case, they're fully empowered to engage and even dictate the outcome of that whole process. That's where our counties are concerned that this will turn these processes much longer, much more expensive. And I made a poor choice of words to say mouths to feed, but what I mean by that is the satisfaction of the demands of a variety of extra stakeholders, some of who are not in the narrow column of what we're actually debating with this permit in this one county. So I think that's the best I can articulate the philosophical concern that our county governments have as to where this could go.
Just one quick follow-up is, so do you do agree that polluters should be held accountable? And I guess
by all means,
that this seems to enable that to happen better than what we have now. Do you disagree with that?
Right. I don't disagree with that. I think the debate here is how wide a swath of stakeholders should be fully empowered in that process that affects a certain geography. Should Greenpeace be a fully empowered stakeholder in the Frederick County permit? And I mean, there are degrees of how do you go about doing a goal that we would all generally agree to.
Thank you. Thank you, Mr.
Thank you, Senator Hettleman. Ms. Nichols, if it's responsive to the line of we'll give you the last. This will be the last word.
Thank you. Yes, pretty much everything Mr. Sanderson said about the law is incorrect. So when citizens file an enforcement action under the Clean Water Act in federal court, you have to first do what's called a 60-day notice of intent to sue. This is a special requirement when you're not a government agency. And the reason that exists is so that the government can take over that lawsuit. So that's what happened with the city of Atlanta. The feds took over the lawsuit, but then intervention was allowed. So the party was allowed to enter into it. In the state, this does happen and has happened, like in Mirant, where Potomac Riverkeeper and 5 downstream citizens filed their notice of intent to sue. The state took over enforcement action and that kicked them out. And because there wasn't intervention, they never got back in. And that's what this fixes. That's why it's set up this way under the Clean Water Act. And to answer Mr. Sanderson's question about what to look to say that EPA requires this, United States Code, Federal Clean Water Act. It's been enacted since 1972, and it directly requires this level of public participation for Clean Water Act cases because of this weird scenario that even if the citizen started it, once the government seeks to take action, that citizen suit is ended with the remedy that you join and participate with the federal or state government in enforcing the law there. And as to the MS4 permits, this does not apply to any administrative actions. It's only enforcement. It is only when there's evidence of pollution. So it doesn't touch anything about permit terms or anything else about that. It's only enforcing against polluters. It's very narrow.
Fantastic. Thank you very much. And with that, Senator West and Senator Jackson. I see your hands are both still raised, but I assume that was just from earlier before. That was from before. Okay, great. Check that. With that, that concludes our hearings for this evening. We are going to reconvene tomorrow at 11 a.m. for bill hearings, and then we'll have a voting session. So have a good night. Thanks for hanging in there with